make us live, as it were.
Oh, yeah.
Thank you. Good morning, everyone. Welcome to the Joint Standing Committee on the Judiciary. We have a very full morning today. I want to just let committee members and members of the public know what's on our agenda and where we're headed. We have three public hearings: LD 2022, an act to amend the judicial districts and divisions for York County, and then 2023, an act to implement the recommendations of the Secretary of State regarding notarial acts, and then LD 2008, an act to establish a court process for involuntary substance use disorder treatment. We'll do public hearings on all of those bills. It's possible that we might move into a work session on one or more of them, depending on how the public hearing goes. But we'll make that decision as we do the public hearing on each bill. And then we've got two work sessions: LD 598, an act to prohibit discrimination in employment and school based on hair texture and hairstyle. And then we've got a public hearing, a work session on LD 1946, an act to ensure constitutionally adequate contact with counsel. That's a huge amount of work for the time we have available this morning. I also would like to be respectful of committee members' need for, and staff members' need for, a break between this morning's work and this afternoon's. So we'll make as much progress as we can, but I'm thinking and hoping that we could take a midday lunch break at 12:15 and then start our afternoon work at 1. So that is kind of a run through of what to expect for today. And with that, I will begin our committee introductions. And committee members, I'm just going to call on you as I see you on the screen. Representative Moriarty, we'll start with you today.
Thank you, Madam Chair. Good morning, all. I'm Steve Moriarty. I live in Cumberland and represent my hometown as well as part of Gray in House District 45.
Representative Babbage.
Good morning, everyone. My name is Christopher Babbage. I represent House District 8, which is most of the town of Kennebunk.
Representative Reckitt. Representative, we're not able to hear you. Thanks.
I'm going to make a t-shirt that says you're muted for all of us to wear in our spare time. Sorry to do that. My name is Lois Reckitt. I represent District 31 in South Portland. That's the ocean end of South Portland near SMCC. And unfortunately, I have most of the day criminal justice at the exact same time. So I will be for sure here all afternoon, but this morning I may have to jog in and out. Thank you.
Thanks. Representative Evangelos.
Thank you, Senator Carney. Good morning, everybody. Jeffrey Evangelos, House District 91. I reside in Friendship.
Representative Sheehan.
Thank you, Madam Chair, and good morning, everyone. My name is Erin Sheehan, and I represent Biddeford's House District 12.
Representative Libby.
Good morning, everyone. My name is Laurel Libby, and I live in Auburn. I represent District 64, which is part of Auburn and all of Minot.
Representative Thorne.
Good morning, Madam Chair, members of the committee, members of public. My name is Jim Thorne. I am a House Representative for District 103, which are the towns of Carmel, Herman, and a portion of Etna up in the heart of Maine.
Representative Poirier.
Thank you, Madam Chair. I am Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Senator Sanborn.
Good morning, I'm Heather Sanborn, and I represent Senate District 28, which is half of the city we refer to today as Portland and half the city of Westbrook.
Senator Kime.
Good morning, everyone. My name is Lisa Keim, and I represent Senate District 18, which is Northern Oxford County in two communities in Androscoggin.
Co-Chair Harnett.
Thank you, Senator Carney. Good morning, colleagues and members of the public. My name is Tom Harnett. I represent House District 83, which includes the town of Farmingdale and the city of Gardner, where I live. And I will be needing to pop out for a short meeting at some time in about the next 10 minutes, but I will not be gone for long. We'll be back as soon as possible. Thank you.
Thank you. And would like to introduce our OPLA analyst, Peggy Reinsch, and our committee clerk, Susan Panett, who will be here with us this morning. And I'm Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, where I reside, and a little bit of Scarborough. And with introductions complete, we will move on to our legislation, and I will open the public hearing on LD 2022, an act to amend the judicial districts and divisions for York County. And we'll be joined by the bill sponsor, Senator Donna Bailey. And while Representative Senator Bailey is joining us, after she introduces the bill, we'll call on those who wish to speak in favor of the legislation. So if you're an attendee and you want to speak in favor of LD 2022, please raise your electronic hand and just keep it raised until I call on you. Thank you. Senator Bailey, welcome back to your former committee.
Thank you, Madam Chair. And unfortunately, we're still Zoom, so I don't have treats, but I know I owe you some. Good morning, Senator Carney and Representative Harnett. He may have stepped out. My name is Donna Bailey. I represent Senate District 31, proudly serving the people of Saco, Old Orchard Beach, Hollis, Leamington, and part of Buxton. I'm here this morning to present LD 2022, an act to amend the judicial districts and divisions for York County. This is a fairly straightforward bill. As the committee is probably aware, construction on the York Judicial Center is underway. I think they're over halfway complete at this point and expect to be open in the spring of 2023, if not before. Current law provides that the division of York County and the districts, which is District 10, requires the judicial branch to have courts in Sanford, Biddeford, or Saco, and York. This bill would just amend that to only require the judicial branch to have a courthouse in Biddeford, which is the location of the new York Judicial Center. Now, this doesn't mean that the judicial branch couldn't have more courthouses, but at a minimum, they would only be required to have one in Biddeford, given that when the Judicial Center opens, the courthouses currently in Biddeford and Springvale and York will be closed. So it's a statutory change just to reflect reality, if you will. And with that, I'm happy to answer any questions.
Thank you so much, Senator Bailey. And I see that we do have some committee questions. Representative Moriarty, go ahead.
Thank you, Madam Chair. Good morning, Senator Bailey. I'm just curious, what is to become of the Superior Courthouse in Alfred?
There will be no change with that. That will remain as is.
Oh, good. It's such a pretty courthouse. I'm glad to hear that.
Yes, I mean, I don't think that, I mean, currently, and if Julie Finn is here, she can correct me if I'm wrong, but I think currently the state just leases space in that courthouse. It's actually owned by the county. So of course that will continue on. It will be owned by the county, but that the state would no longer lease any space in that courthouse.
Okay, thank you.
Committee members, any other questions for the bill's sponsor? I am not seeing any, and Senator Bailey, you're welcome to stay on the panel throughout the work session, the public hearing and any work session.
Thank you, Madam Chair.
And we'll next be joined by Julie Finn from the Judicial Department, who wishes to speak in favor of this legislation.
Good morning.
Good morning and welcome.
Thank you very much. And many thanks to Senator Bailey for sponsoring this bill. And I think earlier in the session, I said there would only be one judicial branch bill, and I'm going to stand corrected as this is our second bill. So this is the second of two, hopefully. Senator Carney, Representative Harnett, members of the Joint Standing Committee on Judiciary. I'm Julie Finn, and I represent the Maine Judicial Branch. And this morning I will be testifying in favor of LD 2022. Over the last several years, the judicial branch has renovated and built new courthouses with funding and support from the legislature in several parts of the state, including Bangor, Augusta, Belfast, Machias, and Oxford. We have consolidated operations in order to maximize our space and be more efficient with our resources. The new spaces are safe places that provide private and respectful areas in which the people of Maine work to resolve their disputes. Construction has begun, as Senator Bailey mentioned, on our next new courthouse in Biddeford in York County to be called the York Judicial Center. The spacious new building will take advantage of the latest technology, solar and geothermal energy sources, and natural lighting to provide an energy and cost-efficient building for the people of York County. Title 4, Section 153, titled Judicial Divisions, and Title 4, Section 154, titled Districts, very specifically lists the counties and municipalities where courts shall be located. The York Judicial Center will consolidate the district courts in York County and relocate the Superior Court. While presently there are district courts in York, Springvale, and Biddeford, and a Superior Court in Alfred, all York County courts will be moved to the new building in Biddeford. This type of consolidation allows us to manage our courts more efficiently, including, and this is really important right now, especially more efficient deployment of our marshals for entry screening. As you have heard, we have had difficulty finding judicial marshals, and having one location instead of several allows us to use those resources that we do have. The anticipated opening of the York Judicial Center is planned for the spring of 2023. Once the York County courts are unified into one building, it will be important to have a uniform designation for the district court. We would like to begin using the Biddeford District Court docket designation as of January 1, 2023 to make filing uniform for the 2023 calendar year. Docket numbers are important to our case management system as they identify the location, case type, and year of each case for the duration of the case. It is our hope that this will mitigate confusion for the public, as well as for those within the court who work with data collection and analyze that data. For these reasons, we would request a really minor amendment to the effective date, making the bill effective on January 1, 2023. The statutory changes reflected in this bill align the language of Title IV with current plans that are well underway in York County. Thank you very much for your time, and I'd be happy to answer your questions.
Thank you very much for that thorough review, committee. Oh, I see we do have a question. Representative Moriarty.
Thank you, Madam Chair. Ms. Finn, I'm just curious, if the bill passes, and I certainly assume that it will, and takes effect 1/1/23, but the construction isn't finished until 3 or 4 months later, are there problems in the interim? What will happen?
No, in fact, that's a great question. And that is exactly why the language of the bill allows us some flexibility. In fact, instead of saying specifically that district court must be in Biddeford, the bill says the district court for York must be held at Biddeford or in any other court facility in the division. So we will have that flexibility during the transition period to have our other courts remain open until the move-in and the opening actually happens.
I see. Okay. And then just as a quick follow-up, I just want to make sure that I've understood your testimony and Senator Bailey's as well concerning the Alfred Superior Court. What's to become of that then?
Yes, that, and Senator Bailey was entirely correct that that is a county-owned building. And they continue to own the building. I believe the district attorney's office has space in there, and that is their decision as to what happens with that building. It's not a state facility.
Yeah, but the question is, is court going to be held there?
No, it will
Oh.
be all consolidated to Biddeford.
Oh,
They may have probate court in the building, but again, that's a county court.
But not Superior Court.
Correct.
Oh, well, sort of sorry to hear that, but okay. All right. Thank you.
You're welcome.
Representative Thorne?
Thank you, Madam Chair. Julie Finn, I was wondering if you could just kind of recap for me, the top 3 reasons that this was necessary. Was it based on increase in population, aging of facility? If you had to put your finger on it.
Well, sort of all of the above. We have been, as I mentioned, sort of trying to update and consolidate courthouses throughout Maine. Some of the buildings are, 100 years old and, in need of repair. And also it's difficult in terms of security and technology for the older buildings to be safe in terms of marshal coverage, in terms of fire exits, in terms of spaces for the public, in terms of prisoner entry and exit. There's a lot of reasons why the new buildings are much more appropriate to the current time. And the consolidation makes it a more efficient proposition because you consolidate your resources. As I mentioned with the marshals, that will be a huge assistance to us, since instead of having to have marshals entry screening at 4 buildings, we'll only have to have that at 1 building. And we hope to continue to renovate courthouses into the future in other places because there are some that are in dire need.
Thank you. And a follow-up, if I may, Madam Chair?
Yes.
Thank you. And I'm new to this because unfortunately I am a freshman legislator, and I know that you've probably been working on this with others for years now. When did this process first start where it was identified that this new building was necessary, if you recall?
Yes, I would have to look that up to be specific. It has been, I'd say, at least 3 years probably when the first bill passed. Obviously we have to get legislative approval.
Right.
And that was 3, maybe even 4 years ago, but I can get you I can find the legislation and get you the date on that.
Yeah, it was more anecdotal for me, just know the process. Thank you. Thank you, Madam Chair.
Representative Babbage?
Thank you, Madam Chair. Yes, if I could just comment in response to Representative Thorne's question, having served 3 terms on this committee, the judiciary has been looking at each of their courthouses around the state for a long time, and in my opinion, the creme de la creme of a model to follow has been the Kennebec County Courthouse right there in Augusta, and looking at the 3 disparate geographic locations and the individual challenges that each of them brought, and then the location issue of where the new one should be built came down to considerations of access to a sewer system and things of that sort. The new protections that are going to be afforded with appropriately designed space in the new courthouse will be a terrific thing for York County. it certainly will be a bustling place when it opens. We're going to have about 210,000 people by the time that opens, and so it'll be a bustling place. But we're very excited about the access to justice and the safety that will be provided for all people involved with regard to the design of the courthouse. So I just thought I would offer that, and I was going to chastise Senator Bailey for not knowing about this very controversial bill months before, but it is it is something that's wise to do, and it does provide that a cushion of flexibility should we not open as we expect. So, thank you very much, Madam Chair.
Thank you, Representative. And it looks like all of our questions for Julie Finn are completed. And so I'm just going to turn once more to the attendee space and see if there's anyone else who wishes to be heard on LD 2022. Please raise your electronic hand. I'm not seeing anyone. Is there anyone who wishes to be heard in opposition to LD 2022? Raise your electronic hand, please. And then neither for nor against. And I am not seeing anyone, so we'll close the public hearing on LD 2022. And I would ask if there was a committee member who wished to move to suspend the rules and move into work session. Representative Moriarty.
Madam Chair, you anticipated my comments. I move to suspend the rules and proceed immediately to work session on this bill.
Thank you very much. Representative Evangelos.
Second Representative Moriarty's motion.
Thank you. And so we'll close the work session on LD 2022 and the public hearing, excuse me, and open up the work session on LD 2022. And Senator Keim, did you wish to speak to the legislation?
I would just request a corner caucus before the vote. Thank you.
Okay, thank you. Committee members, we did hear one suggested amendment, which is to include an effective date of January 1, 2023. I just wanted to remind committee members of that in the event that there was, let's see, in the event that a committee member wishes to make a motion to that effect. Is there, Representative Moriarty, do you have a motion?
I do. I think it might be useful to have a motion on the table before the caucus. So I move ought to pass as amended, with the amendment being an effective date of 1/1/23.
Thank you. Is there a second? Representative Arnett?
Yes, I second the motion.
Thank you. And committee members, is there any discussion before we break for caucus? I am not seeing any, so we have a motion seconded, ought to pass as amended. Senator Keim, how much time would you like for your corner caucus?
5 minutes.
Okay, great. So we will be back at 9:33, everyone. Thank you. Committee members, if you have returned to your desks, could you please activate your video? And we'll get started as soon as we're all back in the meeting. Let's see. All right, it looks like we are back. Committee members, is there any additional discussion on the pending motion? I am not seeing any discussion. Is the committee ready for the vote? Yes, okay. And we'll welcome our committee clerk, Susan Panett, back. And I think we're ready for you to call the vote, Supi.
Thank you very much, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty. Representative Sheehan.
Yes.
Oh, my apologies.
No, it was my fault.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll recall the absentees. Representative Hagan. Representative Hagan is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 12 members voting in the affirmative, 0 in the negative, and 2 members are absent. That is the vote of the committee.
Thank you very much, Ms. Panett. And so committee members, the ought to pass as amended vote carries 12-0 with 2 absences. Thank you very much for your work on that legislation. And Senator Bailey and Julie Finn, thank you for all the information you provided to the committee this morning.
Thank you very much to the committee. We appreciate it.
Thank you all.
So we'll close the work session on LD 2022 and move on to open up the public hearing on LD 2023, which is an act to implement the recommendations of the Secretary of State regarding, and I always have a hard time pronouncing this word, notarial acts. And this is a bill that we asked to report out in order to implement the recommendations of a study that we authorized in the first session of this legislature. And our own co-chair, Tom Harnett, is the bill sponsor technically of this legislation. And so I believe he's going to introduce it.
Thank you very much, Senator Carney, and emphasis on the word technically. Good morning, Senator Carney, esteemed colleagues of the Judiciary Committee. My name is Tom Harnett, and I represent House District 83, which includes the town of Farmingdale and the city of Gardner. And I am happy to introduce LD number 2023, an act to implement the recommendations of the Secretary of State regarding notarial acts. You will hear in great detail from our Secretary of State about the details of this bill, which creates efficiencies by allowing remote notarizations and makes other changes in the laws regarding notarizations. So with that, I thank you for your time and hope that you are able to support this bill after hearing from the Secretary of State.
Committee members, the Secretary of State will be joining us momentarily, but are there questions for Representative Harnett? Go ahead, Representative Thorne.
Thank you, Madam Chair. Representative Harnett, it just so happens I checked on my my ability on my notary license commission, and currently it's 7 years, I believe. I see the Secretary of State nodding her head, and this would change it to 4 years.
I would, if she's nodding her head, that's great, but I would really defer technical questions about the bill to the Secretary of State. I'm not going to be very helpful.
Okay. I think she just answered my question, but I was just curious as to the why of it. Just, it seems, 7 years with all the things that I have, from registered Maine guide to notary license to my VFW membership and American Legion. The longer the period, if I know I'm going to be in it going forward, the easier it is. But I was just curious if perhaps the Secretary of State could answer why that was shortened from 7 to 4 years.
Representative Warren, I think that what we'll do is we're going to finish taking questions for the bill sponsor, and then we'll bring we'll ask the Secretary of State to provide her testimony, and then you can ask her those questions.
Very good. Thank you.
Many thanks. Representative Moriarty, did you have a question for Representative Harnett?
A very quick one, Madam Chair. Representative Harnett, I have a note to the file that 2 days ago, the governor signed an executive order for temporary remote notarization. I don't know if you're aware of that as well, and if so, does that dovetail with the proposed bill?
I am not aware of that. I know that there were previous executive orders that allowed the practice during the pandemic. I don't know the implication of that on this bill, although this bill would make those authorizations permanent.
Sure. Okay, thank you.
Thank you.
All right, it looks like we're done with questions for the bill sponsor. So we'll welcome Secretary of State Shanna Bellows to the panel, and you can begin your testimony when you're ready.
Thank you, Senator Carney, Representative Harnett, distinguished members of the Judiciary Committee. My name is Shanna Bellows. I'm Secretary of State, a resident of Manchester, and I'm speaking today in strong support of LD 2023, which would enact parts of the revised Uniform Law on Notarial Acts, RLONA, which is how I'll refer to it, and bring Maine into conformity with the 18 other states who have adopted some version of RLONA. I want to start by thanking the Remote Online Notarization Working Group. To be clear, while the Secretary of State receives credit for bringing this bill forward, it really is the product of the working group and an extraordinary amount of information and thought and study by them. So as you review the proposed legislation, please keep in mind that nearly all of the recommendations, including adoption of RLONA, were unanimous by the working group, which is a politically and geographically diverse or representing a broad range of interests, from banks and credit unions, real estate and mortgage industries, to seniors and people with disabilities, to the Bar Association, the Notaries Public Organization, and Register of Deeds. These dedicated individuals met 8 times between August and February for meetings that were very long and thorough, and went into an extraordinary amount of research and detail and thought. The COVID-19 pandemic revealed the need for us to reassess how we conduct notarizations within our state. And LD 2023 provides us with common sense reforms while retaining certain processes and ensuring strong consumer protection guardrails are in place to prevent fraud or exploitation. Rather than going line by line, although I'm happy to do so if the committee would prefer that subsequent to my initial testimony, I'll touch on a few key provisions of the bill. First, the authority to perform a notarial act. Currently, the law has strong conflict of interest protections, prohibiting performance of the notarial act for an immediate family member, for example, except in case of a marriage ceremony. LD 2023 adheres to this and prevents a notary public from engaging in unfair practices. Second, who may perform notarial acts? Currently, Maine statute authorizes attorneys at law who are duly admitted and eligible to practice in Maine courts to perform notarial acts. This bill preserves that, but also authorizes judges, clerks, or deputy clerks of the court to perform notarial acts as well, which is in keeping with the uniform law. Third, the length of a notary commission. So currently, notaries retain their commission for 7 years. This bill would reduce that time. In response to Representative Thorne's question, it seems, Madam Chair, I know you have a 3-minute limit traditionally. As the agency, is it permissible for me to wrap up my testimony, or would you like me to pause and then take committee questions?
No, please complete your testimony.
Okay. So in response to Representative Thorne's question, we had a great deal of discussion about the length of commission. One of the things that we want to share is that this deviation would actually put Maine in conformity with other states and would allow for a more routine reassessment of commissions in order to verify proper performance of the due days. Lastly, performance of marriages. So currently all notaries public can perform marriages. LD 2023 would instead establish a separate commission for a marriage officiant or celebrant and repeal the power of all notaries public to perform marriage ceremonies. This deviation from current law would put Maine in conformity with other states as well. Additionally, however, it would prevent individuals who have no interest in or knowledge of performing other notarial acts from obtaining a notary commission, thus increasing consumer safety. So in summary, we believe this would allow us to modernize our laws to better serve the public and businesses alike. It's a smart step forward, and happy to answer any questions or go into more detail into the bill itself. I know your analyst prepared a 46-page analysis of the bill and how it compares to current law, which is just represents an extraordinary body of work. So in the work session, that may also be an important tool for you. Thank you.
Thank you very much. Committee members, are there questions for Secretary of State Bellows? Representative Babbage?
Thank you, Madam Chair, and welcome, Madam Secretary. Good to see you. I just refresh my memory about notary reauthorization and how the transition will take place if some people find that their commission is now going to be expired.
So the bill doesn't contemplate cutting short any current notary public commissions. So that's a really important piece of the legislation. Instead, as commissions would be renewed, the renewal would be for a shortened period of time. Now, keep in mind, and I'm sure that your members who are notaries public are very familiar with this, there are some requirements for understanding of the responsibilities and procedures of a notary public that notaries public have to demonstrate. And one of the things in these conversations with stakeholders that emerged is some of the details, particularly as we move into remote online notarization, and some of the requirements may change over time. And so the shortened commission would allow for updated training and education for notaries public as they renew their commissions. But I do want to emphasize that it's the underlying bill that is most important. So if there are details where the committee would like to make some modifications to reach consensus, we are flexible. I think to Representative Moriarty's earlier point, I think that the industries and the consumer protection groups alike do not want to see the ability to do remote notarization end. And while that may be continued through executive order, what's most appropriate is to have the legislature make a determination about how this moves forward and what the checks and balances on it are.
Are you all set, Representative Babbage?
Yes, thank you, Madam Chair.
You're welcome. Representative Moriarty, go ahead. We're not able to hear you, Representative.
My mistake, sorry. Secretary Bellows, last session I sponsored a bill on behalf of the Maine Uniform Laws Commission regarding uniform notarial acts. And were they part of the study group? And if you know, are they on board with this proposed bill?
Yes, and I'm pulling up the report because I want to be very specific. So Molly Liddell of Pierce Atwood represents the Maine Probate and Trust Law Advisory Commission, and Paul Chaikin represented the Uniform Law Commission, and both of them were involved and were part of the study group.
Perfect.
Additionally, Caitlin Wolf, who is the Legislative Program Director at the national level for the Uniform
That's
Law
great.
Commission, served on the stakeholders group.
Yeah. Remember the name from last spring. Thanks very much.
Yep.
Representative Thorne?
Thank you, Madam Chair. Secretary Bell, and I'll save the remainder of my questions for the work session. But you had mentioned that changing it from 7-year term to a 4-year term was in line with 18 other states. And I have my mother's words running through my head. Why is it important that we fall in line with what the other kids are doing?
That's a great question. And let me clarify. 18 other states have adopted RLONA, the Revised Uniform Law on Notarial Acts. 31 states have a 4-year notary public commission. And Maine's current commission length is the same as Massachusetts, which is 7 years. There are some states that have other commission lengths. New Hampshire and Connecticut, for example, have 5 years. To answer your question more directly, I think the purpose of uniform laws is as we engage in interstate commerce and acts that cross state lines, to the extent that there is uniformity with other states, that reduces confusion and strengthens the likelihood that the procedures that are followed by all parties will be in alignment and in accordance with the law. So uniformity across the states is a very important principle when you're talking about business processes that involve interstate commerce, which is one of the reasons why we so strongly support RLONA and why I think you see such strong interest from industry groups and consumer groups in this process. With regards to the specifics on the commission length, again, we deferred to the committee the majority recommendation. So this was a majority recommendation, but I do want to make the point that it was not unanimous. 2 working group members suggested 5 years instead. So a majority of the group recommended 4 years. 2 working group thought, let's do 5 years because it's congruent with New Hampshire. I think what staff have observed at the Division of Corporations that oversees the commissions is that sometimes there are people who have a lot of enthusiasm to get that notary public commission and then don't always stay current, and they're concerns that you lose some of the power of the Notarial Act if people are not following all of the rules and laws, especially as laws change.
Thank you for that. Thank you, Madam Chair.
Senator Khan?
Thank you, Madam Chair. Good morning, Secretary Bellows. So I had a few questions for you. One is, you mentioned that the change eliminates the ability of all notaries to perform marriage ceremonies, and that so that would be a separate license. And the reason you say is it's preventing individuals who have no interest or knowledge of other notarial acts from obtaining a notary commission. And so I'm wondering what examples you have of people who have gotten a license that was for the purpose of performing a marriage ceremony, but in the end ended up hurting consumer safety in some way.
So I can definitely ask our professional staff to research that and bring that back to the work session. What I would say most generally is that a substantial number of people who apply for the Notary Public Commission do so because they wish to perform marriage ceremonies. And the Notary Public office is actually an extraordinarily important office. And it is extraordinarily important for our real estate transactions, but also for a variety of other official transactions in public life. And so just from a common sense perspective, if you have people who are having to go through the hoops to study for and obtain the notary public commission, but are not truly interested in notarial acts outside of the marriage ceremony, then that undermines the strength and potential integrity of those other notarial acts. And again, for our real estate industry, for mortgages, for lending practices, and then for other things, like, for example, there are a number of documents in the elections realm that require a notary public. So I do think that creating the separate commission that would be separate for marriage officiants or celebrants, so that if somebody merely wants to provide a marriage to, perform a marriage for a loved one or friend, they can do so without them having the responsibility and potentially endangering the integrity of one of those transactions. I will say it's important to realize one thing about the bill is it would grandfather existing notaries public. So we didn't want to take anything away. It would extend a 4-year commission to all current notaries public so that they could continue to perform marriages. And then when their commission ended, we would notify them. And if they were someone who was truly just interested in marriage, they could renew that.
Yeah, I understood that part. What I don't understand is you're saying that these people then can be endangering other, other acts or other roles, but yet you're also already going through the same process, right? I mean, right now they all go through the same process of being educated for it. So are you suggesting that changes as well?
So the marriage officiant commission would be specific to marriages. We would provide with the Office of Vital Records, develop a training.
I'm sorry, let me ask that again. So what you mean is that the process of becoming a notary for all the other acts, you want that changed?
Let me be more clear. So currently, to perform a marriage is very different than to perform a notarial act for a real estate transaction for some of the various aspects of elections. So, and I would defer some of these questions to the notaries public. There's a professional organization, and this was a recommendation that was wholeheartedly supported by them as well. There are details with regards to performing a marriage that are important for marriage officiants to know. There are details with regards to the Notary Public Commission that are separate and also important. So RELONA is about strengthening the integrity of the notarial act and also creating another avenue to perform those acts. And so that's why this recommendation is part of this bill.
Understood. Thank you.
Committee members, are there any additional questions for Secretary of State Bellows? I am not seeing any. Thank you for providing testimony and answering our questions. We don't know whether we would move into a work session on this today or not, so I would just ask you to continue to hang out in the attendee part of the meeting. Thank you. And next we'll hear from a legislator who wishes to speak in favor of this legislation. That's Representative Dudera, who's going to join us in just a moment. And then I would ask all others in the attendee space who wish to speak in support of LD 2023 to raise your electronic hands and just keep them raised until you've been brought onto the panel. Thank you. And Representative Dudera, it looks like you're wearing your St. Patrick's Day outfit today.
Well, I am. I'm so disappointed that we're not going to all see each other tomorrow. So I said, well, what the heck? I'm going to wear some green today. So it's also for springtime. Thank you very much for having me today, Senator Carney, Representative Harnett, and distinguished members of the Joint Standing Committee on Judiciary. My name is Vicky Dudera. I represent House District 94, which includes my hometown, Camden, as well as Islesboro and Rockport. I'm here to offer testimony in support of LD 2023, an act to implement the recommendations of the Secretary of State regarding notarial acts. I appeared before you last year to introduce LD 1399, an act to provide for remote notarization, which planted the seed for this bill. I submitted LD 1399 as a starting point for discussions for Maine to finally adopt remote online notarization. And that was after seeing what so many of my constituents were going through as COVID-19 infiltrated our lives. There were elderly couples who couldn't update their wills, bank and real estate transactions that couldn't take place. This was in the early days before the emergency action went into place, but I'm so pleased with the work that this committee did last year. I want to thank you, and with the incredible efforts of the Secretary of State's office and stakeholders since then. Secretary of State Bellows has been keeping me in the loop, and I understand that the study group reached agreement on so many of the issues, and the result is the bill before you. So even without something as extreme as the pandemic, our state is well served by modernizing the ancient practice of notarization by moving towards the remote option. This is already allowed in many states, as you heard Secretary Bellows mention. And many industries and professionals in Maine really could use this as a tool. So for all these reasons, I urge you to pass LD 2023, and I thank you for listening this morning.
Thank you, Representative Dudera. Committee members, any questions for Representative Dudera? I am not seeing any. Again, we appreciate you joining us today.
Thank you for having me. Good luck today.
And committee members, we've got a couple of people in the attendee space who wish to testify. First, we'll hear from Andrew Cashman. And I'm going to also bring onto the panel Leo Delicata and Robin Watts. And Andrew Cashman, welcome to the Judiciary Committee. We're happy to see you. Could you please begin your testimony?
Yes, thank you. Senator Carney, Representative Harnett, distinguished members of the Joint Standing Committee on the Judiciary. My name is Andy Cashman. I'm the founder of Resolve Government Relations. And I'm here today on behalf of my client, the Maine Association of Realtors, which of course is a statewide association representing buyers and sellers in commercial and residential real estate, statewide, as well as affiliated industries. And we are thrilled to be here today and speak to you in strong support of LD 2023. We would like to begin by just thanking this committee for supporting and passing LD 1399 last session that laid the groundwork, as you've heard, for this stakeholder process and ultimately the bill that you have before you today. As the Secretary Bellows stated in her testimony, this was the result of a lot of work by stakeholders. I was honored to serve on that stakeholder group on behalf of my client, but it was a diverse array of stakeholders. And I think this is really a great example of people working together from different areas, discussing things in detail. And I think that the Secretary of State and her staff really did a great job taking, as you can see, a lot of different issues and putting them all together and talking through things in a really constructive way. Ultimately, we support this entire bill because it was the result of this process. In order to adopt remote online notarization, which is our primary focus, because of the very positive impact that it would have on our industry, it was important that all of the notary laws be updated in order to be able to utilize this new technology. And so we support all of the recommendations here, but our primary focus is on the remote online notarization and enabling that as a tool for our industry. There's a long list of reasons for why somebody may not be able to be physically present for a closing, and also other documents related to a real estate transaction along the way that might need to be notarized. And so for those reasons, it's really important to our members that there be tools available that protect, provide procedural safeguards, but that allow people that aren't able for various reasons to be physically present for a closing or other documents to be able to do so remotely, whether that's remotely in the state or people outside of state for whatever reason executing documents. So it's very, very important to our members. There are many, many examples that they have had where this would be very helpful, not only for us, but then also it's well supported by our affiliated members as well, bankers, credit unions, and so forth as well. So for all those reasons, we strongly and respectfully urge you to support this proposal. I'm happy to answer any questions that you may have. I would also note that I believe there's a number of people, stakeholders, that have submitted written testimony as well. And I would just respectfully urge you to look at any of that testimony as well in support of this. So with that, I'll take any questions the committee may have. I appreciate your time.
Thank you very much. And I see that we do have some committee questions. Representative Thorne, go ahead.
Thank you, Madam Chair. Mr. Cashman, you seem like you're very knowledgeable and probably involved in a lot of these transactions as it pertains to real estate. And I was just curious if you had seen any examples of someone who shouldn't be a notary, or maybe didn't know what they were doing, notarizing any type of official real estate document that caused a problem that wasn't done properly?
Thank you, Representative, for the question. I'm not personally aware of that situation. I'm sure there are so many transactions in the state. I'm sure that there are examples I'm just not aware of. I think that it speaks to the importance that the notary process, that it be well grounded and people are able to trust it, and the authenticity of the documents along the way. That's obviously always a very important thing to our members, to make sure that the authentication and of the documents is reliable, to avoid future litigation and so on down the road. So that's always something that we're concerned about. And we believe this strikes the right balance for that, if that answers your question, Representative.
Thank you. No, I just was curious if you were aware of any notary processes that caused problems because they were done incorrectly in the real estate arena.
Yeah.
Thank you.
Thank you, Representative. Appreciate it.
Thank you, Madam Chair.
Committee members, any additional questions for Andrew Cashman? I am not seeing any. We appreciate you being here this morning.
Thank you for your time.
And next we'll hear from Leo Delicata.
Thank you, Senator Carney. My name is Leo Delicata. I'm an attorney with Legal Services for the Elderly, and I live in Portland. Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary, we're happy to speak in favor of this bill. It represents a collaborative effort of many interested parties invited by the Secretary of State to assist her and her talented staff in crafting recommendations that informed the language of this legislation. As a member of this work group, we had the opportunity to consider Maine's current notarial laws, the evolving best practices in the world of remote and online notarization, and the comprehensive approach for the delivery of all means of notarial services offered by the Uniform Law Commission's revised Uniform Law on Notarial Acts, otherwise known as RULONA. The Secretary personally led each of our virtual meetings and encouraged everyone to contribute their view on each subject. She ensured that the discussions were respectful and substantive. Not surprisingly, we were able to reach broad agreement on all the topics we considered. The Secretary's report contains a descriptive narrative of each subject and the recommendations that emerge from that work. As the summary in this bill demonstrates, this legislation is built upon those details. You will receive a comprehensive analysis of this bill from your OPLA analyst. Anything that we might write in that regard will be repetitive at best. However, from our perspective as attorneys providing legal services for older adults, we can share three conclusions about how this bill will affect our clients. First, while adopting best practices, it does not materially change the experience a consumer will have when receiving in-person notarial services from a notary public or an attorney. Second, Consumers will have new opportunities to receive remote notary services from a qualified notary or attorney. Third, it contains safeguards against fraud and exploitation by requiring reasonable methods of providing identity, recognizing the right of an individual to refuse to perform a notarial act if the consumer's capacity or volition is suspect, and most importantly, requiring the preservation of a video recording of each remote notarial act. We believe that this bill provides a step forward for consumers and allows commercial interests to conduct business according to the best practices currently available. We hope that you will agree and that you will vote to pass. And thank you for letting us offer these brief comments.
Thank you very much. Committee members, are there any questions for Leo Delicata? I am not seeing any questions from committee members. Thank you so much for providing testimony today.
You're welcome. Thank you for the opportunity.
You're welcome. And next we'll hear from Robin Watts. You can begin when you're ready.
Thank you. Good morning, Chairs Carney and Harnett and distinguished members of the Joint Standing Committee on Judiciary. My name is Robin Watts. I am an attorney and practicing in South Portland and a resident of Portland, Maine. I was fortunate enough to be able to serve on the Secretary of State's working group to review RULONA. But I'm here and in that capacity, I was representing the Maine State Bar Association's real estate and title section. But I'm here today to speak on behalf of my employer, which is First American Title Insurance Company, which is a national title insurance company serving customers in Maine and with a network of working with a network of real estate attorneys and title agents in Maine. And we would like to support LD 2023. I provided very brief testimony on behalf of our company. I think a lot of testimony was presented when the original bills came before this committee, and we provided a longer testimony at that time outlining why we think that Maine is now ready for remote online notarization as an option for Maine residents. And so this testimony is very brief, just to indicate that we do support the version of RULONA that the Secretary of State has submitted in their report. And in particular, the remote online notarization portion of that, this RULONA would update all of Maine's notary laws, including the Uniform Recognition of Acknowledgements Act, replacing that act. But it would most notably enable various forms of electronic notarization, including remote online notarization. And that type of notarization has now been widely accepted in many states across the country. And RULONA in particular has also been adopted in many states across the country, as noted in the report from the Secretary of State's office. Just like it sounds, remote online notarization takes the traditional notarial process and moves it to an online process where the signer signs a document and it's notarized via a webcam or a smartphone or some other secure audio video two-way communication device. We think that there are several reasons why remote online notarization would benefit Maine residents, but in particular, it provides convenience to consumers, ease of access for those living in remote areas. It can be done anywhere, anytime, and eliminating the need to make appointments, to meet in person, to leave work for any long period of time, or to drive miles to find a notary. And of particular importance, and I think something that we've all worried about, is security. When we first heard about remote online notarization, it sort of sounded space agey, and we wondered whether it was really an appropriate thing for Maine. But now we have years of experience from other states showing that it can be a very secure process, more secure even than in-person notarization in some instances because of its multi-factor authentication process. And the version of Rulona that the Secretary of State has adopted has built in many security measures and then has allowed for rulemaking by the Secretary of State to allow for a flexibility to add additional security measures and to meet the changing landscape of our electronic world. One thing that I would note, and which our industry might find to be additionally beneficial, is the review and possible adoption in the state of Maine, not necessarily as part of this session, but at some point in the future, of another uniform act called
Robin Watts, I'm sorry to interrupt you, but the 3 minutes has passed.
Okay.
And also, we're going to restrict comments to just the bill before the committee. And
Okay.
we're not able to take up other matters at this time.
Okay. Well, thank you,
Let's just-
everyone, and please let me know if you have any questions.
Thank you. There may be questions for you. Just a moment. Committee members, are there questions for Robin Watts? I am not seeing any. Thank you once again for providing testimony today. And just turning to the attendee portion of the meeting, is there anyone else who wishes to speak in support of this legislation? I am not seeing any hands up. And so now for those who wish to speak in opposition to the pending legislation, LD 2023, please raise your hands and keep them raised. And again, I'm not seeing anyone. And finally, if there's anyone who wishes to speak neither for nor against LD 2023, please raise your electronic hand and keep it raised. And I, again, am not seeing anyone. And so with that, we will close the public hearing on LD 2023. I would ask committee members if the committee wishes to move into a work session on this bill. Representative Moriarty?
Thank you, Madam Chair. Having listened to the testimony and noted the lack of opposition, I move to suspend the rules and to proceed immediately to work session.
Thank you, Representative. Senator Kime?
I do have further questions that I was told I would get answers to in the work session, which of course wasn't contemplated to be within 3 minutes. And I mean, there were suggestions several times of some sort of endangering or some sort of endangering of consumer safety. And I think those questions should be answered before we consider voting for this bill.
Mm-hmm. Yes, and if we moved into work session, we would have a regular work session. We'd bring the Secretary of State and others who you wished to ask questions of back onto the panel. I know that you had asked those questions. Senator Sanborn?
With regard to that, I was just wondering if we have a full analyst review ready to go. I think the chart has already been prepared and the bill analysis that would be normally presented to us at a work session, which is what would normally take a couple of days for our analysts to develop. I think it's already been developed. Is that the case?
Yes, that is the case.
Sorry about the barking dogs.
I think that Peggy emailed it to everyone. So we have a motion to go into work session. We have not yet voted on that motion, and I actually didn't even see a second to the motion. So let's just back up a moment. Representative Arnett?
I will second the motion to suspend the rules and go into work session immediately.
Okay, so there's a motion and a second. Is there any additional discussion on this motion? I am not seeing any. And so committee members, if we could do this first by a show of hands, we may need to take a roll call vote, but we could do a show of hands on suspending the rules to move into work session. Please use your actual physical hand. I'm going to ask our committee clerk if she can just do a roll call on this vote, please.
Madam Chair, may I
Yes,
just
go ahead.
comment briefly? Thank you. I'll put my hand down. I certainly don't want to cut off debate. We're getting near the end, and by going into work session, we can at least explore if questions can be answered. And so I am sympathetic to anybody that always needs more time, but perhaps we can address what needs to be addressed now. Thank you, Madam Chair.
Thank you. Yes, this is simply a vote to go into the work session, and we can see where that work session takes us as far as a vote on the legislation. And Clerk Panett, are you able to join us and do a roll call vote on the motion to go into work session?
Madam Chair, if she's tied up, I can do your roll call for you if you want.
Oh, yes, please.
Okay.
Many thanks.
Sure. Senator Carney.
Yes.
Senator Carney, yes. Senator Sanborn.
Yes.
Senator Sanborn, yes. Senator Keim.
No.
Senator Keim, no. Representative Harnett.
Yes.
Representative Harnett, yes. Representative Babbage.
Yes.
Yeah. Representative Babbage, yes. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt, yes. Representative Moriarty.
Yes.
Representative Moriarty, yes. Representative Sheehan.
Yes.
Representative Sheehan, yes. Representative Hagan. Representative Libby.
No.
Representative Poirier. Representative Thorne.
Yay.
Representative Evangelos.
Yes.
Representative Newell. I'm going to recall the absentees. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Representative Newell. Representative Newell is absent. Nine. Madam Chair, I have 9 voting in favor, 2 voting against, and 2 absent. I think that's right.
Yeah. Many thanks, Peggy. And so the motion to suspend the rules and go into work session prevails 9-2 with 3 absences. And so, Peggy, I know that you're busy doing things related to calling the vote, which we appreciate. But when you are ready, we would appreciate your bill analysis.
Great. So thank you. This isn't the typical bill analysis because I usually wait till you hear testimony and try to throw that into the bill analysis as well. I don't know that anybody who testified today actually raised questions about the bill itself, maybe talking about going farther someday. So what I had promised to put together for you, and I wish I had gotten it done earlier, was to compare the question when the Secretary of State presented the report a couple of weeks ago was how did this working group change from the uniform law, and also how does it change the current law? And the Secretary of State raised some of those issues about marriages, being efficient at a marriage, and also the time that somebody, once they're commissioned or once they're licensed, how long that that authority lasts. So those are 2 things that changed. Most of what's currently in law has been incorporated into Rulona. If you had a chance to look at that chart, and I would be amazed if you did, I'm certainly happy to share it on my screen if you want to look at it. The conflict of interest, Maine has a much stricter conflict of interest standard than most other states, and that is retained. I can Do you want me to share it and scroll through it as I'm, okay.
Yeah, I think that would be very helpful, Peggy. Thanks.
That's about as big as it gets. So here, I will actually go back up to the top. And so what I tried to do is flag things that were different from the uniform law, which is in this far left column, and the bill. So we have a little bit of different formatting and sometimes how we word things. But one of the things that's retained is notaries have a role in filing or notarizing protests for mercantile usage. So that's maintained. Maine also includes or will include an official notary seal. I know Janet always worries about giving you seasickness as we go through these too fast, but these differences from the current law as to the conflict of interest, I'm sorry, these differences from the uniform law with regard to conflict of interest are actually current law. And here's the current conflict of interest statute, so you can compare that. And it includes when your somebody in your family is interested in the transaction that you are notarizing, although you can solemnize a marriage. And then there's if a notarial officer is interested in a corporation, that's very limited what a notary can do. And then when there's a direct initiative or people's veto referendum, the notary, the notarial officer, if they also provide services that are not notarial acts, then they're not supposed to be doing the oath or affirmation on that. Any of these, yes.
Oh, I'm sorry. When you're done with this section that relates to the kind of conflict type issues, we have a question.
Yeah. Okay. That just that if a notary engages in one of these acts in which there is a conflict of interest, they are voidable. Which is a little bit different than void. It doesn't mean that they're not valid. It means that they can be invalidated. I see Senator Keim has a question.
Yeah, Senator Keim, go ahead with your question.
Thanks. Peggy, can you scroll back up? I have a couple of questions in this section. And
is this what you want?
so one of them is, I think it's up higher, where it's, okay, yeah, here. So when it says direct beneficial interest, I think that normally means something that's financial, but could that be brought in to mean other beneficial interests? I'm just wondering the context of that.
You know what, that is, I believe that is current law. And I guess I would ask if the Secretary of State or somebody in her office that administers this has had a chance to identify any of those situations.
Oh, okay, we can, let me bring the Secretary of State back onto the panel so that she can ask questions that come up as we review your chart. And just give me 1 second.
Do you want me to stop sharing or?
Yes, please, while we have the
sorry,
the answers to the questions. No, I'm kind of zooming back and forth. And we're also going to bring in Kathy Bowden, who works in the Secretary of State's office.
And as I'm looking at it, it looks like that direct beneficial interest language is really in the Uniform Act. It doesn't look like we're bringing that over from the current law. So I don't know if that is something that the working group spoke about in detail that they would be able to share.
Okay. And Secretary Bellows, did you wish to wait for Kathy Bowden to join us to answer that?
So it looks like Director Bodwin is in the meeting. She is really the expert. She is the director of corporations, UCC, and commissions, and she oversees the issuance of all of the notary public commissions and can answer this question and other questions as well. We did, between the hearing and the work session, and Director Bodwin can speak more clearly to this, confirm that when we talked about our concerns about sometimes people asking for a notary public commission for purposes of performing a marriage, sometimes in an expedited way, sometimes on the Friday before a wedding that's on a Saturday, that we had a generalized concerns that some of those requests are not because people have any interest in doing any other notarial acts or any expertise, but we do not have any documented cases in our office of notarial fraud. Although it's important to recognize that we are a ministerial office that administers the program, we do not have enforcement authority or investigative authority. But Director Bodwin is here and she is the expert.
Thank you, and welcome, Director Bodwin.
Thank you.
Would you like Senator Keim to restate her question? Would that be helpful?
Yes, please.
I certainly will. So direct beneficial interest, I'm wondering how narrowly tailored that language actually is or how broad that could be used.
That right there is just, it's the uniform language that we thought was important to adopt to stay uniform with the rest of the states. I don't have any specific cases or complaints or anything that we've had in the past regarding it, but our current law is so vague on it. And we get the question a lot in regards to what would constitute, you know, a direct benefit. Can I notarize something for somebody if, you know, if I'm not getting a direct benefit, but maybe indirectly I'm going to benefit in some fashion. And so we just, like I said, nothing concrete that I can share with you for an example. However, we do get the question every once in a while, and we thought it was important to adopt Relona's version of that.
So, but what I'm actually asking is, even though this is Relona's language, it seems like a really broad definition. I mean, it seems like a broad statement. I'm not sure how this applies. So a direct beneficial interest. So if I'm a Republican and I notarize someone's petition that's also a Republican and I'm glad they get in office, I mean, it's a benefit. I mean, I just don't know how broad that goes and what we're sort of canceling out that's, you know, invalidating because there's a benefit.
I'm not sure that would be actually considered a direct benefit.
Mm-hmm.
I wouldn't take that. I'm talking more of when I think of direct benefit, I'm thinking of beneficial in some way, and you know, financially a benefit or a promotion or, you know, something like that. But I wouldn't consider that a direct benefit.
And if I may, Madam Chair, just expand on that point, I want to draw the attention to the language in the bill. If you notice, it's specific. A notarial officer may not perform any notarial act with respect to a record to which the notarial officer or the officer's spouse, domestic partner, parent, sibling, or child, or an in-law or a step or half relative of the officer is a party or in which one of them has a direct beneficial interest. So that language is specific to that circumstance in subsection B. So it's section 1904 of the bill, 3B.
Right. So, but it's saying that, so it's actually more broad. It's not just beneficial to the notary, him or herself. It's actually, it can't benefit any of their relatives if they're a party, or in which any of it. So if the officer, any of the relatives, or the officer themselves, I suppose, is a party, or if any of them have a direct beneficial interest. So it's more broad than just the notarial officer themselves, and it's any notarial act, right? Because this is an overarching consideration of conflict of interest over any notarial act. So this, to me, it just seems broad, and I think it would probably need someone maybe with a legal background or something, or someone who's actually kind of looked at this law more deeply to help me understand if this is narrow or broad. It reads really broad to me. And I don't think that I've been given examples that help me understand how it couldn't be broad. I can understand how it could be narrow, but not how it's tailored so that it's not broad, overly broad.
I understand your concern, Senator Keim, and I have a suggestion, which is that we continue to go through Peggy's chart, because I think this deeper dive into the language of the act is really helpful in helping us identify areas where we might need more information or a deeper dive. And so I really appreciate your questions. I'm sensing that if we could go through the chart and get all of our understanding of the proposal completed, then we could table this and return for a work session where we kind of probe those issues that we're still more concerned about. But I think it would be helpful if we could do the understanding the proposal part and then the follow-up in a later work session. I think that's probably the best way to use our time today. So I'm encouraging you to ask your questions, but remembering that, or suggesting that the committee as a whole would benefit from identifying the questions and then tabling the bill and coming back when we have people available to address them.
Okay, and I have another question in the following section.
Oh, in the following section?
Well, in this section, but in C, instead of B, it's C. So I guess I was understanding that this would preclude one type of notary, I guess is maybe how we want to put it, from doing marriages, but yet this says they can do marriages. So in essence, a notary can still do marriages, but there's also going to be a separate license to do only marriages. Is that the plan?
Is that a question for?
I think the Secretary of State, or I don't know. I mean, maybe Peggy,
Director
because.
Brodwin? Okay.
Hi there. So my understanding is that if the committee wanted to move forward with our recommendation of a separate commission, then we would make some changes and amendments to what we have put in here. And I just wanted to stress that Rolona does not address marriages whatsoever. There's only a few states, there's only like 3 states that actually allow their notaries public to marry people. So Rolona does not address marriages at all. So we had put that in because our current law provides for that. So my understanding is we would amend that should we move forward to remove the notaries to marry people, if we decided we'd go with a separate commission as we recommend.
I'm confused. I thought what was in front of us is what I was looking at, then in LD 2023. So testimony is stating that there is going to be a separate commission for a marriage officiant. And yet what I'm reading is that it's part of this, so I'm confused. So you mean that 2023 needs to be amended?
Yes.
Senator, I think you've identified something that we missed. And the working group spent many, many hours going over this legislation together as a group. And we did it all in public meeting. But I think you're correct that if you decide to move forward with the language that is at the bottom of the bill about the marriage officiant, you would want to remove C. And I would defer to Peggy and to Opla to just verify that. But I believe that you have identified an error in the bill that we submitted as part of our report. Subsection C, to Director Bodwin's point, probably needs to be struck. If you don't strike, if you don't create a separate marriage commission, then you would want to keep subsection B. So.
Do you mean subsection C?
C, yes, thank you.
Okay,
Yep.
and then can I ask a follow-up question to this exact issue, Madam Chair?
Yes.
So are you contemplating then, because when you first got on, you answered my question about whether or not there had been a sort of endangering of consumer safety. And you said that there wasn't any record of that, but you had a concern about it. I understand you're stating that. But then, so my question is, the process that a person goes through to become a notary, are you intending to change the process? Like right now, what the process is of, of going through the online test and reading that, are you intending then that needs to get changed?
I'm going to defer to Director Bodwin.
Okay.
So in terms of what is required, the requirements are pretty much the same. However, the testing, so the knowledge part of the application is what's important. And that's where we've seen issues with people who are becoming notaries just to marry somebody. They have a wedding next week and they come to our office and they claim, I need to get my notary because I need to marry somebody. Well, it's a lot because they go through the testing, they're answering the questions, and they're not fully understanding the notarial responsibilities of it. And so they're looking through the handbook and they're writing down their responses just so they can get a notary commission. And then in the future, I mean, a commission of 7 years is a long time. So then they're contacting our office and saying, somebody's presented a document to me and they want me to notarize this. I'm not sure what I need to do. I became a notary several years ago and to marry somebody, but I'm not sure, what do I need to do here? Those are the types of things that we hear. Or we hear from somebody saying, there's somebody in the office that's a notary, but they won't notarize a document because they only became a notary to marry somebody years ago. That's the reason why we're looking to separate those responsibilities. And so to answer your question with the knowledge base, the testing, I think we would have to beef that up and ask more detailed questions, especially regarding remote or electronic notarizations if we move forward and adopt that. So the testing part would change based on the questions and the level of knowledge of any of the new requirements that we adopt in the law. So that's how it would change, is how we move forward. We'd have to adjust that testing and that knowledge piece for our notaries.
Is the testing something that you do through routine technicals rules, or who sets up the testing?
We do that here in the office as it's, part of the statute currently, and then part of our rules. So on the application, whether it's, an applicant is becoming a notary for the first time, it's a paper document that they would answer the questions, refer to the manual, the notary guide, and then renewals are done online right now. So currently they ask a series of questions. They have to pass the test. They can't move forward until they've answered all the questions appropriately. And so they can refer to the manual to find that correct answer. That's how it's currently done.
Okay, thank you.
Representative Thorne, go ahead with your question.
Thank you, Madam Chair. And I'll be forthright. I'm a little uncomfortable with this conversation because I am that guy who got my notary so I could marry my nephew. And the reason why is because Maine used to have justice of the peace. And was that not their only function, was to marry people?
Yes, it was
So,
years ago.
seems like we're stepping back in time and reactivating the old notary, taking the notary public out of it and making people justice of the peaces again. So, and it sounds like it's a big inconvenience to have to answer people's questions about technicalities concerning notarizations. So I can understand that from that perspective. My question is, I haven't heard or talked to any of the people that were on the committee. And I'm just getting a feel that it seems like it's kind of a, this bill is kind of like building a snowman. As you roll the ball across the lawn, you pick up all kinds of incidental sticks and toys and chunks of grass that you never intended to. And one of them is we're throwing out, the people that just want to marry people from the Notary Club. And then the other one is that we have a series of questions that are still unanswered. So my question is there anybody that's available from the committee that was formulating this that we could ask the questions about why we're going from 7 to 4 years and why not 5? And seems like we're making it harder when it should be more welcoming and make more people available to it. And it seems like it's being a more exclusive club. And I'm sorry, it looks like I'm giving Representative Reckitt a headache by asking my question, but it just stands right now. I can't support it because it seems like you're making it more exclusive and excluding people than it is, welcoming people to become notary publics and helping to educate them about how to be a good notary.
Representative Thorne, I'm so sorry to interrupt you, but we,
I'm
as I said a few minutes ago, I think it would be helpful if we could just kind of understand the flow of the bill, and then we'll table and we can have a follow-up work session where we do the kind of questioning. I understand and appreciate.
Never seems to be a good time for my questions. I understand. Thank you, Madam Chair.
Okay. Committee members, are we okay with allowing Peggy to continue to review the chart and then we'll table this bill? Is that okay with everybody? Okay. Thank you.
I'm sorry, I closed my document, but here we are. Back to sharing. So lots of questions about that section. These are requirements for certain notarial acts. These are consistent with the Uniform Act. This subsection 6, this is one of the things that Maine was unique in, and we're going to retain that, protest of losses. And then the things I have stuck here are other provisions. So maybe I should go back a little bit. There are a couple of chapters that this bill would repeal. One is the Uniform Acknowledgements Act, and the other is the whole chapter on notaries public. So some of these things are in those chapters, and we just want to make sure that everything transfers over. That is an important thing to retain in Maine law. It's really not a change about the personal appearances required, except when we get to the electronic, there still has to be somebody there. I think this is one of the things that Secretary of State Bellows mentioned when she presented the report, that the uniform law says for ID, you shouldn't take something that is more than 3 years expired. And the working group decided that it was okay in some situations to have identification that was expired as long as it worked in the circumstances. So that's one of the changes. I'm just going to keep scrolling down here. This is where attorneys have the power to notarize things. This is in the current law, and this would be part of notarial acts in the state that who can perform them. So here's the difference that we call, there'll be a new term, which is notarial officer. So that would include attorneys, it would include notaries public, but it would also include these folks: a judge, clerk, or deputy clerk of a court in the state, any other individual authorized to perform the specific act by the laws of this state. So just making sure that notarial acts that are performed outside the state are recognized. That's one of the reasons why you do have a uniform law. So that's really consistent with our current law as well. When it's federal authority is recognized. I know I'm going really fast. Maybe you want to just shut your eyes. So here's the new piece, and you'll see that the Uniform Act calls it Section 14A, and this is where we start deviating from the numbers because we don't do A's initially anyway. So this is the new part about a remotely located individual and all the processes that are supposed to happen. This takes the place of the executive order that the governor issued in 2020, and then which you kind of continued by enacting a law last year and giving it a temporary authority, and then creating this study group that the Secretary of State took on to deal with these remotely located individuals. And perhaps that's one of the things you want to spend more time on, is the actual details of how that works, because this is really new to the process. And it's not just, it's a whole aspect of when the notary and the person whose work they're notarizing, what they're doing, they're actually not in the exact same place. So maybe that's something we can just set aside and come back to do detail wise, because we know that's something you're going to want to talk about. I know Senator Keim's hand is up.
Senator Keim, did you have a question or?
I did, but I've lost my place, so I will wait until I find it again.
Okay, yeah, thank you.
Okay, so I do think that takes a little more time to go through, because that's a new process that is put into statute, and the rules and the technology and what kind of record is kept. That's just we don't refer to the National Association of Secretaries of State. We just talk about a National Association of Secretaries of State. This provides for the Secretary of State to establish a reasonable fee, because the Secretary of State accepts service of process when their communication technology is being used. And then these are Maine specific provisions. Remote notarial acts, the following here are permitted, prohibited. Can't do a marriage. You can't mark and witness the marking and sealing of an absentee ballot, ministering an oath to a candidate. And so these are mostly election based things that cannot be done remotely under this law. Almost everything else can be done remotely. The rest of it is about the stamp, the certificate that says, yes, I'm a notary, in making sure that it doesn't have to be exactly the same, but it needs to comply with all the requirements. And here's the thing that always drives us crazy, putting these forms actually in the statute just because of the formatting of them. But the revisor's office did a fabulous job of putting this in the bill. And you'll see that the current law just drops off the side of the page. And I decided not to spend my time on that. Official stamp, that's current law for the most part. And continuing a stamping device. And I'm assuming that there might be some questions about that going forward. A journal is required. I know that one of the pieces of testimony from an organization that does a lot of electronic or remote notarization support, this says you can only have one journal. And so there might be something going forward that the Secretary of State will want to think about if these other platforms are used that automatically make a journal. And yet the notary is also doing paper authorizations or paper notarizations. And so it might be hard to keep them both in the same journal. I'm not sure that this addresses that. And this language that's in italics, I just kept those in there. Those are the comments from the uniform law commissioners about think about this, or if your state does things this way, you might want to make this choice in the language. So this is when there is when a notarial act needs to be executed on an electronic record, the selection of the technology, and that the notarial officer that's going to do that needs to contact the Secretary of State to let the Secretary of State ahead of time know that they're going to be doing it. So it's using that type of technology, so they comply with it from the very beginning, comply with the Secretary of State's rules. The qualifications, I believe these are the current qualifications. The oath, Maine has a very unique oath, so that's our oath is transferred over. I must admit, I don't know what that is. Oh, the bond, the surety bond. Maine does not require a surety bond for someone to act as a notary public. The uniform law offers that as an optional thing going forward, optional part of the law to have uniform law for the states that require it, but they're not saying states need to require it. Here's what Ms. Bodwin was talking about, the examination, the testing, course of study, why the Secretary of State would deny the commission the right to a hearing, which would happen under the Administrative Procedure Act if they're either denied or theirs is revoked or not renewed. The Secretary of State establishes will establish an electronic database. And these are things that acts that are not authorized. If somebody who's a notary also has some other authority to do things, then that might be fine to go ahead, but just the notary commission does not give them the authority to do these things. And this is just my suggestion. It prohibits a notary public who is not an attorney licensed to practice in this state from using the term notario or notario publico, because in other countries, that's the term that attorneys use. So that would be kind of a form of a false advertising. I'm suggesting that instead of saying use the term, use the title, because this technically this says you can, if you're a notary and you're not an attorney, you can never use these words. And that's not what that means. That's not what it's supposed to say. You cannot hold yourself out as being this, having this title. So that's just a quick suggestion for amending. Advertising, what advertising means. And it's basically, the concern is that notary publics are misunderstood to be attorneys and to be able to offer legal advice and to engage in the practice of law, and they can't unless they're actually an attorney. So that's what most of this is about. So that's just consistent with the conflict of interest limits in the current law. We don't have surety bonds. That's just a little bit different in wording about the uniformity from state to state. And then what we don't have in the bill is an effective date. And so we thought, oh, actually we have it in the bill, and I don't know if you want to add it to the actual chapter. So it's there. If you open the red books or you look at it online, it's very clear that the chapter takes effect July 1st, 2023. And then here are the other, these are cross-reference changes. And so those are easy when you're just doing cross-references. And just the cross-reference to the revised Uniform Law and Notarial Acts, the facsimile signature of the Secretary of State. The revisor's office looked at this and said, there's so much gender-specific language in there, we need to repeal and replace that, but carry out the same purpose. And then here's the language that the Secretary of State's office has proposed about creating the separate license for a marriage officiant. And it would be in Title 19, no, this would be in Title 5 because it's the Secretary of State's authority. And then there's all the standards, but then it would be in cross-referenced in Title 19A in the marriage statute. So this is the marriage, who can perform marriages, or how marriages are recorded. 655 is who can perform, persons authorized to solemnize marriages. So right now, here's the cross-reference to a notary public under Title IV, Chapter 19, which we're going to repeal July 1st, 2023. So what the bill does is repeals that 4 and adds a 5 that cross-references the marriage officiant under that new section that the Secretary of State has. So right now, it is true that a notary public, that is one of the things a notary public can do. It's mentioned in the marriage laws, but it's also in the notary public statute that they have authority to do that. And I'm trying to think if there's another provision. So then the next section in the marriage law about lack of jurisdiction. So this section actually says if somebody professes to be able to marry you, it doesn't void your marriage. The fact that they aren't doesn't necessarily void your marriage. So that's just cross-referencing the notary to marriage officiant. And then here's the provision that Secretary of State Bellows mentioned about that anybody who has a notary public right now, a notary public commission right now, will also receive a marriage officiant license for a term of 4 years if they're commissioned, if they have that commission as of July 1st of 2023. So although the authority for a notary will be lost, a notary to perform a marriage will be lost, they will automatically be issued a marriage officiant license going forward for that first 4-year term. They don't have to take it. If the reason they're a notary is so they can notarize documents, then they don't want to do marriages, they don't have to take that, but it's there. So the effective date, it takes effect, the whole act takes effect July 1st, 2023. And one of the things we talked about that we ended up not getting into the bill in time was Representative Dudera bill last year, you turned into a bill that basically codified the governor's executive order about remote, how to modify in-person notarization when you have a pandemic going on where people can't actually be in the same place. And that expires, that whole law expires. It was put into place in order to give the Secretary of State's office time to come up with a more comprehensive way to address the issues. So this law expires January 1st, 2023. If the bill doesn't take effect until July 1st, 2023, you're probably going to want to change this because there'll be a gap. So just make that consistent with the effective date of the bill. And I think that's all I had. But that's the current law with regard to notarizing things when people aren't actually in the same place. It's not the same as remote notarization, but it's, oh, I'm sorry, it is remote notarization. It doesn't require somebody to do it, but it's also not electronic notarization. Okay, I'm done talking.
Peggy, thank you very much. That's a great overview of the legislation, and it helps us kind of see the details that we need to be thinking about as we move forward. Senator Keim?
Thank you, Peggy. So as I read, as you were going through that, I noticed that in your comparison on page 43, that it does talk about the marriage license is, I mean, the ability to be a marriage officiant is basically given to the notary. And so therefore that other section I was questioning is necessary. Am I right in that?
Let me think about that. So what you're saying is here, is this the section you are talking about?
Page 42 and then on to 43. Sorry, I'm looking at it on my own screen because then I can see what I'm talking about.
Right, right.
Yeah.
So this, or you're looking at this language that the Secretary of State will kind of.
So on page 43, it says the Secretary of State shall issue a marriage officiant license for a term of 4 years to every notary public commissioned in this state. And then they can decline to accept it, but they have to take a proactive step. So I don't, maybe they mean to strike that as well. I don't know, because if that is in fact in there, then the other part I was questioning up in the conflict of interest section, I mean, those two are both, I guess, saying the same thing.
So this is B7 is intended to be a one-time extension.
Okay.
For those who actually are commissioned as notary publics on July 1, they're already, they're a notary as of July 1, 2023, when this act goes in effect and takes away their authority to officiate at marriages. So what the Secretary of State is doing there is, if you are a notary and the law takes away your authority to do marriages, we will actually license you as a marriage officiant, so you can continue to do that for 4 years. If that's why you were a notary, your commission doesn't expire for a while, then we'll go ahead and license you as a marriage officiant as of that day, because your notary commission won't authorize you to do marriages anymore. So that's kind of her gap filler. And
okay, I misunderstood. I thought that this was set up so that if you were a notary already, that you would be grandfathered in until your commission expired anyway.
This is only for 4 years. So if you had just been commissioned as a notary, so you have a 7-year term under the current law, that wouldn't last the whole 7 years.
Okay, all right. I misunderstood that, I guess.
That's my understanding of what this wording is.
Okay, thank you.
Peggy, could you stop the screen sharing, please? Thank you. Committee members, I feel like, and I am sorry, Senator Sanborn and Representative Thorne, but I feel like we have done a good overview of the areas, the specific language of the bill, and where we need to do some follow-up work. I don't think we're prepared to do that follow-up work today. We only had a couple of people who wanted to weigh in on this, and I feel like the questions that the committee has extend beyond that small group of people. I would like to give the Secretary of State a moment to give us any concluding remarks, and then I would ask that a committee member make a motion to table so that we can do some follow-up work on the issues that have been identified this morning, and then come back and have a final work session where we address those issues, potentially amend the legislation, and move on to a vote. And so Secretary Bellows, if you wanted to give us a few reflections, and then we'll request a tabling motion.
Thank you, Senator Carney. There were a number of attorneys on the working group, and we also had the Office of the Attorney General present for all the working group meetings. So we will invite one of or multiple attorneys to follow up with your analyst with regards to Senator Kimes' question about direct beneficial interest, and be available at the next working group. We can ask the Office of the Attorney General to be present, but like I said, there were a number of attorneys on the working group as well. To answer Representative Thorne's question about hearing from members of the working group, I want to draw your attention to the committee file. There are written submissions, testimony in favor of this bill from 10 of the 16 external stakeholders who are part of the working group. And of those, you heard oral testimony from 3 of the external stakeholders of the working group. So definitely take a look at that. I think also to address Representative Thorne's earlier point, this legislation is complex because it is the remote uniform law on notarial acts is a complex body of law that is designed to protect our business transactions, some of our election documents, and a wide variety of transactions. That's why there was so much deliberation by the stakeholders. And while I, as Secretary of State, get to bring forward the legislation, this really is the product of a very diverse group of stakeholders who, I'd like to reiterate, on almost every point were unanimous. So I just encourage you to look at the file and reach out to those stakeholders before the next work session. I'm sure some of them will be reaching out to you as well. Thank you.
Thank you, Secretary of State Bellows. Representative Harnett?
Thank you, Madam Chair. I move that we table the work session on LD 2023.
Thank you. And is there a second? Seconded by Representative Sheehan. And committee members, let's do a vote by a show of hands. And if necessary, we'll do a roll call vote. So all of those who are in favor of the motion to table LD 2023, please raise your hand. That is unanimous. All right, thank you, everyone. And Secretary of State Bellows, Director Bodwin, thank you for being here today and for answering our questions. And so the work session on LD 2023 has been tabled. And Peggy, thank you so much for that extensive analysis of the bill and for reviewing it with us. Representative Moriarty, did you wish to speak?
Just quickly, Madam Chair, back on February 11, Peggy emailed to all of us a copy of the report of the study committee. And it might be useful to have that resent to us for those who didn't copy it or may have not have had it with them for this proceeding today.
Okay, yeah, I think it's probably also in our electronic committee records.
It may be.
It's not there, but because when we got it, we didn't have a bill. It's posted on our judiciary reports page, but I'll also submit it to the electronic LD file. So that's a great idea. Thanks.
Thank you so much, Representative Moriarty. Okay, committee members, we're going to open up our third and final public hearing of today. This is a public hearing on LD 2008, an act to establish a court process for involuntary substance use disorder treatment. And we are going to welcome Representative Colleen Madigan, who is the sponsor of this legislation. She'll be joining us momentarily. And while she is joining us, I would ask those in the attendee part of the meeting who wish to speak in favor of this legislation, if you could please raise your electronic hands and just keep them up until you've been brought onto the panel. Many thanks. Representative Madigan, welcome to the Joint Standing Committee on the Judiciary.
Thank you. Thank you for having me today. Good morning, Senator Carney, Representative Harnett, and colleagues on the Judiciary Committee. I am Representative Colleen Madigan. I represent the good people of House District 110, which includes parts of Waterville and Oakland. I'm here today to present LD 2008, an act to establish a court procedure for involuntary substance use disorder treatment. I first started working on this bill in the fall of last year. I had every intention of putting the bill in next session were I to be reelected this November. But then tragedy intervened. My sister Alana died on January 6th of this year. She died from alcohol withdrawal, although her death certificate says cardiogenic shock, because sometimes alcohol withdrawal is deadly. I am a licensed clinical social worker, a legislator, a member of the Health and Human Services Committee, and I sit on the State Substance Use Disorders Commission. I am also a family member of a person who had alcohol use disorder. My sister Alana was the person I was most close to in the world other than my husband. She was my little sister, my partner in crime. She tagged along after me all through childhood. When I was at the State House, if you ever saw me looking at my phone, and I was probably texting her because she would send me funny pictures, words she made up to make me laugh. That's what she did for people. She liked to make me smile. She was in recovery for 15 years. She was born with birth defects that weren't discovered till she was an adult and in recovery. Early in her recovery, doctors discovered she had only been born with one kidney. She was also missing, she only had half a uterus, missing fallopian tubes, and had a problem with one ovary. A few years ago, she developed cyclic vomiting syndrome, which is pretty rare in adults. It was very painful. She was hospitalized a number of times for that. It was more risky because she had only one kidney and was prone to dehydration. She lost her job due to the absences due to this illness. The doctor prescribed her opiates, and for Alana, as it has been for many others in our state, that led to substance use disorder. The doctor stopped writing the prescription for opiates, and Alana relapsed with alcohol after many years in recovery. And from there, it was like a runaway train coming for her. For the last 2 years of her life, she was hospitalized many times for alcohol withdrawal. Sometimes she wound up in a detox unit. Sometimes she was in an IC unit or a medical surgical unit. In the last year of her life, she was hospitalized 12 times for alcohol withdrawal. Plus, there were numerous emergency room visits due to her cyclic vomiting syndrome. In November of 2020, Alana shared with my mother and I that she had been sexually abused by a friend's father when she was a child. We had no idea. She couldn't get this abuse, the memories of it, out of her head, and she was plagued by nightmares for it. These are the re-experiencing symptoms of post-traumatic stress disorder. We had no idea this had happened to her. Each and every time I brought Alana to the emergency room because she was withdrawing from alcohol, I would wait until they had started the IV medication to stop the shaking that happened before seizures. And then I would seek out the doctor or nurse in charge of her care and explain her medical and mental health issues. I would explain that I understood that they likely did not have the releases specific to mental health and substance use disorder in the emergency room, but I wanted them to have Alana sign a release to talk with me and my family, and I would give them my phone number and explain that my family wanted to be involved and we needed their help to get her the help she needed. To be honest, I'm not sure that it ever made a difference. Each and every inpatient unit she wound up on, it was like starting from square one. It was like I had never said a thing. Each time my sister stopped drinking and needed inpatient care due to withdrawal, it was because she didn't want to drink anymore. For many people, including Alana, with withdrawal comes a change in mental status. So as soon as she was on a unit, she would insist she was fine or be out of touch with reality. Once she kept calling me, insisting staff was stealing some other guy's clothes on the unit, and I needed to bring him down some clothes. My family and I were told every time the detox unit or medical unit that they couldn't do anything. Once I was yelled at by a doctor who insisted, "Your family needs to do something. You need to have boundaries." I pointed out that both things couldn't be true at the same time, and we were trying to do something. We were asking for their help. At times, if she was in the ICU or medical floor, I asked for a substance use disorder consultation or for her to be transferred to a detox unit, but that did not happen. When she was admitted to a detox unit, I asked repeatedly for an intervention. I explained my family wanted to be involved, that she had untreated PTSD and medical issues that raised the risk of alcohol withdrawal and use. I was told we don't do that. We are just a short-term unit. She has to want it more than you do. I would explain she did want it. She had stopped drinking, gone into withdrawal, and asked me to take her to the emergency room. She was just in so much pain physically and emotionally that she didn't know how to stop. If she didn't want it, why did she keep trying to stop drinking? When I would insist on an intervention, I was told again, you need to have boundaries. I pointed out that wasn't very helpful, since when I did set boundaries by saying you can't discharge her to my home, she needs a higher level of care, they ignored my family and gave my sister a taxi voucher and didn't even tell us she was being discharged. Once I was so insistent that a staff person on the unit finally did agree to do an intervention by phone on the Tuesday after Labor Day. I sat on my couch that Tuesday morning waiting for the call. Instead, Alana walked in the door. She had been discharged, given a taxi voucher. I filed grievances. I contacted a person at the Office of Substance Use Disorders. They put us in touch with a professional to do an intervention. I also started working on this bill. I couldn't stop thinking that if I, an LCSW, a legislator, a member of the Health and Human Services Committee, and a Substance Use Disorder Commission member with all my knowledge and contacts couldn't get help for my sister, what about all the other families? They must be lost. I told Alana about the bill. I told her I would rather she be mad at me for the rest of her life than die. She cried and said, do it. So I am before you today. I did research and wound up contacting Charlotte Wethington. Her son Casey died 20 years ago this summer from a heroin overdose. She worked to pass Casey's law in Kentucky. Charlotte is a wonderfully kind woman whose family had similar experiences to mine. I told her I wanted to pass something like Casey's law here, but I wanted to add some pieces in. We bonded. In the meantime, I was working to arrange an intervention for Alana. The professional that did the intervention for Alana talked with my family. He asked about her. He didn't ask about her drinking. He asked us to tell him who she was. He was the first person to ask, what happened? She had over 15 years of sobriety. What changed? It was a relief that someone was finally listening to us talk about her medical problems, the physical pain she experienced, the PTSD re-experiencing symptoms. He gave us a template for us to write letters to her and explained how the process would go. He even found her a bed at a rehab facility in Florida that had a specialized women's program that could address her medical and mental health needs. On January 4th, we did the intervention. We all cried. Alana agreed to go to rehab. On January 5th, I talked with Alana before I left to go to the State House. She was feeling tired, stomach upset, but she wasn't shaky. She said she would be fine until I got home. I started that day with hope. I came home. Together, we called the admissions coordinator in Florida and got ready to go to the ER. I was helping her with her shoes. I was holding her hands and I said, I love you, Alana. She replied, I love you too, Carl. Those were her last words. She fell away from me in terror, with terror in her eyes, and the withdrawal seizure started. I held her frantically as I dialed 911. I told her to hold on, help was coming. as I held her. The EMTs arrived quickly. They couldn't find a vein to get the medication in to stop the seizures, probably because she was dehydrated. I wept as they tried. They finally gave her a shot intramuscularly. She threw up coffee grounds vomit, which is when blood and stomach acid mix. She went into cardiac arrest. My mother and I watched as they performed CPR on her bedroom floor. She was transported to the emergency room. I sat with her for hours, watching as the catheter they inserted produced no urine, as they tried to stabilize her blood pressure and her blood pH, as they switched out her intubation tube and tried to give her a blood transfusion. They asked if I had medical power of attorney and if she had a living will. I said, "You don't understand. She has a rehab bed waiting for her. This can't be happening." I kept repeating that. Life Flight transported her to EMMC CIU in Bangor. My family rushed there. As I ran down the hall of the hospital in the middle of the night, I still had hope. But not long after we arrived, the medical team there informed us that she had no brainstem function. I had to explain to our elderly mother what exactly that meant, that Alana would never wake up, that she would never breathe on her own, that her organs were failing. There was no hope. We held Alana and said goodbye as they pulled out the breathing tube. She never took another breath. Her heart stopped, and I raged and I wept. I said this shouldn't have happened, that it never should have gotten to this point, that I would change the law. The doctors arrayed around us agreed. The lead doctor said, "You take that rage and do that. We see this too much." This bill does a few things. A family member may request this action for involuntary substance use disorder treatment. They first are provided an intervention. An intervention is a professionally facilitated process and conversation designed to help a person with substance use disorder agree to enter treatment. If that works, no further court action is needed. I would suggest an amendment to this bill that says the Office of Behavioral Health and Substance Use Disorders Office develop a process and list for approved providers to facilitate interventions. They already know some professionals that do that. They connected me with the person who worked with my family. If the process continues, then there is a substance use disorder evaluation that must consider all co-occurring physical and behavioral health conditions. This is really an important part of this bill. I have been working in this field for 34 years. In all that time, we have been talking about treating co-occurring disorders concurrently. It's a standard of care. Sadly, that is not being done today, even in 2022. This bill changes that. I would also suggest an amendment that says the Office of Behavioral Health Treatment Fund grants be used for those with no health coverage. I think the majority of people that this bill would apply to have main care or would be main care eligible, so I don't think this would be much. This bill also addresses another standard of care. For decades, it has been recognized that substance use disorder is a family disease. That means it impacts everyone in the family. It certainly impacted mine. My surviving sister, Jennifer, and I feel that it's time for families to speak up and speak out, not because we are mad at our loved ones. We want to shout out that they deserve better care. We love our family members. Rehab programs involve families. For many years, those of us working in the field and recovery advocates have said the opposite of addiction is connection, and that is true. Substance use disorder is lonely, isolating, and painful for those suffering with it and their loved ones. This bill involves recovery coaches and their families and families of the individual right from the beginning to build the connections that can lead to recovery. I have thought a lot about this. As a society, as a state, we recognize that some medical or mental health conditions impact a person's ability to make decisions. We have a whole process for inpatient and outpatient commitment for people with psychiatric disorders. We have a whole separate kind of process for people who are impaired in other ways due to brain dysfunction. Substance use disorders are considered a behavioral health disorder. They have codes and diagnostic criteria in the DSM-5 and the ICD-10. They're covered by health insurance. Substance use disorder treatment is healthcare. And yet I can't tell you how many times I said in the emergency room with my sister, if I had brought her in here and she had cut her wrist with a knife or held a gun to her head, you would be calling crisis and holding her. We care enough about people with schizophrenia or depression or bipolar disorder to intervene when their life is at risk. We recognize that their brain isn't working properly. Why do we not recognize that in a person with substance use disorder? I think it's stigma. It is a judgment that those who are suffering, as if they were only strong enough to want to stop, they would. There's still a lot of mistaken notions that the person has to want recovery, as if we would ever consider saying that regarding someone with depression. If substance use disorder is a disease, why do we treat it different in this one way? Is it ethical treatment to give a person who is suicidal with depression a taxi voucher and discharge them and say, I guess they haven't hit bottom yet? There are treatment protocols, treatment programs, and medication for substance use disorder. People should have access to it. I know some are concerned about the civil rights of the person with substance use disorder in this bill, and I get that. I built more protections into this bill for the person than currently exists for people with other behavioral health disorders, because I do think that's important. But I would say this: do you know who has no need for civil rights? The dead. My sister Alana doesn't need her civil rights anymore because she's dead. And finally, I want to say there are many paths to recovery, and I don't care how someone gets there. I told Alana that many times. This bill is not for everyone. This process is not for everyone. However someone gets into recovery, I applaud them. I want to jump for joy. But for those who cannot see how they can get there, this bill provides a path that may save their life. I would have used this process to help Alana get there. And I know she would have understood. She would not have been mad because she told me so. She asked me never to give up on her. I promised I would never give up. I didn't give up, and so I am here today. Thank you. Happy to answer any questions.
Thank you, Representative Madigan. We're so sorry for your loss. Committee members, any questions? I am not seeing any. Thank you so much. And we invite bill sponsors to remain on the panel, and you are welcome to remain on the panel.
Thank you.
Next, we are going to hear from Representative Crockett, who wishes to speak in support of this legislation. Representative Crockett?
There for a second, then disappeared. Okay to go?
Yes, thank you. Welcome to the Judiciary Committee, and you can begin your testimony when you're ready.
Thank you. Good morning, Senator Carney, Representative Harnett, and distinguished members of the Judiciary Committee. I am Ed Crockett, and I serve House District 43 in the Maine House of Representatives. I'm here today to testify in favor of LD 2008, an act to establish a court process for involuntary substance use disorder treatment. When the sponsor told me about this bill, I was shocked that there wasn't a law already on the books. Having experienced the traumatic effects of substance use disorder with my father, and I'll share more on that later, I assumed an avenue for loved ones to pursue intervention in the system was in place. Please understand, the substance abuser will not seek help themselves. Certainly not initially, and for some, sadly, never. Once a person reaches the point of addiction, the physical and mental need for that next drink or hit is much stronger than recognizing the need for help. They cannot and will not get there on their own. They need support. And for many, Ultimately, it's an intervention to have a chance at recovery. This law empowers loved ones to initiate the process, and it will save lives. Many of you know, since you've read my memoir, about my father's story. Walter Crockett, my father, was a homeless alcoholic that spent 17 years on the streets of Portland, from the time I was 2 until I was 19 years old, before finally finding sobriety. It got so bad that he was regularly referred to as the biggest drunk in town and received his last rites 5 times while on the streets. There was absolutely no hope for this guy. But then there was. In 1980, while detoxing at Togus for the umpteenth time, he met the substance use counselor who stuck with him and saved his life. For the next 30 years, he abstained from drinking and sponsored and mentored hundreds who suffered from addiction through his work with Alcoholics Anonymous. The guy who everyone thought, including his son, was a total waste of time, became a lifesaver. Recovery takes time, and often there are setbacks. Back in the day, you'd get 30 days of rehabilitation. Then you were sent on your way with little to no support. This bill calls for a year of treatment and makes sure all co-occurring physical and mental health conditions are considered in assessing the risk and need for treatment. That is huge. Drugs and alcohol, we all know, are beasts. This disease doesn't want to let go. It takes time and a team effort to beat it. 1 year of consistent oversight will make all the difference in the world. If this had been in place during my father's time, when 30 days rehab was the norm, I believe recovery would have happened much sooner for him. You know, the stakes are so much higher for people struggling with substance use today. In the 1960s and 1970s, when my dad was there, it was alcohol almost exclusively. Alcohol is a slow death, and there's a great chance you can recover and live a very productive life. Fast forward to 2020, and we have the opioid crisis. Horrifically, one bad batch mixed with fentanyl, and it's all over. We don't have the time to wait it out any longer. We really need this law yesterday. Without it, more and more loved ones will die. We can save many by passing LD 2008. Thank you for your time, and I'm happy to answer any questions.
Thank you, Representative Crockett. Committee members, any questions for Representative Crockett? Not seeing any. Again, we appreciate you providing testimony today.
Thank you, Senator.
And next, Representative Madigan, is Jennifer Bott your sister?
Yes.
Would you like her next?
Yes, please.
Okay, thanks. And Jennifer, you'll have a weird sensation of going through cyberspace before you're on the panel. Good morning, Jennifer. Welcome to the Judiciary Committee. We appreciate you being here today, and you can begin whenever you're ready.
Okay, thank you. Good morning, Senator Carney, Representative Hartnett, and members of the Judiciary Committee. My name is Jennifer Bott, and I live in Ship Bottom, New Jersey. I am here today to testify in favor of LD 2008, an act to establish a court process for involuntary substance use disorder treatment. The sponsor of the bill, Representative Colleen Madigan, is my sister. Alana Madigan, for whom Alana's Law is named, was also my sister. I support this bill because it will help prevent what happened to our family from happening to another family. Alana battled substance use disorder for many years. She was successfully sober for over 15 years and unfortunately relapsed after several medical and personal issues over the past 2 years. My sister needed the medical, psychological, and behavioral assistance that this bill will provide. Alana had multiple emergency room and ICU admissions over the past few years, and the system wasn't equipped to provide her with the assistance she needed. Alana needed an intervention. She needed help from the doctors, social workers, and hospital staff, those who would repeatedly treat, stabilize, and release her back home. I spoke with Alana multiple times while she was in the hospital, either in the ICU or the detox floor. She knew she needed help, and she wanted that help, but her illness always went out because there are holes in the system, holes which provide an individual with the opportunity to relapse and continue their destructive cycle of addiction. Alana, like most addicts, always knew what to say to her providers, and she would promise to follow up only to be back in the same place 4 to 6 weeks later. Alana not only had a substance use disorder, but she also suffered from PTSD and multiple medical issues. I often wonder if anyone ever looked at her complete medical history. Did anyone look at the whole patient and not just the alcoholic who was unable to control her demons? We, her family, tried so many times to have the hospital staff set up family meetings and intervention, or just to give a better background of Alana's history. Alana needed help, and she wanted help. She just didn't know how to ask for that help, and she felt ashamed for needing that help. People who battle substance use disorders often feel guilt or shame for their disorder, even when they have the love and support of their families. Alana needed a standardized protocol, a system to help battle her illness. Alana never received the help she needed within the current medical system. After months of binge drinking and attempting to self-detox, Alana's body gave up. On January 6th of 2022, my sister's illness won, and Alana died. The system let our family down, not because it's a broken system, but because it's an incomplete system. Alana wasn't perfect. Like all of us, she obviously had her issues. This bill, Alana's Law, isn't perfect either, but it's a start. It's a first step. This bill will help others suffering from substance use disorder. And I truly believe that this bill would have helped my sister. Please consider the benefits of Alana's Law and vote in favor of this important and much needed legislation so that Alana might help others, even if she couldn't help herself. Thank you.
Thank you very much, Jennifer. Committee members, are there any questions for Jennifer? I am not seeing any. Okay, Jennifer, thank you for being here today, and I'm going to send you back to the attendee part of the meeting.
Thank you.
And next we'll hear from Amy Halstead. and then Ronald Springle. Good morning, Amy Halstead. Welcome to the Judiciary Committee. You may begin your testimony when you're ready.
Good morning, Senator Carney, Representative Harnett, and honorable members of the Judiciary Committee. My name is Amy Halstead, and I'm a resident of Freeport, Maine, and I'm here to testify in support of LD 2008. I'm here today in honor of my younger sister, Laura. Laura was so many things. She was generous and funny and compassionate and brave, so brave. There was so much about her that I admired. About 7 years ago, we learned that Laura was drinking too much. She was ashamed, and it took her a while to admit to us how bad it had gotten. We pleaded with her to go to rehab. And after many months of begging her to get the help that we knew she needed, she was admitted to inpatient rehab in 2017. She was there for many, many months. Her head started to clear from the fog of alcoholism, and she started treatment for anxiety and depression, and she finally got a good therapist. She took up painting and meditation, and she told me that she finally felt alive again. When she was released, she felt so hopeful, and we all did. She was sober for over 18 months. But then, in a span of just a few months, her 15-year marriage fell apart. And then the pandemic hit. And she couldn't spend her free time with friends. AA meetings on Zoom just weren't the same. And she was alone most of every day. Her depression and her anxiety got worse. And we soon found out she was drinking again, even though she couldn't bring herself to talk to us about it. She was admitted to the hospital multiple times after trying to detox at home alone. From the many hospital visits, we learned that her liver was failing. The doctors were clear that if she couldn't stay sober, she would die. My family was panicked. We begged her to consider rehab again. But the alcohol just didn't allow her brain to understand how serious her situation was. We tried to arrange interventions with her therapist and rehab specialists, but they kept telling us, you can't make her want to get better. She has to want it herself. But the thing is, I know Laura wanted to get better. Every time she tried to detox at home, ashamed to tell us that she had relapsed again, that was her wanting to get better. I just remember feeling like alcoholism was this monster who was dragging my baby sister away from us. And when we asked for professionals to help us help her, they just kept telling us that she had to decide that she wanted to escape. But the disease's grip was too tight. She could not break free. My parents and I just didn't know what to do, or what our options even were if she would not go to rehab. And we soon learned that there just weren't any options. Laura died on September 6th, 2020, from complications from alcohol withdrawal and a failing liver. Her birthday was yesterday. She would have been 41. I couldn't hear her voice or wish her a happy birthday, so instead, I took the day off from work and I wrote this testimony. Families should not have to navigate a system that tells them that the only option is a sick person deciding that they must have what it takes to cure themselves. I know that the reforms in this bill would have given Laura the fighting chance that she deserves. Please support it. Thank you.
Thank you, Amy. Committee members, any questions? I'm not seeing any. We really appreciate you being here today and providing your testimony. And next, committee members, we will hear from Ronald Springle.
There we go.
Dr. Springle, welcome to the Judiciary Committee. It is nice to see you. I think you and I have corresponded, but I'm not sure we've ever met in person. We appreciate you being here, and you can begin your testimony when you're ready.
Thank you, Senator Carney. Yes, that would be correct. I am a constituent. Representative Tom Harnett and Senator Carney and distinguished members of the Joint Committee of the Judiciary, thank you for the opportunity to testify in favor of LD 2008. My name is Dr. Ronald Springle, retired addiction medicine physician and a resident of Scarborough. Some of you may know me through my work with recovery housing, but I am offering this testimony today as an individual, a recovery advocate, and a person in long-term recovery from opioid use disorder, and not on behalf of any organization. I also now serve as a gubernatorial appointee to the Overdose Review Panel, and that experience has informed my views on this bill. Several years ago, I began working with former Kentucky Governor Dr. Ernie Fletcher. Like me, he is a retired physician who now works in the field of recovery supports and programs. Through my work with him, I learned of what Charlotte Wethington did in Kentucky and how she enacted Casey's Law in memory of her son, Matthew Casey Wethington. Dr. Fletcher was governor when Casey's Law was enacted in 2004. Last month, I asked him about the law, and he had only positive comments to say about it 18 years later. Apparent fears of people falling victim to manipulative family members were unfounded. I first met Representative Madigan several months ago and learned of her sister, who suffered immeasurably from substance use disorder, alcoholism. Colleen detailed the struggles that she had, even as a licensed clinician, and I cannot add to her poignant story there, so I will not. I understand the recovery community has objections to this bill amid fears of increased stigmatization and other unintended consequences. I share these concerns. A few years ago, I would not have supported this legislation. However, a lot has changed since then. Overdose deaths have skyrocketed, and there is no end in sight. I can sum up in one word why I now support this legislation I once regarded as drastic. That word is fentanyl. The ubiquitous nature of this powerful opioid now being mixed with psychostimulants, benzodiazepines, and other illicit substances has altered all of our previously held assumptions. Harm reduction is now more like sitting on death row. We must recognize this is a time for drastic measures in response to a horrible continuing epidemic. At the very least, I urge the committee to further the intent of this bill by either adopting it outright or by establishing a working group to study the proposal and recommend how this bill can become law. We need LD 2008 and the treatment beds and funding it will require to make it work. Lives can and will be saved. Thank you very much for the time to offer this testimony. I urge ought to pass.
Thank you, Dr. Springle. Committee members, any questions? Not seeing any. Again, we appreciate your testimony today. And finally, committee members will hear from our colleague, Representative Collings. And I would ask those in the attendee part of the meeting who wish to speak in opposition to the legislation to raise your hands and just simply leave them raised. till we get to that part of the public hearing. Representative Collins, welcome back to the Judiciary Committee.
Good morning. Thank you, Senator Carney, Representative Arnett, distinguished members of the Judiciary Committee. I'm Representative Benjamin Collins, representing District 42 in Portland. It's still morning. I'll say good morning, and I promise I'll be done speaking before it's good afternoon. As a co-sponsor of this bill, I am honored to speak to you briefly, recommending full support of the committee on this. This is a bill that's evidence-based. If you look at some data and some information about where they've tried this, it does show that this method with checks and balances is more effective than the voluntary sort of system we currently have in Maine, and that when you have more of involvement to the manner outlined in this bill, the outcome is greater, and that's what we're all striving for to do. We are trying to prevent people from not getting the treatment and help they need and end up being very sick or unfortunately passing away. This is a crisis, and when we have a crisis, we need to come up with new ways to address it. And I believe if this was just a proposal that didn't have any checks and balances, if there wasn't a very methodical process of going about having this, a person getting the help, I wouldn't be for it. But since those steps are in place in this bill, I strongly urge you to support it. If some language needs to be tweaked to make it, work in accordance with how you think is best, I'm all for it. But I think overall, what is outlined in this bill is reasonable. It's evidence-based, and I believe that the proof shows that this way of doing it is a better way to do it and can save lives. And I think that's what we all want to do. So thank you for allowing me to speak. And once again, to reiterate, I hope this committee will unanimously support this proposal. Thank you very much.
Thank you, Representative Collins. Committee members, are there any questions? I am not seeing any. Once again, thank you for your testimony. Committee members, we've heard from everybody who is a proponent of this legislation. Now we're going to hear from those who wish to speak in opposition to the legislation. I'm going to bring over people with hands raised a couple at a time. First, we'll hear from Courtney Allen, Justin Andrus, and Catherine Buston. They're joining the panel. And Courtney Allen, if you've joined the panel, could you please activate your video? Thank you, Courtney. Whoops. That sound was the 3-minute timer. It's a reminder that we ask those testifying to please maintain a 3-minute time frame. And Courtney Allen, you may begin your testimony when you're ready.
Thank you, Representative Harnett, Senator Carney, and members of the Judiciary Committee. I just wanted to begin by sending my condolences to Representative Madigan, her family, and the Mainers across the state who are grieving the loss of all of their folks. As somebody who has also lost 3 of my closest family members to mental health and overdose crises over the course of the summer of 2021, I recognize that the pain and the grief of what we're all going through together collectively. My name is Courtney Allen. I'm the policy director of the Maine Recovery Advocacy Project. a grassroots network of Mainers working on community and public policy-based solutions to the addiction crisis. We are a listening first organization. Everything we do and advocate for comes from the grassroots up. Our primary mission is to help lift the voices of people impacted by addiction to places of power. And it is with those values I come to your committee in opposition of LD 2008. Setting aside our moral convictions against involuntary treatment and using the criminal justice system as a means for treating substance use disorder, we have some very practical concerns with this bill. First being the timing. Our network was made aware of this bill and received the final language last week. This is just simply not enough time left in the legislative session to have a conversation of this magnitude with all of the stakeholders. Even as of this morning, the final language of the bill is not available on the legislative website. If our network was not deeply involved in organizing under the dome, we would not have known that this conversation was even happening today. We know that there are many who do not know and therefore have not been able to provide their input. Second, the recovery community is very clearly split on this issue. The committee will notice that today people testifying in front of your community who are members of the recovery community, including family members, people in recovery, people who use drugs, harm reduction workers, and treatment providers, among others, are very split on the issue. It's important to understand that this is not often the case within our community, and that this tells us that this is a very sensitive topic that deserves a much bigger conversation within our community. We do not want to be pitted against each other in the recovery community. It is contrary to everything that we stand for. And we are asking your committee to give our community time to work out our differences. Thirdly, there's a lack of treatment providers, treatment and lawyers. If this bill were to be passed today as written, there simply would not be enough detox or treatment beds available to put anyone in. There are also not enough lawyers or treatment workers on the front lines to give people treatment or to defend their clients. Every day we fight on the front lines to find and place people who want treatment, let alone trying to find beds for people who do not want it. People who have substance use disorder can and do seek treatment on a regular basis. They can and do recover. The problem is not that they don't want access, it's that they don't have access. And then finally, this bill is not evidence-based. Evidence does not support improved outcomes related to compulsory treatment approaches, with some studies even suggesting potential harms. Furthermore, involuntary interventions for substance use disorder are less effective and more harmful than voluntary treatment, and involuntary treatment centers often serve as venues for abuse for this community. I've included those citations in my written testimony if you want to read the research papers. And therefore, given the potential for human rights abuses within these treatment settings, non-compulsory treatment modalities should be prioritized by lawmakers seeking to reduce drug-related harms. On the front lines, there are many things that lawmakers could help advocate for, including increased funding for detoxification programs, harm reduction, recovery community centers, and inpatient rehabilitation. We also need help passing LD 1862, the expansion of the Good Samaritan law to encourage people to call 911 during overdoses. We need help nominating qualified members to serve on the Recovery Council and oversee the opiate settlement monies. And we need that money to begin flowing to the ground. There are so many things we do.
Allen, could you wrap up in a sentence or two, please?
Yeah, there's so many things that we do agree on, and I look forward to working with your committee. I'm happy to answer any questions.
Thank you. And it looked like you were reading from written testimony. If you could be sure to provide that, file it online, that would be helpful to us.
I absolutely will, Senator.
Thank you. Committee members, any questions for Courtney Allen? Well, thank you very much for being here today and providing your testimony.
Thank you.
Next, we'll hear from Justin Andrus.
Good morning, Senator.
Good morning, afternoon.
Afternoon.
You may go ahead when you're ready.
Good afternoon, committee members. I know you all know me, but for those who don't, I'm Justin Andrus. I am the Executive Director at the Maine Commission on Indigent Legal Services. It was difficult for us to assess how to respond to this bill because we absolutely support access to every person in Maine to appropriate and adequate substance abuse treatment and support. Many of our cases, perhaps most of our cases, involve issues of substance abuse. And from a public defense perspective, addressing substance abuse issues needs to be a cornerstone of our policy. However, we have concerns about the way this bill would be implemented. And we have those concerns notwithstanding some of our specific individual experiences in this matter. And I want to tell the committee, and I want to tell the bill's proponents, that we have also history here of family member lost to opiate, including myself within the last couple of weeks with family. We understand the significance, but the bill as drafted is really problematic for a number of reasons. First, the availability of counsel needs to come at the earliest part of the process. The ability of the court to enter ex parte orders on a good cause basis, and for those orders ultimately to result in the possibility of arrest for contempt and incarceration, is extraordinarily problematic from a due process perspective. We'd like to see amendments to address that if the bill is going to go forward. In addition, with respect to assignment of counsel, we support assignment of counsel at the outset in every case. It shouldn't be conditional. And that counsel should be involved from the first hearing. An ex parte proceeding should be available only if service is not practicable, and the standard at an ex parte proceeding should be enhanced to at least a clear and convincing standard. No one should be arrested and subject to incarceration unless there's a warrant and probable cause. With respect to the issue of treatment itself, echoing what you just heard, we have concerns about the availability of facilities. We also have concerns that the bill doesn't require payment. If MCLS is to pay for that, we'll need an appropriation. We don't know what the numbers look like, but we would need an appropriation to deal with that. If some other entity is to pay for the treatment, we need to know who that is. That needs to be included in the bill. To take an addict and subject them to arrest for contempt because they can't afford to attend treatment that isn't available anyway is very problematic to us from a due process perspective. So I would like to work with the bill's proponents to resolve those issues. We don't necessarily want to avoid the implementation of a program that can support people. And so I'll be available to that, and Representative Madigan, I'll be available to that directly. We can talk about it. And hopefully we can alleviate some of those concerns and reach a point where we can support the bill, because we do support the goal of addressing the substance abuse issues here. So it's the briefest I've ever been with the committee, but I'm happy to answer any questions anyone may have for me.
Thank you. Committee members, any questions for Justin Andrus? Not seeing any. We appreciate your testimony today and your offer to help.
Thank you.
Okay, and next we will hear from Catherine Buston, who is on the panel. Catherine, welcome to the Joint Standing Committee on the Judiciary. You can begin when you're ready.
Thank you, Senator Carney, Representative Harnett, members of the committee. My name is Kathy Buston. I'm a resident of Hollowell. And I speak to you today, even though I have 30 or 40 years having professional roles in the system. I speak to you today as a private citizen, a person with extensive experience personally with involuntary, I won't call it treatment, involuntary experience. I also would like to never deny the pain, the agony, the helplessness of family member, friends, and other people who love people who are very much struggling with life and death issues, whether they be mental health, medical, whatever sort of emotional distress. Would never deny that horrible feeling of helplessness, nor would I deny the horrible lack of a system that adequately addresses the true issues of those struggles. Specifically, what I'm speaking of is the realities of some of what we heard today. We did not hear today about loved ones and people who did not have access to treatment. We heard of multiple hospitalizations, multiple presentations with substance abuse counselors and systems, multiple attempts at detox and treatment. We heard of system failures. We heard of a one model approach. And now the proposal is to commit people to those same systems. We often in the state talk about beds and locations where people are. We seldom have the courage and the commitment to look at what's happening to the people in the beds. That's where we need to focus. I concur with Ms. Allen to ask for more time to use this bill as a vehicle to have a comprehensive, extensive dialogue with all parties, offering their experience. We have centuries now of studies and what we know about what does not work about forced treatment. For example, a brief example, we are ignoring what happens when you're involuntarily committed, not participating in treatment because you are involuntary. What do those interventions look like? We're talking about people with histories of sexual abuse, being restrained in 5-point restraint, adding layers of trauma. We're talking about involuntary, brutal treatment. We need to get realistic, and I make a pitch that we offer and propose a larger office of trauma services to get to some of the bases of where these emotional distress issues come from. We can incarcerate care. Thank you for considering my testimony.
Thank you very much, Kathy Buston, for your testimony today. Committee members, any questions? Not seeing any. Once again, thank you very much. Next, we'll hear from Leslie Clark. And Leslie, if you could activate your video, and thank you for joining us.
Thank you. Good morning, Senator Carney, or afternoon, Representative Harnett, and honorable members of the Joint Standing Committee on the Judiciary. My name is Leslie Clark, and I'm speaking as the Executive Director of Portland Recovery Community Center, Maine's Recovery Hub, and as a person in long-term recovery. I'm testifying today in opposition of LD 2008 as it is currently written. However, to be clear, Portland Recovery Community Center supports the intent of LD 2008, which is to provide family members and loved ones of those with substance use disorder the ability to seek court-mandated assessment and treatment. There are problems with this bill as it is currently proposed, and we cannot support it without resolving those concerns, which I've laid out in written testimony. We're grateful to Representative Madigan for bringing forward this legislation in the wake of her personal loss and in response to the overwhelming loss of lives to substance use disorder every week in Maine. These are unprecedented times. Families are watching their loved ones succumb to drugs that destroy their lives and are exceptionally lethal, unlike anything our society has ever experienced before. Families need to be able to access treatment, assessment, and urgent care for their loved ones. It's our belief that treatment for SUD can and will continue to aid in saving lives, and there is a growing body of evidence that does support the efficacy of mandated treatment. Last week at PRCC, we had a gathering for Black Balloon Day. One of the mothers who attended, Sue, lost her son, Kevin, to an overdose of fentanyl. As Kevin lay on the street, on Congress Street for 2 hours, there were cameras there that captured the scene. He lay there dying with his dog by his side. People walked by, they stepped around him, they looked at him with judgment. Nobody stopped to give him Narcan, which he carried on him. They just walked right by, and for 2 hours, nobody called 911. Kevin's mother had desperately tried to get help for him. Some days he was willing, and some days he was not, despaired of hope, despite her countless efforts to access help for him. As a family member, she could not. I grew up in the age of recovery, believing and being told that people need to be ready and willing. They need to hit bottom. Even today, people are being screened out of treatment based on the ability to prove their motivation and willingness to change. Meanwhile, hundreds of families stand by helplessly and watch their loved ones die of a treatable disease, a disease that by very definition impairs our judgment. There's no other health condition where you have to prove you're willing to do the rehab that's required from the illness that you have in order to get treatment of an acute episode. No other healthcare is rationed based on who can prove their worthiness for receiving care. Although we cannot support 2008 as it is written today, we will support legislation that addresses the concerns and provides a sound pathway for additional access to intervention and treatment. I thank you for this opportunity to testify and hope that a work group will continue to work with stakeholders to work through the issues on this bill. Thank you.
Thank you, Leslie Clark, for your testimony today. Committee members, any questions? I am not seeing any. We appreciate you being with us today. Next, we'll hear from Megan Sway. And then I just want to let those in the attendee space know that you'll be being moved over gradually onto the panel. Megan Sway, welcome to the Judiciary Committee. You can begin your testimony when you're ready.
Thank you, Senator Carney, Representative Harnett, and distinguished members of the Judiciary Committee. My name is Megan Sway, and I'm the Policy Director for the ACLU of Maine. On behalf of our members here today, I'm here because we share the sponsor's goal of increasing access to treatment and increasing the many pathways, but we oppose the method that this bill takes. In my testimony that I submitted online, there's a list of specific issues with the bill that that I hope the committee will take up if it decides to move forward with the bill. A couple of things that have come up to me through testimony is one, whether more use of advanced directives could be used for folks with substance use disorder, especially as you go through different stages of your disorder and of acknowledgement of the problems you're facing, that perhaps advanced directives would be one way to address people changing their minds when they're in different states of mind about whether or not they are open to receiving treatment. Another thing is that the involuntary hospitalization laws already cover people with substance use disorder. So when we're talking about how dangerous fentanyl is, for example, we already have laws to address that and don't need another law to do that. The involuntary hospitalization laws already apply. Third, there are real efficacy issues, and I think the Department of Health and Human Services weighed in and cited various studies about involuntary treatment and how it's not found to be particularly effective as compared to people who enter voluntarily. And then finally, there are just the constitutional issues from the ACLU's perspective, and this is painful. No one wants to see their family members in pain or unable to help them, but the Constitution is there even when we're in pain. And so I just want to bring up for you all that the right to refuse medical treatment is a constitutional issue. There are constitutional dimensions, and there's a test to go through about when the government can force you to have medical interventions against your desires. Those are really real, and I don't think that as written, the bill takes those into account enough. There's also the issue the ACLU has opposed for over 55 years, criminalizing people who use drugs. And while I want to be really clear that this bill doesn't do that, it does allow people to be jailed if they don't undergo an examination or an intervention. And so, this is putting people in the position of being in jail when they're in contempt of court for not following court orders. And our jails are overloaded, they are full, and we should not use jails for people who are struggling with substance use disorder. Thank you.
Thank you, Megan Sway. Committee members, any questions for Megan Sway? Not seeing any. We appreciate you providing testimony this afternoon. And let's see, next we'll hear from Simone. And Simone, welcome. I didn't catch your last name. You can proceed when you're ready.
Thank you, Senator Carney. Good afternoon. I will change from morning. Good afternoon, Senator Carney, Representative Harnett, and honorable members of the Joint Standing Committee on Judiciary. My name is Simone Mallon. I'm a resident of Winthrop, and I am the Executive Director of the Consumer Counsel System of Maine. We're here today in opposition to this bill, not for any lack of mad respect for Representative Madigan's loss and struggle. It is real. I'm a person that lives, we don't normally weigh in on substance use disorder strict bills because we're in a mental health organization. I'm a person that has lived experience in both mental health, and I've been a person in long-term recovery, and I've been sober for over almost 28 years. So this struggle is real for all of us. With countless family members, and yeah, just got to say that out loud. The reason we're weighing in on this bill is one, the co-occurrence of mental health and substance use disorders is just really high. There's a conservative guess of 50%, but my social work experience and lived experience says it's closer to 85, 90 or higher. So our community is disproportionate. The mental health community has a high incidence of both. The other is that involuntary treatment is something we know. And our goal is not to increase that pool of people who are being forced treated. Why? Because we know the real trauma and pain that forced treatment can cause, and the lack of real evidence that forced treatment helps anyone, other than layering trauma upon trauma upon trauma. So we understand this pain, and we want to support the community in getting this treatment that they need. As you know, or you may not know, there's not even enough beds for those that want treatment. So adding people who don't want treatment, my recommendation, let's fix the system, and let's talk about fixing the system that makes sure there are beds for everybody whenever they're ready, and not by forcing people into treatment. None of us like to be forced into anything. And our current laws already support SUD involuntary commitment if in fact that is absolutely needed. So I thank you for your time and your attention to this bill.
Thank you very much. Committee members, any questions? I'm not seeing any. Once again, we appreciate you providing testimony today. Next, we'll hear from Candy Cleaves.
Good afternoon, Representative Harnett and honorable members of the Joint Standing Committee on Judiciary. My name is Candy Cleaves, and I'm a resident of Garland, and I'm in opposition to LD 2008. Substance abuse issues have been around me most of my life and have left myself and my family devastated many times with traumas and loss of life. When I was only 18 years old, the man that I was engaged to was court-ordered into a treatment program for drugs and alcohol. John had completed his detox, was attending his meetings daily, and following all of the rules. During what at the time was referred to as a dry drunk, he chased me through the house, and when he had me on the floor sobbing, scissors in his hand, threatening to cut my hair he was gripping a hold of, he kicked me in the stomach. I was 6 months pregnant. Thankfully, our baby was okay. However, the court-ordered treatment wasn't enough to guarantee that he would be. Our child is an adult, and that baby I was carrying, or that baby is an adult and has a child who is 19 years old right now. It was 17 years ago that John actually, by choice and not court order, actually chose to get help. And that was after he had crossed the line that was too much for him. Dan, who I was later married to for 11 years, attempted many times to get help. But although it had already been known for years that a dual diagnosis of mental health and substance abuse needed to be treated simultaneously, that type of treatment was denied to him. And as you heard Representative Madigan mentioned earlier, it's still not being done in the state. He eventually died an early death. And actually, he died in my home, house sitting for me, not even 2 feet from where I'm sitting right now. I understand being desperate to get help for our loved ones. And my heart goes out to Colleen and her sister and to everybody else that has lost people. We cannot legislate laws based on emotion. It's not right. Now, I was never more desperate than when it was my daughter who was needing the help. But is help what this bill will accomplish? No. We cannot force people to get help. We can only give them opportunities to do so. And this bill does not create opportunities. Instead, it builds barriers, denies rights, and ultimately will destroy the trust, not only in others, their family members who they've actually confided in at that point, or their friends, all can turn against them with that knowledge, but also in our country. I struggle to understand how any elected official who has sworn an oath to uphold our Constitution can put forward or support this bill. It is filled with more rights violations than can be discussed in 3 minutes. So instead, I'll share some of the damage this bill will bring. By violating the rights to keep private a person's substance and mental health records, you will keep many people from telling their providers the truth and from seeking help. By demanding their appearance before court and providers, you risk their ability to get or keep jobs, not only the time it takes away for them to have to appear, but also for the arrest record when they don't appear on the court. You also will be affected.
Candy, I just wanted to let you know that your time is up, and if you could wrap up in a sentence or two, please.
You're also affecting people's right to own a gun, and not being able to own a gun, you're going to eliminate a person's ability to be in the military. If they are already serving, they will lose their right. And I am married to a disabled veteran.
Thank you very much.
You have submitted testimony
in writing. Thank you. Thank you for your testimony today, Candy. Committee members, any questions? I am not seeing any. We appreciate you being here today.
Thank you.
Next, we'll hear from Dan Moran.
Good afternoon, Senator Carney, Representative Harnett, members of the committee. My name is Dan Moran. I'm the Director of Government Affairs and Communications for the Maine Medical Association. On behalf of the Maine Medical Association, the state's largest professional physician organization representing more than 4,000 current and future physicians, our testimony is neither for nor against LD 2008. Representative Madigan, you've always been great to work with. I was very sorry to hear about your loss, and I greatly respect you for your efforts at the Capitol. So thank you for trying to make a difference every day. Our key points in our testimony are listed in bullets. There is little evidence that involuntary civil commitment laws are effective. Coercive treatment action conflicts with the harm reduction philosophy. Maine's existing capacity to provide people with needed care is already limited. And there's a cost component to this bill. In most states, the costs generally fall on patients and their families. 38 states, from what we found, and the District of Columbia allow opioid involuntary commitment of an adult without a conviction. The legislature should seek out outcomes-oriented studies from those states and carefully examine them before implementing civil commitment in Maine. It may achieve the immediate goal of preventing an overdose or related danger, but clear results that it leads to sustained recognition of treatment and long-term success is unknown. It's also harm reduction is the standard of care that our substance use physicians that I spoke to related to this bill, and they were quick to point out that this is in direct conflict with the harm reduction philosophy. It deviates from the structural interventions based on harm reduction goals and the public health model of substance use disorder treatment. I have a link to the theory of harm reduction from the Substance Abuse and Mental Health Services Administration, and it indicates harm reduction approaches have been proven to prevent death, injury, disease, overdose, and prevent substance use, misuse, or disorder. You've already heard about the existing capacity to provide people with needed care. It's very limited. It's well known the most effective treatments for opioid use disorder are the 3 prescription medications approved by the FDA: methadone, buprenorphine, and naltrexone. Only certain facilities and licensed clinicians are legally able to offer all 3 medications. I know there's been discussion about alcohol abuse disorder here, and we've certainly heard that there needs to be more attention focused on that and not just have a single laser-like focus on opioid use disorder. As far as the costs, when you read this bill, there are court and attorneys' fees, evaluation fees to physicians and other clinicians, assessments, eventual outpatient treatment of persons with substance use disorder, and potential inpatient substance use disorder treatment. There's no way outlined in the bill on how that's going to be paid. Will it fall on families and loved ones and guardians? Will it fall on Medicaid? Will it fall on the private health plans? And that directly goes into our last section of testimony, which is health equity. Prior to this session, the MMA determined that public health disparities concerning underrepresented and minoritized populations would be considered a core foundational priority. This bill fell into that when we were discussing it. The goal is that all residents have necessary and equal access to appropriate and comprehensive health care, be it substance abuse disorder or others. Opioid use and opioid-related overdoses are continuing to rise among racial and ethnic minorities. And we also have to look at the people who don't have the social support systems or the finances to participate in a process like this. So we're unable to support LD 2008, and based on our feedback, it may have been actually opposition, but the bill introduction and the hearing notice fell in between our legislative committee meetings, which is taking place tonight. So I bet we'll further discuss this tonight, but we didn't hear a lot of support, heard a lot of concerns. And for today, it's neither for nor against. Thank you for reviewing our comments.
Many thanks for your testimony and your comments, Dan Moran. Committee members, any questions? Representative Babbage?
There we go. Thank you, Madam Chair. Mr. Moran, one of the things that's troubling, of course, is perhaps the reluctance to recommend treatment due to available beds or due to cost or any of that. I think the constitutional issues that have been brought before us are real. What I want to ask you, we heard Dr. Springle, I believe his name was, from talk about opioid addiction and how to him the calculus has changed due to fentanyl as far as risk and whether action is necessary. Do you think that's true?
Not from the members that I heard from the substance use experts, the active substance use member experts that I reached out to on this bill. They are aware, obviously, that the standards and the treatment methods are changing because of fentanyl and its increased deadly nature of that. But they haven't deviated from the harm reduction philosophy and the avoidance of coercive treatment methods.
Thank you very much. Thank you, Madam Chair.
You're welcome. Committee members, any additional questions? Not seeing any. Dan Moran, thank you for your testimony today. Committee members, next we'll hear from Andrea Mancuso.
Good afternoon, Senator Carney, Representative Harnett, distinguished members of the committee. My name is Andrea Mancuso. I'm here today on behalf of the Maine Coalition to End Domestic Violence to raise several concerns with respect to the proposed process outlined in the bill. There's not a community that has escaped the lethal impact of substance use, and we really do appreciate that the bill is presented in that context. However, considering the implications of the bill with our perspective from the experiences of domestic abuse survivors, we're concerned about how those who engage in abuse and violence would seek to exploit these good intentions to do harm. Abusive partners frequently try to portray those they victimize as mentally ill or substance dependent as a way of evading accountability for their own behavior. Our resource center advocates often help survivors whose partners have coerced them into using illegal drugs and who have used that dependency as a means of controlling the survivors, which really does create complex and devastating barriers to accessing help. And as drafted, the process outlined provides pathways to substantial harm by empowering an abusive partner as a legally authorized person with little to no protections against intentional misuse. As proposed, an authorized person could be an estranged spouse or partner to file this petition and launch this involuntary process. We have significant concerns also about the compulsory intervention meeting and evaluations happening prior to an opportunity for the court to hear from the respondent. Upon separating from an abusive person, many survivors will refuse to respond to their partner's communications or refuse to engage with that person in the way that is demanded. And under this proposal, the abusive partner could then file a petition to initiate this process, alleging the survivor has substance use issues and is in need of treatment. And the court, in setting a hearing, would then require the respondent to engage in an intervention meeting with this abusive person before the survivor is able and entitled to be heard by the court. The very fact that a survivor has been court ordered to submit to an evaluation, and this prior to thoughtful judicial review and an opportunity to be heard, could be and would be exploited by an abusive person to impact their employment, to undermine their credibility with family and friends and other community supports, to gain tactical advantages in family court proceedings, and ultimately to try and coerce the respondent to submitting to their demands in exchange for dropping the petition. We see a number of questions that would need to be answered around how these evaluations would be accomplished. The potential financial impact is particularly relevant for survivors who have experienced significant economic abuse and who might be struggling to establish their financial independence. And for survivors, the ability to have agency over what information is shared about them and with whom it is shared is often of critical importance in planning for their safety. We have several questions about how access to information would be handled in this process. I'm happy to answer any questions. We do share Director Andrus's perspective on the importance of automatic appointment of counsel, and underscore others' perspectives about the limited substance use treatment resources that currently exist in the community. Thank you.
Many thanks. Committee members, any questions for Andrea Mancuso? I'm not seeing any. We appreciate your testimony this afternoon. And finally, we'll hear from Mallory Shaughnessy. Welcome.
Thank you, Senator Carney, Representative Harnett, esteemed.
I think we lost her somehow. Hang on a second.
The broadband, and even in District 28, can be a problem down here in Westbrook.
I think that was my error in trying to manage the attendee part of the meeting. So we can blame it on the lack of broadband if we want.
Hi, I think I'm back. Am I back?
You are, and my apologies. I was trying to move somebody into the attendee space and I inadvertently sent you back there. Welcome to the Judiciary Committee again. You may begin when you're ready.
Okay, thank you, Senator Carney, Representative Harnett, and esteemed members of the Joint Standing Committee on Judiciary. My name is Mallory Shaughnessy, and I'm a resident of Westbrook and a constituent of Senator Sanborn. And we do have fairly good broadband here. I'm also the Executive Director of the Alliance for Addiction and Mental Health Services. On behalf of the 35 members of the Alliance, I'm here today to speak neither for nor against LD 2008. In our discussion of this bill, we reached the conclusion that this is just an issue far too large to address in the waning days of this legislative session. We want to offer our condolences to Representative Madigan and heartfelt thanks to her for all of her work and advocacy and work with us in advocacy for those with substance use and mental health challenges. She contributes a vast amount. We also acknowledge the timely importance of the intent to save lives, especially given the 11 to 12 people Maine is losing weekly to the opioid overdose, to opioid overdoses, and the 8 to 9 that die weekly from the impacts of alcohol use disorder every week in Maine. We don't hear so much about these latter ones as in the news, as they're not as sudden and dramatic as an overdose, but are due to lack of treatment and years of untreated alcohol use disorder. We lose more than 1,000 Mainers annually to substance use disorder of all kinds. However, we are concerned that there's simply not enough time to review and discuss the research and impacts regarding short-term involuntary substance use disorder in the few weeks remaining in this session. There are many studies that have been conducted. There are outcomes from other places where it's been implemented or piloted. This committee needs time to review. I've linked to a couple of them. There are many, many more. There's also constitutional challenges to Casey's law in Kentucky, which this legislation is modeled on, that are currently working their way through the courts still. So any legislation we should consider should be thoroughly reviewed for constitutional issues prior to implementation or passage. We would urge that this bill be amended to become a vehicle to gather stakeholders with diverse perspectives and expertise with some staff support to review and discuss the research and constitutional issues and report back to the 131st legislature with recommendations. We would also highlight that at the present time in Maine, we do not have enough treatment beds nor access to outpatient care for those who are voluntarily seeking substance use disorder treatment. To mandate treatment without a full continuum of care to access seems to be unworkable. We need to fill the holes in our system of care. One of the only two agencies offering access to medically monitored withdrawal for those with Maine Care who are uninsured was unable to even remain open fully this past year, having to close down multiple times due to lack of funding to sustain staffing. And not only is there not enough access to treatment currently, we also don't offer case management or care coordination for all those seeking help so they can pull together the support and stability needed to sustain their recovery. Needs for housing, transportation, food stability, community connections, and a purpose in life. Again, we urge that this legislation be amended to put in place a stakeholder group with staff support to take a deeper look at how we do and do not support those seeking or in need of substance use disorder treatment and their families. We have a system of care that is not truly a system, that is not a full continuum of care. We should take the time to study and invest in a much more comprehensive approach to the problems of substance use disorder. And I thank the sponsor for this to bring this important issue to the fore and to have this conversation. And I think we need to further study and truly take the time to look at this. Thank you for the opportunity to speak. And I'd be happy to get you any additional information.
Thank you. Committee members, are there any questions for Mallory Shaughnessy? I am not seeing any. Thank you very much, Mallory Shaughnessy, for your testimony. And I just want to remind folks in the attendee part of the meeting, we're actually still on opposing testimony. And there's, I think, been a little confusion as to where we were. So if you're in opposition, could you please keep your electronic hand up? Okay, and now I'm not seeing any additional opposing testimony. So we'll move on to those who wish to speak neither for nor against. And if you could please re-raise your hand. We will bring all the neither for nor against over to the panel. First, we'll hear from Julie Finn. Welcome to back to the Judiciary Committee. Julie Finn, you can begin when you're ready.
Okay, thank you very much, Senator Carney, Representative Harnett, members of the Joint Standing Committee on Judiciary. My name is Julie Finn and I represent the judicial branch, and this afternoon I am testifying neither for nor against LD 2008. This legislation would create a new court process for a petitioner to enter another person involuntarily into substance use disorder treatment. The bill confers jurisdiction on the district court and provides multiple pathways into court for individuals suffering from substance use disorder. Although due process and other constitutional problems are noted in the legislation, my testimony this afternoon will focus on two areas. One, the lack of time remaining in the session to properly develop a comprehensive new court process with input from stakeholders. And two, the lack of capacity of the district court to take on additional case types at this time. We would like to begin by recognizing the pain and trauma that substance use disorder brings into the lives of many Maine people, including so very recently for Representative Madigan. It is nothing short of a scourge on our society and too often produces seemingly preventable tragedies for families. The proposed legislation establishes a significant new court procedure that involves an ex parte hearing, a full hearing within 14 days, contempt hearings, and possibly post-judgment hearings regarding whether to vacate the original order. Due to the short amount of time left in the session and the complexity of the bill, the judicial branch, like others today, suggests that a study or stakeholders group be convened to work out some of the problems presented by the bill and come back next session with a new bill. We would be happy to assist and work with whatever group might be formed. With respect to adding a new case type to the workload of the district court, this committee knows that the courts are already working at maximum capacity with the limited resources presently available to address the pending caseloads made larger by the coronavirus pandemic. If this bill were to receive a positive vote in committee, our fiscal note would require adequate additional financial resources to fund judicial officers, marshals, clerks, and possibly courtrooms to address the new cases. This testimony today has not listed specific issues with the bill because we feel that a study group would be the more appropriate place to discuss the details of a new court process. Thank you very much for your consideration, and I'm happy to answer any questions if you have any.
Thank you. Committee members, are there any questions for Julie Finn? Not seeing any. Thank you for your testimony. Next, we'll hear from Dr. Nicholas. And Dr. Nicholas, I am not sure how to pronounce your name, but why don't you introduce yourself and begin when you're ready.
It's okay, thank you. It's Nicholas Petrowski.
Thank you.
Senator Carney, Representative Harnett, members of the committee. I'm Dr. Nick Petrowski, Medical Director of Addiction Psychiatry at Maine Behavioral Healthcare, and I'm here to testify neither for nor against LD 2008. LD 2008 outlines a process whereby an intervention would occur within 24 hours of a scheduled hearing that includes 2 substance use disorder professionals, including a physician, separate meetings with patient and family, and a review of co-occurring medical and mental health diagnoses. While I wish a holistic intervention could be made available to all patients with an immediate connection to treatment, I question how and where this could happen in our existing healthcare landscape with a dearth of substance use disorder professionals and treatment options available. In order for involuntary treatment to be effective, the capacity of our existing substance use treatment system must be addressed. It's no secret that Maine lacks access to substance use treatment. Medically monitored withdrawal management is extremely scarce, with statewide capacity often well under 30 beds for patients with Maine care. The capacity for residential services is also severely lacking, and accessing a bed can frequently take months. It's an unfortunate reality that patients often give up and resume misusing substances while waiting for these services. I'd also note that our hospital emergency departments have become an option of last resort for behavioral health patients, with up to 1/3 of Maine Health hospital emergency department beds filled with behavioral health patients on any given day. Moreover, very few hospitals in Maine are licensed to care for patients with co-occurring diagnoses. So committing a patient to a hospital with no connection to appropriate care after discharge will only burden an already overwhelmed system, and it's not patient-centered care. Before passing a bill of this magnitude, the state must invest in increasing capacity to ensure that behavioral health patients have timely access to appropriate care. The bill attempts to solve an age-old dilemma. As a society, how do we protect the lives of individuals who pose a substantial risk to their own lives due to an addiction? Identification of best practices and evidence-based approaches to better meet the needs of individuals who struggle with substance use disorder is definitely warranted. We recommend that the topic be studied by key stakeholders, including treatment providers, criminal justice professionals, community advocates, individuals in recovery, and experts in patient rights. Importantly, the availability of treatment needs to be considered and studied as well, and we urge your support for increasing access to treatment for Maine people suffering from substance use disorders. Thank you, and I'd be happy to answer any questions.
Thank you, Dr. Petrowski, for your testimony today. Committee members, any questions? I am not seeing any. We appreciate you being here. And I think that brings us to the last person who wishes to speak, and that's Jeff Austin. Jeff Austin, if you could activate your video and begin. Many thanks.
Thank you, Senator Carney, members of the committee. My name is Jeff Austin. I'm here on behalf of the Maine Hospital Association. We're testifying neither for nor against, largely because our policy committee didn't have an opportunity to review the bill. Based on my experience, I don't think our membership would object to the basic structure and outline of what Representative Madigan is pursuing. And it is different than green paper and blue paper, but it is structurally somewhat similar. I'm a little, let me deviate from my written testimony, which you have. I'm a little surprised at the overwhelming objection to setting up a system of involuntary treatment for substance use. I believe our blue law currently allows that today. It's in law. The limitation is on services. So it is not utilized because there's not really beds to which people are committed. But as you can see from my written testimony, our definition of mental illness in the involuntary hospitalization sections of the law includes substance use disorder. My approach to analyzing this and looking at the Kentucky law was that this was a more thoughtful and targeted approach than blue paper to people with substance use disorder. And so it was in that spirit that we reviewed it. There are definitely considerations about lack of resources, particularly for beds for this kind of care, which we really don't have, and the resources that families have to come up with to get their family members into this system. At least based on Kentucky law, it's the families that have to pay for the services. So those are limitations. I don't know that that's a reason to object to the bill. I think it's a reason to work on the bill, but not to oppose it. To me, that's the lifeboat theory of the law. Do you save some just because you can't save all? I think our members would say you try to save some, even if you can't save all with a particular bill or a particular program. We have one concern with the drafting as constructed, and that is there's a 72-hour court-ordered hospitalization, and we're just unclear as to what that is. We don't really confine people based on a court order. Riverview might do that, and maybe that's the thought process behind the bill. We don't really take people in at court order and confine them for 72 hours. If someone has an acute medical need, you wouldn't go to court, you'd go to the emergency room. They're going through withdrawal or they're having an overdose. But if there's a non-medical need, it's hard for us to admit someone for 72 hours at a court order. So that might have been Riverview, it might have been a different facility. That would need either clarification or removal. The big obstacle is resources. But again, just because this may be of limited use doesn't mean it's of no use. And I think you should give it due consideration, and we'd be happy to work with you this session or over the summer on how it might work. With that, I'd be happy to take any testimony or any questions.
Thank you, Jeff Austin. Committee members, any questions for Jeff Austin, Maine Hospital Association? Okay, I'm not seeing any. Again, we appreciate you being here.
Thank you.
And then we have one final person in the attendee room, Representative Holly Stover, whose hand is up, and we're going to bring her on to the panel to provide testimony.
Good afternoon.
Good afternoon. Welcome. You may begin your testimony when you're ready.
Thank you very much, Madam Chair. Senator Carney, Representative Harnett, and distinguished members of the Judiciary Committee. My name is Holly Stover, and I serve as the representative for House District 89. I'm here today to testify in favor of LD 2008, an act to establish a court process for involuntary substance use disorder treatment. I worked in human services for my entire career, including currently working as an addiction outreach specialist in Boothbay Harbor with the Boothbay Harbor Police Department, and I've been doing so for 5 years. I've witnessed firsthand the deleterious and devastating impact that addiction has on the lives of people and those who love them. However, I'm testifying today on my personal and family journey with addiction. I'm an aunt to a 37-year-old nephew. His name is Josh. Josh was a lively, intelligent, curious, active, and athletic boy. He played sports. He enjoyed many friends like most adolescents. He sustained football injuries, also not uncommon for high school football players who like the competition and the full-on aspect of the sport. Josh was a kid who grew up in the 90s, and his sports injuries were treated not with Tylenol and ice like mine, but with opiates. He was given OxyContin at age 15 as a high school athlete to treat his injuries that were painful, but likely could have been as easily treated with over-the-counter pain relievers. That was the beginning of an agonizing and somewhat torturous journey that has lasted for more than 20 years. Josh has participated in nearly every form of treatment known in the state and has periodically been incarcerated for minor and at least one major crime. He has been incredibly successful in his career, but also has been reduced to digging tides for worms that he can sell, which is what he does now. He had a family of his own and a child, yet due to his addiction and many broken hearts and broken roads, he does not have his child in his life at this time. He believes in God, and he attended our church for many years, where I saw him embrace the peace and love of the people there. He has volunteered and at times has contributed and given back to our community in many ways. But he has struggled for 20 years with a nearly paralyzing addiction and subsequently mental health issues, including the trauma that has happened to him living in a very chaotic and sometimes dangerous world. He has lost friends, family, connections, and parts of his community. He lives with shame and stigma that no one should have to experience. The professionals come and go, and thankfully law enforcement in our region and our county have always taken the time to reach out and try to help him. In fact, 2 weeks ago, they helped him when there was concern that he might have a gun in his possession. Let me be clear. The reason for the concern was and is what he could do to himself in an hour of desperation or need. He has spent a tremendous amount of time, money, and resources in hospitals across the state. There was one occasion where he overdosed and the medical team was not sure he would wake up and come back to us. I sat next to his ICU bed for days, and it reached a point where a decision was made to remove the vent. They prepared me for the worst scenario that he would code, but in a true Phoenix fashion, he rose straight up into the air and fully awoke from what seemed like an impossibility. He has had myriads of physicians and treatment professionals that engage and treat him despite the struggles and challenges I am sure they experience being in that role. There have been countless times when I would have really loved to commit my nephew, if only to stop and suspend his spiral of self-destruction. I am convinced if he could have been brought in and given an opportunity to detox and receive treatment, he may have seen his way out again. I dread when the phone rings at night or in the wee hours of the morning and worry that the knock on the door from law enforcement will come one day and he will be gone. As of today, my nephew is sitting in an ICU bed. He is experiencing liver failure as a result of 2 types of untreated hepatitis. We are praying that the treatment and care will work and he can avoid a liver transplant. The past 3 days have been painful and traumatizing, and as his family member, the sense of helplessness to do anything is overwhelming. I have had many hours of thinking about what I can actually do to make the outcome of this different. I am praying I get another chance to see Josh get healthy and continue on his recovery journey. I hope he lives to see his child grow up, and I hope they can return to a place where they can make happy memories together. I'm asking you to please support LD 2008 and ensure that people who are living with dangerous and deadly addiction access involuntary treatment at a point in their lives where the decision to accept help is not one they can make alone. This is less about removing rights for me and more about ensuring that people with a disease that is chronic and progressive receive needed treatment before it's too late and they are dead. I'm available to answer questions, and I thank you for the opportunity to testify on this important legislation today.
Thank you so much for your testimony, and our thoughts are with your nephew.
Thank you. Thank you very much.
Committee members, yeah. Committee members, any questions? I'm not seeing any. Thank you for testifying today.
Thank you very much.
Have all who wish to speak on LD 2008 provided testimony? If you're in the attendee portion of the meeting and this is the bill you wanted to speak to and haven't had a chance, please raise your hand. I think we have heard from everyone. So with gratitude and condolences to our colleague, Representative Madigan, thank you very much for bringing this bill forward. We'll close the public hearing and we will schedule a work session soon. Take care. So committee members, we've completed our work session on LD 2008 and the timing of the morning did not work out as I expected it to. And so I think what we should do at this point is to take a lunch break, and I would ask if a lunch break until 2:45. Actually, we still have work sessions to do as well, but we do as a committee need a break. Committee members, I'm just one moment, Representative Thorne. I feel like a 45-minute lunch break would be important because we have been going for 4 hours straight. Is that acceptable to committee members?
You said 2:45, Madam Chair.
Excuse, I meant to say a 45-minute lunch break.
Okay.
Is that acceptable, committee members?
Sure.
Okay. We'll return at 1:45, and in the interim, we're going to check in with the bill sponsors for the work sessions that we haven't gotten to on our morning agenda yet, and give everyone an update at that point. Thank you, everyone. See you at 1:45. Hello again. Good afternoon, committee members. It's just 1:45. If you've returned to your desks, could you please activate your video so we have a sense of who is ready to rejoin the committee meeting? Thanks. So we've got 1, 2, 3, 4, 5. Okay, so we're going to wait just a couple of more minutes till some additional committee members return.
Senator Carney, I just want to remind you that I believe Representative Reckitt and I have an appointment with the Criminal Justice Committee to go over the Joint Rule 319 review for LD 1899.
Oh, thank you. That had totally skipped my mind. Thanks for the reminder. Is that at 1:45 or is it at 2?
No, well, it was scheduled for 2:30, but I understand that they're a little behind on their schedule too.
Oh,
So,
I'm glad we're not the only ones.
No big surprise there.
So I mean, Janet will be working with you this afternoon anyway, but I might have to drag Representative Reckitt with me.
Okay.
Okay.
Thanks. Committee members, let's resume. Thank you for rejoining so promptly after lunch. I think that we should get going even though we're waiting for a couple of additional committee members. And let's start with some scheduling announcements because we have more work than we can do in the available time this last week of committee work. We were able to connect with the bill sponsors on LD 598 and 1946. Those are the 2 work sessions that we had scheduled for this morning, and we are going to postpone those until tomorrow. We'll reschedule them tomorrow, and we'll be letting everybody know soon what the specific schedule will be. But we thought it was better to try to catch up a little bit more rather than falling behind. And so this afternoon, we'll start with the work session on LD 1728, and then we will do the work session on LD 585. And so with that, I'm going to, Senator Keim, go ahead.
Just while you were still on the scheduling thing, I had a question related to 2023, which was notarial acts. And so we went into work session, and then we never did actually work all of the bill. We just went through that comparison chart and then kind of cut off questions. So when we take that up again, how are we actually going to work through that? That was my first question.
I have not, because I was running the hearing on the subsequent bill. I didn't have a chance to figure that out. But I would love any input that you can share on how we should do that. Maybe we could take that up later on this afternoon, because I would appreciate your feedback on that. So that maybe would be a good way to handle that. And then what was your next question?
Well, just on process on 585, but maybe I should wait until we are there on that bill.
Yeah, because we'll be opening up that work session shortly. And I think that would probably be a better time to talk about that one.
Very
Is
good.
that okay? Okay, and then, please let's maybe check in with each other at the end of the day today about the notarial acts, which is a very notoriously hard word to say. Thank you. And so any other concerns before we dive in? Not seeing any. So I'm going to bring Senator Timberlake, who I believe is in the attendee part of the meeting. I thought he was.
Yeah, he's there.
Oh, okay. Thank you.
Do you want me to bring him?
Yes, I was having a hard time finding him. Thank you, Peggy.
Well, I tried. There it is.
Senator Timberlake, welcome back to the Judiciary Committee.
Well, I thank you very much, and I promise not to take up very much of your time.
Let me officially open up the work session before you dive in, because I haven't done that yet. So we are going to open the work session on LD 1728, and we've been joined by the bill sponsor, Senator Timberlake. And you can go ahead, Senator Timberlake. You wish to address the committee?
Yes, I appreciate the time today. And as you know, the stakeholders group was convened a year ago. The purpose was to find a way of how law enforcement officers could better protect citizens when faced with individuals who are on the verge or in the midst of mental health crisis, while at the same time not infringing on individual rights. I found it to be a very difficult balance to strike in this whole thing. But with the passage of LD 785, an act to change the standard of taking persons into protective custody, which lowered the standard for law enforcement officers to take someone into protective custody if that person poses a likelihood of serious harm. And I understand there has been some positive change with hundreds of people receiving help instead of being left out on their own. I think we can continue to watch the effects and the value of this law until next session, and at that time submit legislation if necessary. The parallel here is the mental health crisis, the lack of mental health providers and treatment. My hope and my goal this session is to be able to find a consensus and provide ample funding to address the needs of these patients and the providers. I have spoken with several folks who work in the field and have asked them to come together with a funding plan. And I've been working on that all week. I appreciate the time and the attention you have given to this bill. I hope you can all agree appropriating funds for addressing today's mental health crisis, yes, it is very much a crisis, is a priority and will continue to be a priority for me. For that time, I thank you for listening to me. And, I think we just need to move on from this bill until a later time, but I will be working. I've made calls to 5 different groups to work together in the next week to see if throughout the budget we can do some funding for the mental health crisis to help police and everything else. So thank you, Madam Chair.
Well, thank you, Senator Timberlake, for sharing your thoughts and observations and for the work you're continuing to do in this area. I think I don't know if you were with us for the previous public hearing, but the acute and the need is very real and acute. Did you wish us to simply vote and ought not to pass on this for now and revisit it next year? Okay, thank you. And with that, and with thanks to Senator Timberlake, is there an ought not to pass motion? Moved by Senator Keim and seconded by Representative Harnett. And committee members, I think that we can do this just by a show of hands. And then if we need to do a roll call, we will. So this is on the ought not to pass motion at the sponsor's request.
I've got 10 and it looks unanimous on the screen.
Thank you, Peggy. And with that, we'll thank the bill sponsor and bid you farewell and close the work session on LD 1728. And at this point, Representative Babbage, go ahead.
No, I was just wondering, since that is an official action on a bill, I wondered if it needed to be reported out as 10-05 and so forth.
Committee members who were not present to vote have an opportunity over the next 2 days to vote. So it won't be reported out until we finish that step.
I understand.
Okay, thank you. We have been joined by our colleague, Representative Newell. Welcome, Representative Newell. Would you like to introduce yourself?
Thank you, Madam Chair. Good afternoon, everyone. My name is Rena Newell, and I represent the Passamaquoddy tribe.
Thank you. And we've also been joined by OPLA analyst Janet Stocco. And I am going to turn the virtual gavel over to our co-chair, Representative Harnett.
Thank you very much, Senator Carney. Welcome, colleagues. This afternoon, we will be having our second work session on LD 585, which has been amended in its title to read an act to enhance tribal state collaboration to revise the tax laws regarding the Holton Band of Maliseet Indians, the Passamaquoddy tribe, and the Penobscot Nation, and to authorize the Oxford Casino commercial tracks off track betting facilities and federally recognized tribes to conduct sports wagering. And hopefully I can respond to Senator Keim's question, but if I have not, when I describe the process for this afternoon, Senator, please let me know if you have any additional questions. We will first be hearing from our analyst, Janet Stocco, about the most recent amendment, sponsor's amendment to the bill. This bill is really broken out into 3 distinct parts. And as we did yesterday, I'm going to work it by focusing on one part at a time. And I'll explain how I will do that. The first subject we will take up is tribal state collaboration. And for that, I will invite as a representative of the tribal attorneys, Corey Hinton as a panelist, and then also Jerry Reed from the Governor's Council to participate. When we reach the taxation portions of the bill, I will bring over Corey Albright, one of the tribal attorneys, and we will also have available Kim Pat Warden from the Attorney General's office and one representative from the Maine Revenue Service. The third and final topic we will take up is gaming. And for that, we will have Allison Binney, tribal attorney for the Penobscots, also a representative from the Governor's office, again, possibly Jerry Reed, but even more importantly, a Milt champion from the Gambling Control Board. Those people will be available for questions from the committee, as will our analyst. And as this is a work session, if there are persons that committee members want to bring over to address technical questions for work session purposes, just let me know and we will make that happen. Does that respond to your questions, Senator Keim?
Thank you. It does. As far as process, I guess I just wanted to clarify at the outset that I do understand that, time is of the essence in all of our work, of course. but also that there may be questions that we have that we need to have answered. And regardless of whether they've been asked and answered previously, if we still lack understanding, it's not as a means of delay, but as understanding the impact on people. And so I just would ask ahead of time for that sort of understanding, that we are conscious of the time, and yet we do need to make sure that we understand the impact of all legislation as it gets passed, because it is important. Thanks.
Thank you, and I appreciate that. And I will say up front that we're all aware of the time, and I want us to be as efficient as possible, but as deliberative as possible. And my hope that we can have those questions answered today and proceed to a vote on LD 585 before the end of the day. Representative Babbage. I'm going to assume that's a latent hand since I don't see Representative Babbage in his screen. So with that, I will turn. Representative Babbage, did you have a question? We can't hear you, but I think I can read your lips enough to know that it was just left up inadvertently. Thank you. So with that, I will turn to Janet to provide an explanation of the most recent amendment that you provided to the committee. Welcome back to Judiciary, Janet.
Thank you. I'll share my screen.
Great.
Okay, so this is a sponsor's revised amendment. So unlike the bill before you yesterday, this is a bill which already had to have an amendment. So this is an amendment to the amendment. So ordinarily you would just see, what's the language, but I acted as if the first sponsor's proposed amendment was the bill, and I made a markup of it with highlighting to show you the changes, because otherwise it just didn't seem like you would see what the changes were. But if this is voted by somebody, all of it will look like of one piece. It won't be stricken through or anything else. It'll all look like one piece. And because I can really write a lot, I made the title even longer. So that's just a good summary of how I work. There aren't changes to the collaboration piece. And this time, instead of stars, I put little blue arrows on the side to make sure I didn't forget to show you something. And I'm really sorry for the scrolling, but I'm just proving to myself that I'm not forgetting to show you something. Okay. So the first change is here in section C7 of the bill. This is part of the tax provisions, and this is the definition of a tribal entity. And you can see most of the definition is the same. It's the same 75% ownership test or full ownership test. If you want to qualify as a tribal entity and to be entitled to the benefits here, and here the benefits are just sales tax. No, so sorry, I'm getting my bills confused. Let me double check before I speak out loud. Sorry, I've been in criminal justice all day. I literally just left, and Peggy was not kidding when she said they were behind. I was supposed to be there at 10:30, and we did our review at 1:30. So tribal entities would be entitled to a sales tax exemption for.
Janet, I'm sorry to interrupt you. Senator Keim, did you have a question you needed? At this point?
I just wanted to know if before, like, as we go through these changes, if we could ask a question about each change before we went on to the next, just because I think scrolling backwards will be harder.
If a question with respect to the amendment that's being presented?
Yes.
That would be fine.
Okay, thank you.
Yes, so I have just confirmed my notes, which I'm sure anybody listening who knows that I'm wrong will correct me, because I do not want you to have bad information, that the importance of the tribal entity definition is for the sales tax exemptions in this bill. It's not an income tax exemption. It's just a sales tax exemption. And so the only difference that this amendment makes to the definition of tribal entity you saw at the last work session on this bill is it allows the tribal entities same membership test, same ownership test, but they could be chartered under a tribal law. So you can think of a corporation being chartered under federal law or being chartered under state law. They could also be chartered under tribal law as long as they still meet the ownership tests that are already set forth in the amendment that you saw before. Then they would be entitled to the sales tax exemption if they meet the requirements of that sales tax exemption, which are in this proposed amendment. The next change, oh yeah, Senator Kine.
Oh, Senator Kime, sorry, I missed that.
Thank you. Thank you. I just had a question about this. So I'm sure I just I'm not quite understanding it, but if a tribal entity is a legal entity that's organized or chartered by a tribal authority, if they have the authority to create the charter, how do we get to then say what the parameters of that entity is?
So that is kind of how I said it. So I'm sorry for being a little confusing. Let me back up. So the idea that I understand it of this amendment is there is a certain subset of corporations that might be formed with some tribal ownership, a certain subset of them, if they meet the requirements for the sales tax exemption, will get it. So which subset of corporations are we talking about? We're talking about wholly owned corporations by tribal governments or tribal members, or we're talking about where at least 75% of the ownership is the tribal governments or tribal members. And then there are some control tests, management and control tests that are being incorporated from federal law. So you'd have to have the 75% ownership and meet the management and control tests from federal law to even be counted as a tribal entity. And then you go and you look at, do they meet the requirements for the sales exemption, which would require the purchase to be made and sourced to tribal lands, and it have to be the right tribe. So the only thing that this is saying is when you are, I've never been great at corporate law. I just took a little bit of it in law school. But when you go to incorporate your business, you can choose, do I want to incorporate under Delaware law, which is what a lot of people choose, at least back when I went to law school, that's what I was told. Or do you want to incorporate under Maine law? There are some federal laws that allow for incorporation of a business. And so what this is saying is if you choose to incorporate under tribal law, you're still considered a corporation. So you could right now have a tribal entity that would meet this test that isn't incorporated under Maine law. They could be incorporated under Delaware law because they like the way that that law works with respect to all of their liabilities and everything else, that they like the way Delaware law works. But this is saying also if you chose to under tribal law, you'd still be eligible. So it's not that the state is trying to say, if you want to be a tribal corporation, you need to meet this test. It's just saying we won't deny you the exemption just because you incorporated under tribal law instead of choosing state law to incorporate under.
So then are then the tribes are already authorized to incorporate under law currently under their own parameters, just like Delaware or whatever?
I do not know if the tribes in Maine have corporate laws right now. I know that some other tribes in other states do. I don't know if they do. I think that I would have to defer that question to the tribal attorneys.
Okay, so it could be an expansion or it could be just something that they already are doing.
Correct, and I just don't know the answer.
Okay, thank you. I think someone can come back to that later, I would guess. Thank you.
Absolutely, Senator Kime. We'll have representatives from both the MRS and the tribes to answer taxation questions. Representative Libby, do you have a question on this particular amendment on page 5?
Yes, I think it's just a quick question. Janet, my question is about the 75% number. Is that something that is kind of standard under federal law or a number that other states use in similar law? Where does that come from?
That is what it's my understanding that this whole amendment process was a negotiation and an agreement. And so that is the number that obviously the parties picked. I would point out the only other benchmark I have is 1626. And that one had a 50% ownership test. So this is higher than that. I don't know why this particular number was chosen.
Okay, thank you.
You can continue, Janet. Thank you.
I'm going to be worried. I never trust myself. I don't want to have lied about 50%. Yes, it was 50%.
It was 50%.
Okay, just wanted to check. I have no self-confidence, sorry. Okay, so the next change is here in section C10 of the amendment. And this is a provision that is probably hard to understand if you just look at it straight. So I'm glad we had this opportunity to go through it. I have my notes on my handout here. Okay, so what it said originally was, notwithstanding this provision of the Maine Implementing Act, for the purposes of Part 3 and 8 of this title, Part 3 is the part that governs the sales and use tax, I believe, I wrote it down, and Part 8 is income tax. Either that or they're flipped, but it's one of those two. It would say that the Passamaquoddy tribe and the Penobscot Nation are deemed to be acting in a governmental capacity and not in a business capacity. And if you go back and you look at this provision of the Maine Implementing Act, it says that when these two particular tribes are acting in a government capacity, they're exempt, and when they're acting in a business capacity, they're not. So what the original sponsors proposed amendment would do is say, if you're trying to figure out, are they acting in a governmental or business capacity, we're going to say a governmental capacity, and that allows for the exemption from sales tax and income tax for the tribes when acting as tribes, not tribal members or anyone else or their corporations, just the tribes themselves. This amendment, what it does is it says it switches it from notwithstanding the provision of the Maine Implementing Act to just signaling a cross-reference to the Maine Implementing Act, and that may sound really minimal and different. And this was actually language I proposed because I didn't think that this committee, if it wanted to vote in favor of this bill, wanted to look like it was attempting to amend the Maine Implementing Act. And the way it's written, it looks like you're trying to amend it. And instead, this is more of a rule of construction within the tax laws. So that was the change in the first sentence. And that actually, that was in the bill analysis as just a suggestion so that there wouldn't be any question, do we need to send this to the tribes for approval and all of that other question. The second sentence, it's my understanding, this was in the governor's office's proposed technical tax changes, and the chart that Attorney Reed sent with that had a little explanation on the side, and it said this was a request from the Holton Band of Maliseet Indians to also have a similar sentence included with respect to that tribe as well. So that's the second sentence, just to make it clear that when the tribes are acting as a tribe, they're acting as a government, not any individual or any corporation that they owned, just as the tribal entity itself. The next two changes are literally just sentence structure changes. And I just thought it read better this way, and I guess somebody agreed, so that's a good sign for me. So that's the only thing, it's really not substantive at all. Let's see. The next change has to do with the sales tax transfer provision. So just as a minor reminder, there is a current law that says that sales tax collected on the Passamaquoddy Reservation are transferred monthly to the Passamaquoddy tribe. What the amendment to 585 does is it adds similar sales tax transfers for the Penobscot Nation and the Holton Band of Maliseet Indians, and it no longer limits it to the reservation. It would include sales tax collected on Indian territory or Holton Band Trust land. What the first little technical amendment does is, instead of saying the tax collected under this part is going to be transferred, it says just under Chapter 213. So this part of Title 36 includes both sales and use taxes. And so by making this change, you would be clarifying it's only sales taxes that are going to be returned, not use taxes. As for why, I am not the why person. I can just tell you what it does. That similar thing, if we just skip down for a second to subsection 4, it's the same thing. It's clarifying that only sales taxes are being transferred back to the tribal governments, not use taxes. So those two amendments go together. The next thing that this does is it clarifies what does it mean for a sale to be occurring on Passamaquoddy Indian Territory, Penobscot Indian Territory, or Holton Band Trust land. And so there is a test here, and it says for it to be occurring on, it means that the business location of the seller from which the purchase is being made is on tribal land, and the property or service is being received on tribal land. So it's a two-part test. You have to meet both for that sale to be occurring on land, and then that sales tax that's collected would then be transferred back on a monthly basis to the 3 tribes,
Thank you,
but
Janet.
only to the one that it belongs to.
Thank you. Before you continue, Representative Moriori, do you have a question on this amendment?
I do, Mr. Chair. My personal hobgoblin with some of these bills is the interchangeability of language. Up at the top of at the beginning of section 1815, we see the phrase tribal land. Yesterday, we were dealing with tribal territory. And I want to make sure that we're as uniform as possible. I understood from yesterday that Indian Territory consisted of reservation land and land held under trust. I guess my question is, is the intent to refer to the same 2 types of land in this section? We learned yesterday that fee land really doesn't qualify as territory. And
Correct. So there are no changes to the Maine Implementing Act in this proposed amendment before you. So we somewhat have to clean out what we talked about yesterday to understand how this bill works just independently on its own. And so the definitions of Passamaquoddy Indian Territory and Penobscot Indian Territory include, as you mentioned, represent the reservations as well as trust land that's acquired, the 150,000 acres. We've talked about all of the limited geographic areas, all of those. Once the land is acquired in trust, it has to already be in trust, then it's Indian Territory, and then it would be eligible for this sales tax transfer. Holton Band Trust land is just that. There isn't a reservation, so it's the trust lands of the Holton Band and Maliseet Indians. And this tribal land is a shorthand. In the other bill, I was very meticulous about changing all of those, but there was a definition that was being used throughout, and it was an attempt at uniformity. I don't think this heading needs to be changed, but you can absolutely vote to change it if you want to favor this amendment. You could write Indian Territory and Holton Band Trust land here, but the head note is not substantive law. It just lets you know the kind of topic that will be discussed. And then throughout this section, it does specifically refer to the Indian Territory of each tribe by the full name and the Holton Band Trust land. So if you see another tribal land in there, definitely let me know and I will clean that up.
And Janet, am I correct that there's actually a definition of tribal land earlier in the bill at the bottom of page 5?
Probably, and I just forgot.
That's right.
There you go. So it's not even a problem that needs any cleanup. There you go.
Right. Thank you. Representative Babbage?
Sorry. That's what I wanted to point out. Thank you, Mr. Chair.
Thank you both for helping me get through this.
We're a team. You can continue, Janet. Thank you.
You're welcome. Okay, so the next change, trying to find it, looking for my arrows. Okay, so this next change is in the corporate tax exemption, and right in the original amendment, the only type of entity that would be exempt from Maine corporate tax were the so-called Section 17 corporations. So they're organized under Section 17 of the Federal Indian Reorganization Act. We talked a little bit about last time, those are wholly owned by the tribe corporations. They can't have partial ownership or anything else. And those were the only types of corporations that would be exempt from Maine income tax if you were to vote in favor of this amendment. So not that separate tribal entity definition, that does not come into play here. And so the technical tax amendments proposed by the governor's office included making it clear that the tribe, the Passamaquoddy tribe, the Penobscot Nation, and the Holton Band of Maliseet Indians as tribal governments they also cannot be subject to the corporate tax. I didn't know that it was possible for them to be subject to that, so I would not be the best person to ask why this might be necessary. The next two changes, these are the individual income tax provisions. The first one is an addition to your main income, and the second one is a subtraction to your main income. And I do have an example I could go through if you want me to try and understand how those work. But the goal of these amendments is to say, right now, the amendment says if you're a tribal member and you have income sourced to the tribal lands of the tribe that you belong to, that you're a member of, and you reside on the land of that tribe, then you would have the income tax exemption. And it also would apply to the estate of a decedent who was a tribal member. And what these technical amendments do is they say you need to check about their residency at the time of their death to see if the state is entitled to this income tax exemption. The next part, these are also technical changes proposed by the governor's office. It's my understanding they're intended to help with administering this law should you enact it. And this next provision talks about sourcing. How do you decide whether income should be sourced to tribal land or should it be sourced somewhere else? And so it's my understanding that 5132, which is newly created in this amendment, is modeled on 5142. And 5142 is the statute in current law, which sets forth the test to determine if someone who's not a Maine resident, whether their income should be sourced to Maine and therefore subject to Maine income tax. And so a similar test is going to be used here to decide if someone is a tribal member residing on tribal land, do you source their income to that tribal land? So 5132 is based on that. It's not exactly the same. I am not the expert who can answer the questions for you on the differences. I apologize. But what this technical amendment does is it says when you're looking specifically if an individual is part of a partnership or a limited liability company and you want to know if their share of that business income should be sourced to tribal land, there's a cross-reference here to use the test in 5192, which is in current law, and it's the test used if you're a non-resident, for example, and you have partnership income, and should it be sourced to Maine. And what this does is it says there are some cross-references from 5192 to 5142, which is that non-Maine resident versus Maine income tax provision. And this is saying when you cross-reference to 5142, don't look there, look here at 5132 instead. So it's just trying to follow the model of 5142, but in this own new statute, which is specific to tribal members and whether their income should be sourced to tribal lands. The same thing happens here in subparagraph 2, which is about estate and trust income. 5176 is the sourcing statute that deals with that in Maine's tax laws. It's referenced in 5142 when you're deciding non-Maine residents and whether their income should be sourced. So we just need to clarify here. It's my understanding that whenever 5176 is going to refer to 5142, we don't want you to go there. We want you to go here to this specific statute that's about tribal income. That is literally the maximum I know about these two proposals. So the other amendments are in the sports betting piece of this. I see a question, so should I pause?
I'm sorry, I missed that hand coming up. Representative Babbage, did you have a question on the tax amendment?
Yeah, thank you. I'm just, I don't know if it's fair to ask here. You're saying in 5132 that there is a test. What I'm wondering if somebody can explain to this layman the impact of that test. Is it permissive? Is it restrictive? I'm not quite getting the significance of the addition.
Representative Babich, I'm going to ask you to
Yes.
hold that question because we will have Daniel D'Alessandro from the Maine Revenue Service available as a technical expert.
Terrific. Thank you. Thank you,
Questions
Mr.
on
Chair.
all of the taxation provisions. So you can continue, Janet.
I just want to say how happy I am to hear that news. I know he knows the answer to that question. So the next amendments are to the sports betting pieces, and they change who is eligible for a facility sports wagering license. And because that change is made, the first change is here in the legislative intent provision. It can no longer just say that only off-track betting facilities conduct facilities-based sports wagering, because that authorization is now expanded. So this is just making sure the legislative intent provisions match what you're going to see below. So if we scroll down, almost everything is the same. There's just a few little changes. I really am sorry for the scrolling. I just want you to be sure that we catch all of the changes that are in this amendment versus the last one you saw. Oh geez, sports betting is long. I might know the person who was wordy and drafted it, but I'm not reviewing. So the change here is under the original sponsors proposed amendment, there would be a total of 7 facility sports wagering licenses. And now that is increased to 10. And in addition, if you look at who is eligible, it would still be all of the off-track betting facilities under 275D and Public Law 2019, Chapter 626. So just to remind you, the 275D off-track betting facilities are located in Waterville, Sanford, Lewiston, and Brunswick. The 2019 Public Law Chapter 626, that is your Scarborough Downs off-track betting facility. They would all remain eligible for facility sports wagering license. You would add Oxford Casino, so just that one casino, and then you would add commercial tracks, for which there are currently 2, is my understanding. One is in Cumberland, and the other one is the Bangor Raceway.
Representative Babich, did you have a question on this section, or is that from your taxation question?
I do, but I'm going to hold. Thank you very much.
Thank you.
So if you add these up, there are 5 in category C, 1 in category B, 2 in category A. So that's 8 entities currently exist that would be eligible, but the amendment says that there are 10 licenses available. So if there's a new OTB that opens, for example, or a new commercial track, they would also be eligible to get a license. But there is a finite number, a cap, if you will, at the end. And then the only other change is in the mobile sports wagering license provision. So I just want to back up again, just to remind you how the amendment overall is structured. So if you are one of the facilities we talked about, an OTB or a casino or a commercial track, or if you are one of the federally recognized Indian tribes that's eligible for just a mobile sports wagering license under this amendment, you may have the in-house expertise and be able to just offer that amenity and that service to customers, and that's great. But if you don't have that in-house expertise, there is an availability to enter a contract with a management services provider. Those entities have to be licensed if you look through this language, and we talked about it last time. And the contract between the operator who has the actual mobile sports betting or facility sports betting license, the contract between them and the management services provider is highly regulated under this language. So that exists. And then what this amendment does is it says if you are a federally recognized Indian tribe and you get your one allotted mobile sports betting license, you can only enter a contract with one management services licensee. It is my understanding from being asked to put this amendment together that the idea is, for example, if the Penobscot Nation wanted to get the license for mobile sports betting, they wouldn't be able to enter into contracts with FanDuel and now I'm blanking on all of them, DraftKings and MGM and every other possible sports betting management services provider, thereby getting sort of like multiple licenses. It feels like they're only allowed to enter into an agreement with one. So if they choose FanDuel, that's who they have. They can't also have one of the other providers.
Thank you, Janet. And I see Senator Keim has a question.
Thank you. Yes, just a clarification right here on this section is, so in other words, the mobile sports wagering license, am I understanding correctly, there would only be 3 given in the state because it's, or would it be 4?
It's 4 because this phrasing is federally recognized Indian tribe. It doesn't exclude the Mi'kmaq Nation like some of the other provisions.
Okay, so Mi'kmaq is included. They could get this mobile sports wagering license as well as the other 3 tribes. Okay, understood. Thank you.
Thank you, Senator Keim. You can continue, Janet.
I think that's the last change. The only other things are just corrections to the summary to match. And I had originally drafted one part of the summary a little bit inaccurately, so I fixed it. But it's just matching. I can go through them if you want.
I don't think that's necessary. It's just reflecting what you've already told us.
I believe so. I certainly hope so.
Okay, thank you. Once again, Janet, greatly appreciate your work on this. Now I'm going to Representative Moriarty, do you have a question before we get into the first topic area?
I do, Mr. Chair. Janet, yesterday I printed an amendment to this bill that was sent by you, and it's for the work session of today. The transmission was dated March 15, and it has no highlighting, no blue arrows, and no shading. Did you send a second amendment later on?
I don't think so. Did anybody else get that? My goodness, I'm sorry.
Because it's not what I'm seeing on your screen.
Senator Sanborn has a hand up that you might be able to help out.
Yeah, so Janet sent us the version that she just went through at about 8:20 this morning. I don't have the email right in front of me, but it was right around, let's see, 8:35 this morning in your email. There's a revised sponsor proposed amendment, and then a revision to her bill analysis, and those are attached to the email she sent to the committee at 8:35 this morning. Steve, I think if you have something you printed yesterday, it would have been from an earlier transmission of the original version of the sponsors amendment, not this revision that was just published this morning.
Okay, Senator Tamara, thank you. I apparently printed something yesterday. I did not print anything today, so I must have taken it to be a duplicate, but it wasn't.
Thank you, Senator Sanborn. And thank you, Representative. At this point, I'm going to ask, before I start moving people over, the first section we will deal with is Part A, which deals with tribal state collaboration. Are there any committee members who have questions about that portion of the bill? If you do, raise your electronic hand and I will call over Corey Hinton. I would ask Soupy to please move over Attorney Corey Hinton and the Governor's Counsel, Jerry Reed, as panelists so we could direct our questions to them. So I'm going to give them a minute or two to get transferred. And while we're waiting for that, I see we've been joined by Representative Hagan. Welcome, Representative Hagan. Please take the chance to introduce yourself to committee members.
Thank you very much, Mr. Chair.
Members of the
David Hagan. Pardon me?
I'm sorry, go ahead.
I apologize. Anyway, I'm Dave Hagan. I represent House District 101, Hamden and Newburgh. And thank you very much, Mr. Chair.
Thank you, Representative Hagan. It's nice to see you again. And Senator Keim, you have a question on the collaboration portion of the bill?
I do, thank you. And my question is for Jerry Reed. Good afternoon. Thank you for being with us. My question for you is, we talked a little bit more about the collaboration and having liaisons and training, which we sent you follow-up questions, which I appreciate. There wasn't really an ability, I think, for you to give us any sort of real numbers on how many people would need the training, nor did we get any real numbers on the number of policies that would have to be gone over, but that there would be a designated liaison for every single department. And I'm in favor of this collaboration, but what concerns me is that we're not seeming to be realistic about the cost involved. Like, we've had many other discussions with MCILS on training, or any number of different agencies who come to us and give us costs just on training, never mind a designated liaison. So for me, it doesn't pass the straight face test. And I want to make sure that when we consider something, that we are considering every impact of it. So I guess I would like, given your answers to us previously on a little bit the vagueness of your response, how you would now answer about cost.
Sure. Good afternoon, Senator Khan. And that's a concern for the administration, as you can imagine. And as I said in the written responses I provided to your questions, the point of this collaboration bill is to improve communication between the state and state agencies and the tribes, and to promote respectful dialogue. It's not intended to create a new bureaucracy that's difficult to implement. It's not intended to be overly prescriptive in its terms. It's not intended to become a pitfall for the unwary in terms of, people getting called on missing aspects of this as during the implementation. It's something that is intended to be and has to be implemented in good faith by all the people involved. And when I say all the people involved, I'm not just talking about state agencies. I'm talking about everyone who is mentioned in the bill in one form or another and has a role in implementing the provisions of the bill. That means certainly agency heads and agency staff. It also means tribal leaders and tribal staff. It also means the Maine Tribal State Commission, which has a role in this. It means the governor and the governor's office. It means legislative committees of oversight. Everybody who's mentioned in this as having some role will have to work together in good faith to ensure that this fulfills its intended purposes. But getting back to your question about resources, it's really not possible for me or for anybody else to provide kind of a blanket response to your question, because how this will be implemented within individual agencies will be so individualized. Some agencies I can see having more occasion to engage in the sort of collaboration the bill calls for. Some agencies that are mentioned, frankly, I think will very seldom have any occasion to engage in collaboration, but that doesn't mean that it's not appropriate to include them, because at some point they may have an important reason to engage in the collaboration. And if they don't have frequent occasion to do it, it's really not imposing any sort of a burden on them at all. They'll have to make sure that whatever staff are likely to engage, to kind of encounter tribal issues, are ready to handle them. Maybe that's a very small number of staff, and they'll have to file an annual report, or not an annual report, a report every 2 years with their committee of oversight and with the Tribal State Commission. That's not a significant burden. And the designation of a liaison to oversee this within each agency is not a significant burden either. Each agency already has a legislative liaison. It would be something akin to that. And I think that in order to implement these requirements in a way that's efficient and not unnecessarily bureaucratic, my vision of it will be to provide all the agencies with some assistance through standardization. So there will be some model policy adopted or at least drafted that can be tailored to meet the needs of individual agencies, so that there's not a lot of reinventing of the wheel that's going on. The training that is envisioned in the bill will be developed in some uniform way that again can be tailored to meet the needs of each individual agency. So we're not going to dump this concept on the agencies and tell them to go figure it out. We're going to try to solve those problems upfront, work through it with them, and then kind of hand it over to them to implement in a way that makes sense. And it will all, by definition, it will have to be done within existing resources because we're not attaching a fiscal note to this bill to provide additional resources. And I think it is realistic to do that. The sort of communication that's called for here shouldn't be anything more that's already happening, but I think in some cases it will be, but it's important and it's already the sort of work that is expected of state agencies. That's our view of it. So I understand where you're coming from about resource concerns. The administration always has resource concerns, but this is a program that we think can be implemented alongside the other sort of work that agencies do in a similar way, their interaction with the state legislature, with the congressional delegation, with other outside entities. We think it's realistic and we're comfortable with it.
Thank you for that answer. Mr. Chair, can I just follow up with a couple of questions?
On the collaboration piece?
Yeah.
Yes.
So just so I
Again,
understand, so what's that?
Directed to the administration or to the?
Yes, just with Mr. Reed. Thank you. So generally when we create law and direct a department to do training or develop model policy, each department then has to follow through. But the way you described it, which I understand would save resources, is the governor's office would take on this and then sort of hand it off to the departments. Am I understanding that correctly? And is that actually the way the language reads?
So we're going to kind of feel our way forward on this, but I've already started to give some thought to what a model policy might look like. And so I envision myself as playing a role in helping the agencies get a head start on this. It's not written into the statute, and I don't think it needs to be, but I don't think it's fair or in anybody's interest to just expect that each agency is going to pick this up on their own without having some coordinated approach. And the bill itself does call for the agencies to be collaborating with the tribes and in different circumstances with the Tribal State Commission as they implement parts of this. So it is envisioned that there's going to be some kind of coordinated approach. And I'd like to be of assistance to the agencies and to everyone involved in trying to get this off the ground. So it's not written into the bill, but I think it's only fair that I should try to be helpful to the effort.
And then, so how often would you envision that training happens for the employee, for the affected employees in the departments? Would that be, once, so they're aware of this process that is, sort of happening? Is it training that happens, every other year? What are you envisioning for that?
Yeah, and again, I'd hesitate to be too specific about that. I think there will need to be some initial training provided to ensure that staff knows what they're doing at the beginning. And then within each agency, it'll depend on things like staff turnover, changes in staff responsibilities, that sort of thing. So I wouldn't want to be too prescriptive. It's not written into the statute. And as I said in my written responses, our expectation is that agency heads will take this responsibility seriously and implement it in good faith and try to comply with the spirit of the collaboration requirement, and determining how often training needs to be administered and re-administered is all going to be part of that. It's not, I don't think it's appropriate to say it should be every year or 2 years or 18 months. It's going to depend on the circumstances of the agency.
Okay, thank you for those answers. And then I don't see any other hands up. So can I ask another question, Mr. Chair?
Yes, you may.
Okay, so I think I asked this before and I don't remember the answer, but just the separation of powers question about the legislature directing the governor to hold a meeting with the tribes once a year. I mean,
Right.
clearly the governor could just say no. So is this, I mean, why would we put this into statute when we don't really have the authority to do so? Or do you disagree with that?
No, I think the reason you would put it into statute, even though there is a constitutional issue implicated in what you're describing, is that you're providing a clear statement of the legislature's desire that the governor convene this meeting with tribal leaders. And in the same way that the legislature technically can't compel the governor to convene the meeting, I think you're right about that. The legislature can't compel the tribal leaders to participate in it either. So all of this depends on the good faith of the people involved in order to make it a success. And there are limits to what the legislature can require in this area, but we think it's worthwhile for the legislature to be on record as to what it thinks is appropriate and necessary. That's how we would interpret it. And we interpret that language that you've pointed out in a way that is consistent with constitutional separation of powers in the way I've described.
Okay, thank you so much for your answers.
Thank you, Senator Keim. Thank you, Council Reed. Are there additional questions from committee members regarding Part A, the collaboration piece of LD 585? Representative Evangelos.
Thank you, Mr. Chair. I just need clarification if the collaboration piece is the same thing as the dispute resolution piece. Are they the same thing, Mr. Reed, or are those two different concepts separated?
So yes, thank you, Representative Evangelos. The dispute resolution piece is, I think you're referring to a provision in LD 1626. Is that right? Yeah.
Yes, and I asked you last time, and you said 585 had a robust one. So I just want to make sure, is this collaborative business we're talking about right now, does that include the dispute resolution process?
It does not include the unallocated language that LD 1626 contains that directs the establishment of a separate dispute resolution process. This is collaboration between and among state agencies and the tribes and the governor and tribal chiefs. So the separate dispute resolution piece in 1626 is not separately contained in this bill. And if I led you to believe otherwise in answering a previous question, I apologize.
That's okay. So I'm assuming then if there's a dispute, it'll be handled through the collaboration process.
Yeah, I think that's a good point. All of this is intended to avoid disputes, right? It's intended to have everyone communicate better, communicate more thoroughly and more respectfully in order to avoid disputes before they arise. So our hope is that will be one of the dividends of this process.
Okay, I understand better now. Thank you.
Thank you, Representative Evangelos. Additional questions on the collaboration piece? Senator Keim and then Senator Evangelos, both second timers. Senator Keim.
I did give everyone else a chance. So my question, and this is not probably something you could answer right now, Mr. Reed, but I'm just wondering if there was any way, if I wanted to propose an amendment on this collaboration piece that would clarify the idea that this would be done within existing resources. I know that there isn't a fiscal note put on it, but I understand the process that you're describing, and it makes sense to me. But I guess I just don't know how it actually plays out. So I just didn't know if there would be a suggestion from you on that, if that was something I was interested in pursuing.
Sure, I'd be open to that, assuming that the tribal representatives are also open to it, and I'd be happy to work with you and Janet on language if that's the direction that the committee wants to go.
Okay, thank you so much.
Representative Angelos.
Thank you, Mr. Chair. Previously, there was some information that came through from Executive Director Paul Tebow of MITSIC, who may have some information he wanted to provide the committee on this collaboration piece. I'll leave it to the discretion of the chairs whether you want to call him in, but it was something previously discussed. And I had written him and told him that, you know, this would be the place for him to be recognized if you feel it's relevant, Mr. Chair.
Are you asking for Mr. Tebow to weigh in on this issue, Representative Angelos?
I think since I had indicated and gotten some guidance from the committee that he would be given an opportunity. So yes, I'm asking just briefly.
Thank you. Supi, could you please move over Paul Tebow? And as he is being moved over, I just want to check so we can move on after Mr. Tebow. Are there other questions from committee members regarding the collaboration piece, which is only the first 3.5 pages of the bill? Mr. Tebow, welcome back to the Judiciary Committee. Representative Angelos, did you want to pose a question to Mr. Tebow?
I just wanted to know, because he's had a lot of experience in working with the tribes across the nation, if he could share some best practices that he may have witnessed. That was all.
If I may, then I would just make some brief comments, and I appreciate the opportunity to do that. Just very brief background. As some of the committee members know, 2 years ago, MITSIC was asked to offer recommendations regarding best practices on consultation. And we worked with the tribes on language that ultimately became, at that time, LD 2118. A lot of the language of 2118 found its way into 1626. And some of that work product, I believe, is reflected in 585 that you are now discussing. A statute on tribal consultation in MITSIC view would be a very positive step forward. Executive orders have come and gone. And so a statute would institutionalize that process. And that would be a good step to take. I do want to make a couple of points about the specific language in 585. The scope of the matters that would come under consultation under LD 585 is narrower than exists in some other places, including in some other state consultation statutes. But it nevertheless, I think we regard it as a step forward. Probably from MITSIC's view, not the last step in developing a robust policy and practice of tribal state consultation, because it is not as broad in scope as exists in some other places. In particular, the language that limits the matters to those that uniquely affect the tribes is different than exists in some other places. I guess the last point I'd like to make is that best practices in tribal state consultation is a evolving thing. It's been evolving over the last couple of years. And our hope at MITSIC would be that based on the role that is provided for MITSIC in this in this process that we could continue to bring to those conversations and to the development of the process our recommendations regarding best practices that have been developed, because a lot of people have been working on this in a lot of places. And it only makes sense that that here in Maine, we take advantage of the work that's has been done and continues to be done in a lot of other parts of the country between the state and tribes to develop robust policies that really do work towards true collaboration. Those are basically the comments I wanted to make.
Thank you. Thank you, Paul. Attorney Hinton, do you have concerns about the breadth of the collaboration process? Is there any input you would want to give?
I just say that this is intended to be a first step towards improving tribal state collaboration. We looked at in landing on what you have before you, we looked at other models for tribal state consultation, and we're aware that these sorts of dialogues are handled differently elsewhere. This is not intended to be the gold standard. This is what the parties agreed upon, and we're hopeful that it'll be a first step for improving tribal state communication.
Thank you very much. Are there additional questions regarding collaboration? And I am not seeing any, so thank you, Paul Tebow. Thank you, Corey Hinton. Thank you, Council Reed. I will now move on to the taxation provisions, which are on pages 4 through 12 of LD 585. I ask the committee clerk to please move Mr. Reed, Mr. Tebow, and Attorney Hinton back to attendee status, and to bring over Corey Albright, Daniel D'Alessandro, and Kim Pat Warden, who might be of assistance along with Janet on technical questions regarding tax, although I know Janet would be happy to have me send those to those technical experts. So I will wait for them to come over and ask, are there questions from committee members regarding the taxation portion of LD 585? If so, please raise your electronic hand. And it looks like we have all 3 persons over, so they are available. Oh, and I also want to recognize, I believe the bill's sponsor is in the attendee room, and it is the practice of the Judiciary Committee to have the bill sponsor as a panelist during work sessions. Soupy, could you please move over Representative Talbot Ross? Representative Talbot Ross, I'm sorry it took me so long to get you over. Welcome back to the Judiciary Committee. I feel like you're an honorary member, but you were just in the last session, so that's not that big a change. Nice to see you again. Committee members, are there questions for the tax experts regarding Part B of LD 585? Senator Keim.
Thank you. I am not sure. I have several questions and I'm shuffling to try to put them in some sort of order. But one of the questions I had, which I think it has to do with exempting the blueberries and the potatoes and the forest products. And so we did get an email, which I thought I printed, from the Blueberry Commission, and I can't find it in front of me at this moment, but they had a question in that I thought we probably would like an answer to. And then I think I had asked about overall impact on with these different entities. So is there someone that could answer that for me as well? And I will pull up, or if no one else saw the Blueberry Commission question.
I see that Janet has her hand up.
Okay.
She might be of some assistance here. Janet?
I believe Senator Keim is referring to testimony that was submitted within the hour before this work session started. So if you look in the electronic committee file, if you sort by date, it's probably the last thing in there.
I just found it in front of me. So I was curious about overall impact to these different entities, but also the Wild Blueberry Commission and does this this testimony. And basically, and maybe we can't answer it now, maybe it's something we have to find out later, but they're asking a question about how the tax would be levied, because if wild blueberries are grown on tribal land in Maine and are not subject to tax, but those blueberries are then shipped to a facility for processing and then processed either in the state or outside of the state, is the processor then required to pay the full tax amount to the state? So basically the tax, the processor is still required to pay tax on blueberries that are grown on tribal land. That was their question.
Thank you. I will first turn to the governor's counsel to ask if I should direct that question to him or to Mr. D'Alessandro, or if the administration has had any contact with the Blueberry Commission.
I would defer to Daniel on that.
Thank you. Daniel D'Alessandro, any thoughts on the question posed by Senator Keim? And I was unaware of additional testimony being filed right before the work session by the Wild Blueberry Commission. So I have not had an opportunity to review that. Are you familiar with the program, Daniel?
Yes, I am. Hello, my name is Daniel D'Alessandro, and I'm Associate Tax Policy Counsel, the Office of Tax Policy and Maine Revenue Services. Thank you for having me here today. Thank you for that question, Senator. I have not seen the testimony yet, but this exemption would be for blueberries that are grown on tribal land. And so that would, no matter where they're processed, the processor would be exempt if the blueberries were grown on tribal land.
Okay. And do we know yet the overall impact of this exemption on the Wild Blueberry Commission and the Potato Board and the Forest Products Board or Commission, whatever they're called?
Dr. Allen is in the waiting room, and he would be the best one to answer questions about the fiscal impact of any fiscal impact questions.
Of those three specific things. Okay. And so we can either do that now or later, whatever works best for you, Mr. Chair.
Well, I'll forget it if we do it later, so we might as well have Dr. Allen. Is that Michael Allen?
Yes.
You listed as Michael Allen. Soupy, I'm gonna have this panelist room pretty full. Could you please move over Dr. Allen to address that question? Welcome. I'll wait till I see your face. Welcome, Dr. Allen, back to the Judiciary Committee. It's nice to see you. Can you address the question posed by Senator Keim?
Yes, so I don't have an answer for you on the blueberry tax or the potato tax. On the commercial forestry excise tax, that acts a lot like a property tax. So in this case, the tax base would be lower because the tribal lands would be exempt. So the tax rate will adjust to generate the revenue necessary to help the department cover the costs of fire suppression. So there shouldn't be any revenue loss. It'll be just a rate change.
Thank you, Dr. Allen.
Can I ask a follow-up on that?
Yeah, yes, you may.
So there's a rate change, which means that in order to keep the same level of services for fire suppression, does that then mean that there's a rate change of an increase to the tax on other land?
Correct.
And do we know how much the increase to other land would be?
No, we haven't looked into, to what extent this exemption would affect the base.
Okay, and no guesstimate on that, like
I
okay.
don't, sorry.
Okay, thank you.
Thank you, Senator Keim. Representative Babbage, and thank you, Dr. Allen.
Thank you very much. I wanted to pursue incorporation, if I could, and Mr. D'Alessandro, Mr. Allen, or whoever might be able to help me with this, perhaps Mr. Reed. I would like to know, authorizing the tribes to incorporate means what to the state of Maine?
So this bill doesn't authorize the tribes to incorporate. This bill is defining which type of entities are qualifying for the sales tax exemption. And so I think you're referring to the part that said that a tribal entity includes an entity incorporated under tribal law. This bill itself is not authorizing the tribes to incorporate an entity under tribal law. It's just saying that if there is an entity incorporated under tribal law, which could be one of these tribes, potentially could be one of these tribal laws, but it could be a different tribe's law as well, then it can qualify for the sales tax exemption. And so that's similar to having a corporation incorporated under Delaware law or under Maine law, or really any tribe's law. And generally, we would expect those to be similar types of corporations.
Okay.
But each authority could have its own rules.
Okay, thank you for that. I'm trying to grasp the meaning of part of the amendment was to include limited liability corporation. Can you, I understand the meaning of each of those words. I don't know practically what that means in this application. Somebody help me with that.
Daniel, I'm going to call upon Attorney Corey Albright to see if he wants to weigh in on that issue, unless you're ready to address it, although I would get his take on it as well.
That's fine.
Okay. Attorney Albright.
Thanks, everyone. Thank you, Representative Babbage, for the question. I will, I think, respectfully defer to Mr. D'Alessandro in terms of the questions about limited liability company and their treatment under the Maine tax code. And Representative Babbage, it might be helpful as if there's a particular provision is it the tribal entity definition that you're asking about in particular?
Yes.
Okay. And I think as was referenced earlier by Ms. Stocco, the tribal entity definition was very carefully discussed at length among Maine Revenue Services, the Attorney General's office, the governor's office, and the tribal attorneys to ensure that there was clarity about what entities would be eligible for that limited sales tax exemption specifically on Indian Territory and Holton Band Trust land. And so within that overall definition, as you know, there are different types of entities that can be formed. And you may have a limited liability company, you may have a mom and pop shop, but when people seek to do business, they may choose different business forms. And so the intent, I think, was simply to sort of encompass generally those forms, so long as they meant that very careful, strict definition of what would be a tribal entity. And I think, I would defer to Mr. D'Alessandro for further thoughts on that.
And if possible, for a layman like myself, can you give me a for example that could be used? Thank you.
So for example, Representative, if you were to join with other members of your distinguished committee to form a business selling widgets, you may choose to incorporate that business as a limited liability company so that in the future, if the business has a liability, that person does not come and seek to take your home and does not seek to bring a claim against Representative Babbage in his individual capacity. And that is why, limited liability companies are the standard form of business in the United States, among all people. So hopefully
That's all right. Yeah, I thought that was the definition of all incorporated companies, limited liability in that sense.
I will defer to Mr. D'Alessandro or others. I'm not a corporation's attorney, but that.
What I'm actually getting, yeah, I'm sorry. I don't mean to prolong this. This was an amendment that was added to the wording, and I'm trying to determine what the significance of adding those words were into the entity definitions.
Mr. D'Alessandro, is it the only addition, the word tribal, that it could be incorporated under tribal?
Yes, I believe that in LD 1626, there was an amendment to add limited liability corporation, but that's not in this portion. Limited liability corporations or companies could fit this definition, but there's not an amendment adding them specifically now.
And all corporations can, people are free to form limited liability corporations, correct?
Right.
Okay, so this is not providing any right.
I'm sorry if I misreferenced that. I may have made a mistake. I have one more question, but I don't have to.
You're the only hand up in the room.
Okay, I'll take it down in advance, Mr. Chair, but I do have that one more. I wanted to, before when we were talking about the bill, we're going to have a hard time finding it now, but I believe it was the referencing, what was the question, is 5132. Where did I find it? Okay, maybe it's not new, but it said the individual's distributed share of partnership or limited liability company income.
Where are you, Representative Babbage?
I'm on page 10, 5132. It was
that's when it incorporated the tests that already exist in statute?
Exactly, the tests that were evidently referenced in 5142 or whatever. And I guess with regard to partnership and limited liability company, or an individual share of estate or trust income, my question was, is that section of the bill that applies those tests, is that more or less restrictive than if that wording had not been added? I think the last time we did it, I said, is that the significance of including that here is to make it more permissive, or is it to make it more restrictive? I didn't understand the significance of this section of this wording.
Are you talking about the amendment language or the provision more generally?
The provision more generally in 5132. Well, as worded, of course, but yeah.
Would it be helpful to step back and kind of describe what this income tax provision is doing and how the 5132 sourcing provision fits in?
It would be to me. Thank you.
So what section G3 and G4 of this bill do is they exempt income of a tribal member who is residing on tribal land for the income that is sourced to tribal land. And so what does it mean to be sourced to tribal land is an important question there. Now, in state income tax, we have people who live in Maine, who live outside of Maine, who earn income both in and without of Maine. And so we commonly have to answer the question, where is the income sourced? And Maine generally taxes the income that is sourced to Maine. For a resident individual, we would tax all of their income and provide a credit for income sourced outside of Maine. But for a non-resident or a corporation, we would just tax the income that is sourced to Maine, that is earned in Maine. And that can be allocated. Some types of income go all to one place, like your wages. They go to wherever you earned your wages. Some income is split between multiple states. And so if you think about a business, if I had a factory in Maine and I sold all my widgets in New Hampshire, you would have to answer the question, which state should tax that income? And there's not a uniform answer. Different states take different approaches. But what Maine does is it says, look to where those sales are. If those widgets are sold in New Hampshire, they're sourced to New Hampshire. Other factors that could be considered are where the property is, where the payroll is. Where's the factory? Where are the employees? Maine doesn't currently look to those factors, but we have in the past, and other states do. So 5132 is answering a similar question, not when is income sourced to Maine, but when is it sourced to these tribal lands? And it's modeled very tightly on section 5142, which answers the question of when is income sourced to Maine. We're applying really that same criteria. There are a few differences, but we're applying very similar criteria to determine when the income is sourced to tribal land. With the most important difference is instead of looking at where the sales are, we would look at where the property and payroll are. And so some examples would be if I'm an employee, right? I'm a tribal member, I'm working. My income is going to be sourced to where I perform that work. If my wages are earned at a store on tribal land, it would be sourced to tribal land. If it was at a store in Bangor, it would be sourced off of tribal land. If we look at a more complicated scenario like a business, if the property and payroll, the employees and the manufacturing equipment is all on tribal land, we would use the property and payroll here. That's different than our normally sourcing rules, but we would source that income to tribal land, no matter where the sales are. If the factory is off of tribal land and it's sold onto tribal land, then we would source that income off of tribal land. So you would kind of look at where that equipment, where that payroll is to determine whether it should be sourced to tribal land. And so that's what 5132 does.
Actually, that helps me a great deal. I appreciate that answer. Those are my three questions, Mr. Chair. Thank you.
Thank you very much, Representative Babbage. Representative Hagan.
Thank you, Mr. Chair. A little confused by this stuff, so I hope my question doesn't sound crazy. Businesses incorporate in different states due to tax reasons in part. Could any business be able to incorporate within the tribe if their rules allow it, especially if the goal is to generate economic activity?
So this bill doesn't speak to the tribe's power to incorporate corporations. And that's more of a civil law kind of incorporation power. And I'm not certain whether the tribes do have that authority under current Maine law. Maybe Mr. Albright could speak to that.
But it's not implicated in this bill. This bill is not addressing that issue.
Right.
Attorney Albright, do you have anything to add on that in response to Representative Hagan?
No, I think I would simply say that, all states, I think, have their own corporation codes, and they have their own laws and rules about what are the requirements for eligibility to incorporate under that state's laws. So for tribes that may have a corporations code, they would have the same, they would be setting the same kind of rules, by their own legislature in terms of what, the consideration they would give to potential incorporation under tribal law.
Thank you. Senator Keim.
Thank you. I think I have a clarifying question around that exact point, because when Janet was screen sharing the new amendment, the word incorporated under federal, state, or tribal was added. And so I had questioned at the time that exact thing. So do the tribes have their own ability to establish corporations under their own parameters or law, just like Delaware or, you know, federal corporations or whatever? Do they already have that ability in Maine? Is it giving them that ability? Because it's referenced there. So maybe I'm misunderstanding, and I don't know which one of you can answer that for me.
Well, I would agree with Mr. D'Alessandro that the bill does not speak to any authorization that does or does not presently exist in terms of the ability to incorporate under tribal law. I know my client, the Holton Band of Maliseet Indians, does not have a corporations code. But why is that? That is simply a decision that the tribe has made. You know, whether or not tribes hypothetically right now in Maine are, I guess what I would like to say is that, you know, that question is not one that I think needs to be answered for purposes of this bill, whether that authority exists. You know, the Attorney General's office is here, tribal attorneys are here, but the bill itself simply speaks to incorporation under these different forms of laws, whether or not that ability, you know, exists. For example, a tribe could incorporate under Delaware laws, has been mentioned, and whether or not there's a question surrounding whether tribes can do that. You know, I don't know that to be the case, but I would view it the same way.
So the fact that it's referenced doesn't mean anything one way or another. Like the addition of putting in whether they're incorporated under federal, state, or tribal law doesn't change anything, is what you're saying, even though they may or may not have corporate law, or is that what am I understanding that correctly?
I think that's fair to say, Senator Keim.
Okay, thank you. I have other questions, but I'll defer.
Senator Sanborn.
Yeah, I was just hoping I could be helpful on this point, because I think that the purpose of that sentence in the amendment, both in its amended version, which is a little bit broader, is the point is it has to be a separately organized entity in order to qualify under this provision of the bill. So the emphasis of the part of the statute that's really functional there is to say this has to be an entity. It has to be a legally organized entity. And so we'll recognize legally organized entities that are created under state law, federal law, or tribal law. But maybe there are no legally organized entities under tribal law. Well, that doesn't matter. It just means that the emphasis is on, is it a separately legalized, organized entity? And it would be a problem potentially if there were entities that were organized under tribal law. I'll just throw it out there. Maybe they're organized under the law of a different tribe in a different state, the same way you could be organized under the law of Delaware. Maybe you can incorporate under Navajo law. I have no idea. But if you could, that's the sort of entity. It's a separate corporate entity that we could apply these tests to, and it would make sense. So I think that's the purpose of the language in the statute as I understand it. And I wanted to give Mr. Albright and Mr. D'Alessandro a chance to respond to my interpretation and check whether that accorded with what they think the function of these words is in the statute.
Yes, I think that's right. And the only other thing I would add is this language, both elsewhere in the tribal entity language and that specific sentence, tracks with the Federal Small Business Association's requirements, and they also allow organization under state, federal, or tribal law. And so this is harmonizing us with what the federal government is doing as well.
Thank you for that, Senator Sanborn and Daniel D'Alessandro. Senator Keim.
Thank you. And I think my question is for you, Mr. D'Alessandro. One of the questions we asked in an earlier work session was the idea of the overall fiscal impact of these tax changes. Have you begun work on that at all, or would that not be your job?
I would defer to Dr. Allen on any of the revenue questions.
Okay, perfect.
Dr. Allen.
Thank you. Senator Kime, we have started that work. It's not complete. I think when we had met with you a week and a half or so ago, we had indicated that we had a rough idea of the magnitude of dollars currently being collected, both from income tax and sales tax on tribal lands. But we haven't done anything beyond that at this stage.
Okay, and so for our knowledge, and I know I asked this before and I do not remember the answer, I apologize. But so for our purposes, not only now for understanding the fiscal note that would come from the snapshot in time we would have at this moment, but then the future impact of whatever this might be, is that information that we as legislators will have access to and will understand the impact of all the full tax exemption portion of this bill?
We will estimate the revenue impact on general fund revenues of the proposals that this committee passes out, yes.
Right, and that's for as everything currently stands. But what I'm asking is that then in the future, if we were to look at, okay, what's the impact of this tax code on these tribes and on these entities, is that something that becomes part of the information that is accessible to legislators, or does it become, privileged like tax returns?
Well, we can't provide any information on any particular taxpayer. We would use the information we have to develop a fiscal note that would certainly be provided to the Office of Fiscal and Program Review, who would then provide it to the legislature, but it would be aggregated. We wouldn't be able to tell you that the XYZ company will see this sort of benefit, or Mr. Smith is going to see this sort of a income tax cut. We don't do that for any bill. Right, it's confidential taxpayer information.
Understood. I guess what I'm asking is that in the future, does this become part of the overall picture of what's going on in the state of Maine, or no? Once this is part of law, no one ever looks again at what these tax exemptions are.
So correct. We will do an estimate now based on the information that we have, and our estimates currently go out to fiscal year 25 because that's as far as the revenue forecast goes out. So our estimate will certainly include the same economic growth assumptions that are currently built into the economic forecast. These will become tax expenditures. And every 2 years, we put out a tax expenditure report as required by law. It's commonly referred in the Taxation Committee as the Red Book. And that lists the estimated revenue loss for all tax expenditures enacted by the legislature. So to the extent that we have actual information off of income tax returns and sales tax returns, those will certainly be reported in the tax expenditure report every 2 years. And it'll obviously, if we think the revenue impact from these provisions are maybe costing the state more or costing the state less, those will be incorporated into future revenue forecasts by the Revenue Forecasting Committee.
Thank you. That was the part I'd forgotten. I did write in my notes in big something about Red Book, and then I looked at it later, had no idea what I was talking about. Okay, that's helpful. And then I know that I asked previously and you weren't able to answer, but how soon would we be able to find out the impact of just the specific exemptions on the potato or wild blueberries or forestry? Is that a difficult, are those difficult numbers to find?
I'll be honest with you. I don't know. They're just not, the blueberry tax and the potato tax are really, Maine Revenue Services administers them, but I'll be honest with you, in the 25 years I've been here, I don't think there's been any tax changes on those. So they're just not lines we're familiar with. Also, I'm not sure those are general fund revenue, so I don't believe they're dedicated taxes, so it's not something that usually gets incorporated in the revenue forecast that we do every couple of times a year. So it may be easy information to determine what this particular exemption will have on those two lines. It may be more difficult. The information may not be clear, and we may have to do some additional searching or some guessing.
But the impact of the loss, even if it wasn't on general fund, is something that would still be at some point figured and incorporated into this as a fiscal note.
I think so, because I think that would be other special revenue. This is what I'm assuming. OFPR could probably answer that question better than I can at the moment, but my assumption is the Office of Fiscal and Program Review will want us to provide them an estimated revenue loss for those two taxes.
Right, and then whatever the rate change would be to the other landowners based on the forestry excise tax as well. Is that correct?
We could probably tell you if the law had been in effect this last year, how that would have changed the tax rate. The tax rate changes every year based on the value and also the needs of the Forest Service. The commercial forestry excise tax covers a portion of the fire suppression costs for the Forest Service. So depending upon what that cost is each year, the tax rate has to be adjusted in order to collect that amount.
Right. Okay. Thank you.
Thank you, Senator Keim. Are there additional questions from committee members regarding Part B, the taxation portion of LD 585? I am not seeing any. I would like to thank very much Daniel D'Alessandro, Dr. Allen, Kim Pat Wharton, who was let off easy, and Attorney Corey Albright for responding to the committee's questions regarding taxation. We'll now turn the committee's attention to the gaming portion of the bill, which begins the legislative findings and purpose, Part 1 on page 12, and then the substance of the bill is Part J. And for this portion of questioning, I'm asking the committee clerk to please move over Attorney Allison Binney. Council Reed can stay with us, and I've also been asked to bring over Milt Champion from the Gambling Control Board. I'll wait till those transfers are made, but as we are waiting, if committee members have questions about this portion of the bill, please raise your electronic hand. I see your hand, Representative Babich. I'm going to wait till people are pulled over. I see that as soon as I see Allison Binney and Milton Champion on camera. Welcome back, Attorney Binney, and welcome, I think for the first time, Milton Champion. If you've been here before and I forgot that, I apologize. Questions from committee members regarding gaming? Representative Babich.
Thank you. Excuse me. Thank you, Mr. Chairman. Yeah, a couple of basic ones, if I could. I just in the bill, there were several numbers for fees: 200,000, 40,000, 4,000, 250. Can you review for me the impact of the purpose of each of those fees, so I can just clarify that? So be able to do that for me.
I am trying to figure out who that question would be directed to. I know that our analyst reviewed all of those fees and could tell us what category they are for. Is that something you could do? And if that does not respond to your question, we'll figure out another way to address it. Representative Babich? Janet?
Well, my understanding is that at least for the online portion, that the initial cost of contracting, well, I don't know. What is the $200,000 for? That's a good question.
Why don't we let Janet
Sure.
review those categories?
Certainly. So there are license fees. So if you want to obtain a facility sports wagering license, so that's in-person betting only, then it's a $2,000. Oh, sorry, I'm reading 1352 column. Sorry, it's a $4,000 fee for a 4-year term. If you want to receive a mobile sports wagering license, so that's only online or mobile application bets, and the person betting has to be physically located within Maine, then those are $200,000 licenses for a 4-year term. If you want to be a management services provider, so as I talked about a little bit earlier, those are the companies that maybe actually have the applications and the online, or you might even do them in person. I don't know enough about sports betting to know what that would look like in person. But if you want to be able to enter into a contract with a licensed mobile or facility operator, then you need to pay $40,000 license fee for a 4-year term. The $250 one is for the individuals who are employees. Somewhere that is on my chart. Yes, here it is. So if you're an employee that's engaged directly in sports wagering related activities, so that would be if this is a mobile sports wagering license for the tribe, if you're an employee of the tribe or the wholly owned corporation that the tribe gives the license to, and you are directly engaged in those sports wagering activities, it's a $250 initial licensing fee. And then there'd be renewal fees significantly less of $25 for a year or $50 for 3 years. But if you are just an employee that doesn't have anything to do with sports wagering, you wouldn't need this license and you wouldn't have to pay that fee.
Thank you for that, Janet. If I may ask for a clarification. So if we're talking in this bill, off-track betting, a raceway, Oxford Casino, they would pay the $4,000 fee in order to offer sports wagering. And the tribes would pay $200,000 a piece for each of their licenses for online sports wagering. That's right. And so if they are to contract somebody to run the operation, an out-of-state company that is in the gaming business, that gaming business company would pay $40,000 in order to be able to operate in the state of Maine. Okay, thank you for that.
We got their suppliers too. I don't know exactly the difference between the management services providers and the suppliers. I would defer to Director Champion on that, but you might also contract with a supplier of the equipment, and they also have a $40,000 license fee for 4 years.
And Mr. Champion, a supplier, as far as sports wagering, those that would only probably be for brick and mortar establishments that would have a machine by which to enter that wager. Is that true?
Yeah, equipment suppliers typically are like people that handle the servers and the platforms. So once they bring them in, if somebody wanted to, if they had a brick and mortar, they could just have the supplier furnish the platform, the server, and they could hire people to establish the betting and all that sort of thing, which is basically what the other entities like with the mobile apps do as well, like DraftKings and FanDuel.
Thank you. The bill, I think it's the bill, because I came across the term adjusted gross sports wagering receipts. And I was surprised that it's gross sports wagering receipts, but adjusted means adjusted for what? What is that figure? What does that figure represent?
I think, see, Janet has her hand up. I believe that we might have had a chart on that. Janet, is that something you, and I don't mean to cut you off, Director Champion, but if Janet has a ready response.
Sure. The definition of adjusted sports wagering receipts is on page 14 of the amendment we've been reviewing today. It's also listed on page 8 of the chart that outlines all the sports wagering provisions. And just in shorthand, you take all of the wagered amounts and you subtract out the winnings that were paid out to the winners, and you subtract out any federal taxes. The amount of money that's left, you might think of as like the profits. That's what the tax is collected on.
And is that, I think I've seen it represented by the casinos as net income. Would that be
I
like?
think that they may be referring to that because at least one of the casinos, and I can't remember which one it is, I know Director Champion knows, at least one of them pays 1% off of all of the wagers placed before then they net out everything and then they pay the rest of their taxes off of what we would think of as net income. So I think that's probably why they might have raised that point.
Okay, I have one more, Mr. Chair, if that's all right.
That's before you get to your next one, is that accurate in your estimation, Director Champion?
Yes.
Thank you. And you have another question, Representative Babbage?
Yes, I wanted to understand in the last page or two of the bill, we do have what I think is the management services providers cap as far as what could be entered into a contract for that service. And I believe that's what it's for. And I think I read 30% with a 40% maybe temporary provision if to get it started or something it's necessary. So I'm not sure whether it's a 30% cap or really a 40% cap. But I guess what I'm looking for is the intention of a cap. I would think would be to if the state is giving permission for this to happen through this legislation, we want the money to go where we hope the money will go, and therefore we'd like the cost of operation to not take advantage of the situation. We'd enter into a cap. But I'm looking at the two types of tribal entities, one being wholly owned, I think it was called Section 17, and then one being 75% owned. Is it possible for an out-of-state entity, I don't know if it be, any of the gaming corporations, to say, okay, I will enter into a contract for 30%, but that's not enough. So I want 25% ownership of the corporation that owns this operation. Is that a legal possibility within this framework? Yes.
Janet, if you could explain the answer to that. I think we're mixing sort of apples and oranges here.
Yes, so the tribal entity definition we talked about, where it could be wholly owned or 75% owned, that is for the tax piece, and that's for the sales tax piece, and that's the only place it's used in this amendment to 585. As far as the sports betting piece, the federally recognized Indian tribe is what is itself eligible to get the license. And if it gets a license, then it may transfer it to a business entity that is wholly owned. So that could perhaps be your Section 17 corporation, because those have to be wholly owned. I'm happy to be corrected on that if I'm wrong, but that's my understanding. But they could not transfer the rights under that license to an entity that's even 99% owned. It has to be wholly owned by the tribe.
That is my question. Thank you very much, Janet. Thank you very much.
Thank you very much, Janet. Senator Keim.
Well, Representative Babbage started in on some on some of the questions I had as well, and maybe this is best for Mr. Champion. But so the idea that we would set in statute this limit, is that done elsewhere, and is it arbitrary? How did we come up with that number? I mean, I guess I'm looking at this as, well, first of all, from someone who doesn't know anything about this gaming industry, but also that I don't know how much is appropriate and how much, everyone wants to make a profit, plus they need to, be able to facilitate and help do whatever what they are doing. So this 30 or 40% cap, how did the number get to be there? And is that because we're looking at what the business model is for these in other states? Do you have an answer to that? I'm trying to figure out if it's appropriate.
Well, I think this was an addition, so I would defer to Mr. Reed, because this it's not to say that it's not being done, or it's to some extent being done in another state, but I'm not sure how they came to that. It wasn't in the other prior bills.
But it is being done in other states, a cap.
Can I?
I don't know for sure. I can't give you specific states. I have not looked into it, but I've heard of caps being used in this form before.
Okay.
And Director Champion was not personally engaged in the negotiation of this bill. So I think I'm going to ask Attorney Allison Binney, who's very familiar with the gaming industry, to respond to your answer. Attorney Binney, respond to your question.
Sure. Thank you. The language of a cap for management services agreement, it was pulled from the federal law, the Federal Indian Gaming Regulatory Act. That law, which is used throughout the country for every Indian tribe that does gaming activities, except for in Maine, because it's not applicable in Maine, that has a cap on management services contracts, on essentially management agreements. And the reason for the cap, Congress put it in, is they wanted to make sure that the primary beneficiaries of the actual profits go to the tribal government and go into government services, resources, infrastructure, things like that, so that it actually has a benefit to the government. So it doesn't take into consideration things like you're pointing out, Senator, like the actual cost. So like the supplier, they'll be paid. All the costs associated with equipment that's covered. This is basically for managing, like the general managing, whoever a tribe might contract with to manage all the operations. If the tribe doesn't have the sophistication and expertise themselves. So when Indian gaming was first established and kind of working throughout the country, that these types of agreements were very common. And then over time, as the tribal governments gained expertise, they oftentimes started doing it themselves and no longer used management agreements.
Okay.
But that's where the language came from, was the federal.
Right. And is that typical, this 30 to 40%? Is that what you've seen? Mm-hmm. Okay. And do you know if other states actually have given exclusive rights to mobile sports wagering to tribes?
Florida has to one tribe, actually. There's 2 federally recognized tribes in Florida, and Florida legislature passed legislation that gave exclusivity to one tribe, the Seminole tribe. It's common in other states too. And I mean, I could go through several states. In Michigan, the federally recognized tribes each got a license. In Michigan, there are 3 commercial casinos that were pre-existing in Detroit. They worked with the tribes, and the tribes agreed to let them each get a license as well for mobile. I'm not talking about facility licenses, but everybody got a facility license too. In Arizona, the federally recognized tribes, there are 10 licenses for them. And then there were 10 licenses for sport franchises. Every state does it differently. There's a debate going on in California whether to limit it to just the tribes or not. So similar debate that's going on here has happened in many other states, but definitely in the state of Florida, it's just one federally recognized tribe for the entire state. And that was after that tribe got approval from the only other federally recognized tribe.
Okay, so there's other federally recognized tribes in Florida, but if you're going to do mobile sports wagering in Florida, you're working with just one tribe.
Yes.
Like you would be, okay. And then you could probably, you could probably answer this other question as well. So I noticed that in the amendment, I think it's saying that you can contract with they can contract with only one management person, which is, I get this is the same 30 to 40% cap. So does that mean that there's only one mobile app as well?
That's the intent of that language. We would probably want to get input from Director Champion to make sure that we feel comfortable that accomplishes the goal, but that's the intent. The intent is that each tribe only gets to contract with one online platform. Essentially,
Okay.
when the industry, what would be called one skin.
Okay, so then there could be 4 platforms in the state of Maine, or maybe they would contract with the same management company, and there might only be one.
That's exactly right. There could
Okay.
be up to 4, and as few as 1, and up to 4 for mobile.
Okay. Okay, I have another question, but I'm going to wait because it's a little bit separate topic.
Thank you. And if I could just follow up on that last question, Attorney Binney, in the event that the 4 tribes chose to use the single platform, there are clear mechanisms in the statute to make sure that that handle is divided up between those 4 tribes.
That's right. And there's also a provision that requires the operator to separately count.
Right. Thank you for that. I'm going to turn to some folks or any person who hasn't had a chance to ask a question on gaming. Representative Moriarty. You're muted, Representative.
Right, that's right. Sorry, it's been a while. I don't mean to interrupt your planned sequence of events, but I have a question about section 1206 located on page 21.
If it's on gaming, it's fair.
It's on gaming. Late this morning, just before noontime, we all began to receive several somewhat angry emails about section 1206, subparagraph 2B. And I'm wondering if someone can explain the genesis of that provision.
Sure, Representative, I can. So the tribal nations had included off-track betting facilities as the only entities to get facility licenses. When they did that, we were under the assumption that Bangor Raceway was considered unlicensed and as an off-track betting facility. But the goal of the tribal nations was to make sure that off-track betting facilities and commercial horse tracks were covered and were allowed facility licenses. There was some confusion over whether Bangor Raceway was an OTB or technically a commercial track, and more research discovered that it's Bangor Raceway is licensed as a commercial track, so not an off-track betting facility. So we ended up including commercial tracks because we also learned that the Scarborough Downs had closed, but the first tracks in Cumberland County was in the process of developing. And so again, wanted to make sure that, commercial horse tracks were included. And so we ended up pulling the language from commercial tracks that was in LD 1352 to cover commercial tracks. And that essentially covers all the existing facilities that do wagering activities in Maine, except for Oxford Casino. And they are not an OTB and they are not a commercial track. And it did seem unfair that they would be left out since they're currently doing wagering activities. And we could not find a good way to include them. So we included them, as you see, in 2B.
Mm-hmm. Okay, Attorney Binney, that's very helpful. I just need to sort of nail down one point. Some of the emails from late this morning made the point that Bangor was being excluded. You're saying it's already included because it's a commercial track.
Yes.
So.
And that was how this all developed, was trying to make sure that the commercial track, the horse track in Bangor, which I frequent, so I'm familiar with, that they're covered. We wanted to make sure that they were covered somehow, and originally thought that they were licensed as an OTB, but they weren't. They're
Right,
commercial
so
track.
neither Bangor nor Oxford has an advantage over the other.
The tribal nations don't believe so.
Okay, thanks.
And just to be clear, Allison, we're talking about brick and mortar again for that aspect of the bill.
Yes,
Okay,
this is for facility licenses.
thank you. Senator Senator Carney.
I just wanted to point out that I think that Representative Libby's mechanical hand is not working. Her physical hand is up.
Oh, she's not on my screen right now, so I did not see her. Representative Libby?
Thank you, Mr. Chair. I wanted to have the opportunity to follow up on what Representative Moriarty was asking about. I guess to be clear, am I understanding correctly that Bangor Casino and the Bangor Racetrack are two separate and distinct entities, or you're referring to them as one and saying that the Bangor Casino would then be included in this amendment? I guess I'm not clear on that.
Our understanding is they're owned by the same company on our research. And so we originally wanted to make sure that the Bangor Raceway, which is the track which is 2 blocks from the casino, had a facility license. That was always the tribe's goal in trying to assist the harness racing industry here in the state. And then when we learned that First Tracks in Cumberland County was developing a commercial track, we wanted to make sure they were included as well. And so that's how we ended up including commercial tracks, because we learned that Bangor Raceway, the track, was not an OTB.
Okay, so so all commercial tracks are included, and then if the intention is to include the Bangor Casino, if they're owned by the same entity, why not simply include the Bangor Casino as B was included a casino in Oxford County? Why not simply include a casino in Bangor as well?
They would then have 2 facility licenses. They would have a license as a casino, and then they would have a license as a commercial track. So it didn't seem fair to us to give any one entity 2 facility licenses.
Even though the track is only open a very limited number of days out of the year.
The Cumberland track, I think, is also open a limited number of days too, once it's fully open. But our goal was to include commercial tracks, not so much the casinos. But once we included the Bangor Raceway, Oxford expressed concern that they would be the only existing entity that does wagering activities that would be excluded. And so that fairness and equity argument obviously was persuasive to the tribes, given that fairness and equity is something they've struggled with.
Gotcha. So if there was a raceway close to the casino in Oxford, then that would have been included instead of the casino itself.
If Oxford owned a raceway, yeah, it was actually part of their larger property and business, then yes.
Okay, thank you.
Thank you, Representative. Representative Poirier.
Thank you, Mr. Chair. I just want to follow up on this line of questioning as well, because it's my understanding that with the racetrack in Bangor, that the city of Bangor actually owns that property, and that having it worded as such this way, it may actually be very difficult for them to obtain this sort of license, because it would involve going through the city of Bangor and that sort of thing as well. So I think that's something that deserves a little bit more attention and thought before we proceed with that part of it.
So our research didn't show that. If the city of Bangor owns that, that would be helpful if they could share that, because that's not what our research had showed, that the Bangor Raceway was licensed and owned at.
I don't believe anybody's reached out to the city of Bangor on anything. So, but it is my understanding that the the raceway itself is the property of the city of Bangor. So I just think we should look at that. Thank you.
Thank you, Representative. Representative Babich, and then back to Senator Keim. You're muted, Representative.
Thank you. Yeah, I needed that time to recall my question from long ago. Thank you, Mr. Chair. Attorney Binney, good to see you again. You've always been knowledgeable, so I appreciate you being here. When I saw today's amendment and the additions were made for the raceways in Oxford, I was aware that the city of Bangor has ongoing expenses that they've counted on income from Hollywood in order to pay for Cross Arena and so forth. So I am sympathetic to those kinds of things, but I'm interested in market share. All of these are, other than the tribes, are brick and mortar establishments, and so people would have to be there in person in order to wager in sports betting. But you mentioned, for instance, Michigan, or other states that have exclusive tribal online betting that also have wagering in their gaming establishments that are brick and mortar. And I wondered if how much of a dilution is it to the tribes in those areas where these licenses are given to brick and mortar facilities, but online gaming is in the hands of the tribes. Are you able to share something that would give us an idea if this change might, how much it might impact tribal income?
We haven't seen any impacts. So sports betting, whether it be facility or mobile, is a new market, and it's been separate from your existing bricks and mortar casinos. So we haven't seen any impact on sports betting, whether it be facility or mobile, on traditional casino slot machines and table games and things like that. It's on just sports betting, the impact it's had. So it's not had any impact on negative impact on tribal casinos. The facility sports betting, so it's all been positive. So facility sports betting, your in-person sports book has been an increase in revenues, and mobile has been an increase. How much of an increase has varied, to be honest, state by state, because there hasn't been a good, clear model. And I don't know if Director Champion has seen one, but it's sort of, it's a new industry and a new gaming space. So you will see some states authorize up to I've seen states authorize up to 60 licenses, and then not all the licenses get used. New Jersey is an example. Not all the licenses in New Jersey are being used. And then I've seen states, authorize one license, and then everybody else is in between. And so it's kind of like a trial and error approach that's going on now. So how well the industry does in any state and who benefits from it really depends on the population of the state, and the number of licenses, and then how many skins each licensee gets. But it's all been a net positive. I've not seen anybody lose money.
Thank you. If I may follow up, Mr. Chair, what I was wondering about is the influence of some of these mega companies, the FanDuels and DraftKings and so forth. I wondered if marketing can impact, can sort of squeeze out some competitors, or if that's been observable in your experience.
Yeah, I would say that marketing is one of the biggest costs associated with the industry, and obviously the bigger companies have bigger marketing budgets, and it definitely. That's why some states have kind of limited the number of operators that can be in the state. There's also concern just about advertising in general. You'll see over in Europe where they've been doing the mobile sports betting longer than here in the US. They're actually now, considering passing laws trying to limit the amount of advertising that can be done, because a lot of, just your everyday average citizens sick of seeing all the advertising on TV. So yeah, it can do that.
But the difference isn't really between online and brick and mortar competing in that marketing environment.
The marketing is mostly mobile. The marketing on mobile is what's having the big influence. Yeah, the facility sports books, they tend to have smaller advertising budgets. They're just smaller revenue generators. So mobile is definitely where the biggest advertising budgets are.
Okay, thank you very much. Thank you, Mr.
Thank you. Senator Keim, I know your hand's been up for a while, but Representative Evangelos hasn't had a chance to question on gaming, so I'm going to turn to him before I go back to you. Thank you. Representative Evangelos.
Thank you, Mr. Chair. It's a basic question. I just want to get a clarification. So an operating racetrack has its campaign from June to August, and then the harness racing ends in August. That doesn't mean that the brick and mortar sports gambling facility at that location has to close, does it? They can become a year-round entity even outside of the horse racing season. Can somebody answer that for me?
Yeah, and I think, Representative, that if the commercial tracks get facility sports betting, I mean, they will definitely stay open year-round.
But even if they don't stay open, presumably January and February. Anyways, there's no racing going on. The campaign is completed. They have the betting facility there. It's a brick and mortar licensee. They can continue to stay open, correct?
The commercial tracks, yes, they can stay open. The bricks and mortar sports book, is that what you're asking?
Yes, the sports book, even though there's no horse racing, the sports book can continue to stay open.
That's exactly right.
Okay, so I just wanted to make sure in the case of Bangor, for instance, that it's a 365-day operation as well. Thank you.
Thank you, Representative. Senator Keim.
Thank you, Mr. Chair. I have a few questions still, surprisingly. But one of the things that I thought might be helpful is the representative for Hollywood Casino, Chris Jackson, is I think in the attendee space. And I think it might be helpful to pull him on to ask for clarification around Bangor, because we've all had a lot of questions about what actually is going on there. And I think he could give us a definitive answer so that we understand, how it's worded now, how it will play out for those two entities, both the racetrack that's a couple of miles from them and the casino.
If you have questions for Mr. Jackson, I will gladly bring him over. Supi, if you could please move Chris Jackson over as a panelist. And Chris Jackson, as soon as you activate your video, nice to see you. Welcome back to the Judiciary Committee. I will allow Senator Keim to pose her question to you.
Thank you.
Thank you. I was just hoping you would clarify for us the difference between the racetrack and the casino. And I think the intent here was to include the facilities, so there wasn't one left out. But I think there's just some misunderstanding on what that looks like and who owns what. So I was hoping you could just explain to us the amended version, how that plays out, what the impact is.
Thank you, Senator Keim and Chairman Harnett and members of the committee. Chris Jackson, on behalf of the Hollywood Casino, Hotel and Raceway in Bangor. There's a lot here. There's a lot to try to unravel with this issue. But to be clear, the Bangor Casino is excluded in the newest amendment. Intentionally or unintentionally, the Bangor Casino does not get a facility license in this new bill. The bill is written so that the commercial track across the road would get a license. the commercial track, the Bangor Raceway, which we operate, but is owned by the city of Bangor, sent a letter to the committee last week outlining concerns it had with such a proposal, because Representative Moriarty had raised it during the initial work session, at least in concept, that it might be worth exploring. Simply put, the commercial track is not suited to operate a retail sports book. It does not have the space. The location is several blocks on the other side of the road from the casino. It is open for 39 race dates a year, which are statutorily required, and additionally extra days for simulcast racing. However, there's a $300 million facility at the casino with the latest technology, the IT infrastructure, the security measures in place that is far better suited for a retail sports book. The raceway probably generates, as you saw in a rather hurried email that I sent to the committee when I first saw the amendment this morning, probably about 1% of the foot traffic that the casino has. It's just simply not practical to give the racetrack a retail sportsbook license. If the Oxford Casino is getting a license, our strong preference would be that the license just go to the Bangor Casino. That would actually generate more traffic to the raceway than the raceway would generate to the casino. There's a host of reasons why that doesn't make sense. I mean, everything from the lighting to the rooms. I mean, we should do a field trip to the Bangor Raceway sometime, and and we could go through it in person. I'll stop there and answer additional questions. But the bottom line is we're simply a tenant of the raceway. I mean, we may not even have a lease agreement down the road, so who knows how that all could work. It would be very, very problematic.
Just to clarify then, so the raceway, so the license is tied, even if the same entity runs both, the license isn't tied to the company that's running it, the license is tied to the exact location. And if there was one license given to the owner, the ownership entity, then they would just choose to put it at the casino rather than the raceway. Is that correct?
I think what I'm understanding is that we are the operators of the track. We are not the owners of the track. We operate it as a condition of our casino license, but we are not the property owners. And our preference is, if we truly are not wanting to leave out Bangor, that the Bangor Casino, for the reasons that I outlined, and would get the facility license. Now, that being said, our stronger preference would be a facility license at Hollywood Casino with a tethered mobile license that accompanies that, but that may be a separate conversation. But that's our strong preference.
Right. So I have to clarify one more time, and then I don't have any more questions on this. But so the license, though, the retail sports booking license, if it's given to the raceway, benefits the town of Bangor?
No, I mean, it probably wouldn't benefit anybody, is the truth. It's just such a marginal location that it wouldn't benefit anybody. Probably.
I just meant because Bangor owns it.
Right, Bangor owns it, correct.
Okay.
I mean, we would probably operate it through the raceway, but it's just hard to find the logic in giving it to the raceway as opposed to the casino, especially if the Oxford Casino is.
Right, understood. Okay, thank you.
Thank you, Senator Keim. Senator Sanborn.
So I wanted to follow up because I think there's some confusion about who owns the actual physical property versus who owns the license to operate a commercial racetrack. So can you tell me the licensee of the commercial racetrack in Bangor?
I think the Hollywood Casino Hotel and Raceway is the licensee, but the property is owned by the city, is my understanding.
Okay, but you control it as the tenant, as the lessor, and you control the license and you own the license. All of your clients
under this,
owns
yeah,
the license. Okay, and in fact, isn't it true that if you didn't have the raceway license, you also wouldn't be entitled to continue operating the casino under current state law? Is that true?
That is correct, yes.
So those two licenses are inextricably linked and must be held in the same ownership. Is that true?
I'm following your line of question. Yeah, okay. Yes.
Okay. I don't think I have any further questions.
But I guess the point is, why give one facility a license to a casino in Oxford County and not the other facility license to the casino in Bangor? I guess it just, as I said in my testimony, I don't want to be repetitive, but this is unlike any model that's employed anywhere else in the country. This would be far outside of the norm with other commercial gaming states.
Thank you, Chris. Representative Reckitt, then Senator Carney.
Not sure that what I have to say is, I know it's relevant to the discussion, or at least I believe it is, but I'm not totally positive that anybody's going to like what I say, except perhaps the tribes. Because in reality, I don't see why we're doing any of this, except, I mean, the point of this was to give the tribes access to mobile sports betting. That's my only interest in this bill. I don't care if there are more licenses here, there, or everywhere, except that I don't think it makes sense. That's part of my brain, of course, is because I'm not wild about gambling, period. But I am concerned that we find a way to let the tribes have some kind of control over their future financially. And I have zero sympathy, no offense, sir, to Hollywood Casino. I've been in there once, darn near died of the smoke. I know you've changed that, but in any case, I have no interest in that at all. The only interest I have in this bill is in finding a way to give the tribes access to mobile sports betting. And everything else to me is peripheral, and I'd dump the whole darn rest of it out if I had my way, which I'm sure I don't. So I'm just frustrated by the concern that seems to me, and I understand that's how life is, but everything seems incredibly financially motivated to me. I'm not saying that's an awful thing. I know that's how life works. But to me, that's not my priority. My priority is to bring some kind of ability for the tribes to support themselves in a way that we've allowed pockets of people all over this state to do. And it just doesn't make sense to me that we would encroach any closer than we have to that privilege that we would be negotiating with them. So I'll be quiet now, but I've just been frustrated during this debate, so I had to let that out.
May I respond, Mr. Chairman?
If you saw a question there, but if you want to make a brief comment.
Well, I think it's worth reiterating that in the previous sports betting bill that is pending, the tribes had access to a retail and a mobile license. So I grant you that this has been a frustrating process, but it's been frustrating for us as well.
Thank you. I do want to keep the conversation focused on the bill in front of us. Senator Carney.
Thank you. I wanted to ask, and these maybe are questions for Chris Jackson, just a little bit more information about the relationship between the Bangor Raceway and the Hollywood Casino. So I looked up online, because it's easy to do that now, the ownership of the actual track itself. And the tax records are saying that the owner is HC Bangor LLC. And I'm wondering, is that the same corporation that owns the land on which the casino is built?
I'm not sure about that. I mean, I think we're getting into the weeds of the license of the raceway. I can find that out. To keep it big picture, that the city owns it. We operate it as a tenant. I mean, that's my understanding. That's the way it's always been. Who's listed on the tax records? I mean, I don't know. I can go back and find out from someone in the city and get you more detailed information. But
no, I'm honestly, I'm just trying to figure out whether a license that goes to the Bangor Raceway, which may or may not be owned by HC Bangor LLC, whether that license is it tied to the raceway land, the physical land, or is it tied to the licensee that owns the raceway?
Well, the way we read the amendment, that the retail sports book would be located at the raceway, and that's, this is just hugely problematic for us. We think it would be hugely problematic for the city as well. I think so. I mean, we can find out, but I mean, it seems to be more simpler just to put the license at the casino. I mean, we're the Department of Public Safety Director Champion and his team, they're in there on a daily basis. We're regulated. We've got
I understand that. And I'm not sure that I have much vested interest in this other than understanding it. And so is your position that there should be two licenses, one that goes to the Bangor Raceway and one that goes to the Hollywood Casino, or just that there should be one for one or the other of those entities?
Our preference would be a retail facility license at the casino with a tethered mobile license attached to it. That being said, specifically to answer your question, if there's going to be one license in Bangor and it has to go to either the commercial track or the casino, we feel very strongly it should go to the casino. Was that helpful?
Yeah, that was helpful information. Thank you.
Thank you, Senator Carney. And Attorney Binney, I saw you had your hand up. Was it in response to a question that has been on the table?
It was. I just wanted to clarify that. So I hear Mr. Jackson's point on the preferences to have the sports book at the casino. The goal of the tribes when they did this, though, was to help the commercial tracks, the harness racing. And so having the sports book at the commercial track would bring more business to the commercial track. The land does appear to be owned by the city, but it's leased and licensed through Hollywood Casino and Raceway. They're the ones that profit from the enterprises, and they are the ones that would get the license. So it's like when we talk about the tribes' lands, and one of the members of the committee asked, well, can the tribes lease their lands? They can. And then the tribe only regulates it, and whoever they lease it to is the one that generates the revenues. So the goal, I just wanted to be clear that the goal of the tribes was to help the commercial tracks. It's not abnormal, just to also clarify, it is not abnormal to have a state, most states, and I won't want to say all, because there might be one or two one-offs, but pretty much all the states that have authorized sports betting, whether it be facility or mobile, has limited licenses. And there are instances where commercial casinos did not get a license, but tribes did. What's abnormal and what the governor and the tribes were trying to correct is the situation in Maine where the tribes do not get to operate casinos. In every other state in the country, tribes get access to the casinos, and they don't in Maine. And that's what the governor and the tribes were trying to fix here by allowing the tribes to have exclusivity to the mobile licenses. And I hear what Mr. Jackson is saying and why Bangor Casino would prefer the sports book to be in the casino. He's right. The sports book itself would probably generate more money being in the casino than at, I mean, I would say it would be very likely that the sports book being in the casino would generate more money and more revenues. But the goal of the tribes was to benefit the horse racing industry, and having it at the commercial track would be more helpful in their views.
Thank you, Attorney Benny. Senator Keim.
I actually have a couple sort of technical legal questions that I would like to ask Mr. Reed. If that's all right, a little bit changing track here. So if people still need to ask
I'm going to put that
Mr.
off
Jackson. Yeah.
So Representative Moriarty had his hand up. And if it's on gaming, I'd like to get to him first. I don't think he's had a chance to weigh in on this one. Representative Moriarty, did you take your hand down? You're muted, Steve. Representative Moriarty.
Sorry, I did take my hand down because I thought Senator Keim was going to be leading into a string of questions. What I had intended to ask was to point out was that we really haven't heard from the tribes on this rather new amendment. And I reference has been made to what their desires were vis-a-vis the racetrack industry. I know this was a negotiated agreement from the get-go. I hope it still is. But personally, I'd like to get some reassurance from Mr. Hinton and Mr. Albright on this Section 1206 issue.
Thank you for that. I think the way I will handle that is I'm going to have Senator Keim pose her questions to the Governor's Council, and in the interim, ask the committee clerk to please bring over Attorney Hinton and Attorney Albright. Senator Keim, and then after Senator Keim, Representative Newell.
Thank you. So I have one clarifying question for you, Mr. Reed, after Ms. Binney's most recent statement that the tribes haven't been given an opportunity for a casino. Aren't ours actually established through a process that they could have also attempted? Is that not correct in the state? Whereas we had municipals, we had a statewide referendum that was put forward.
Well, the political process is certainly open to the tribes as it is anybody else.
Okay. So I had two questions, and one I had asked on a previous work session and didn't get an answer. Well, at least I don't think I did. But it might also have to, it might tie into another question. But so one of the things, and in section 1207, mobile sports wagering license, there was a question that that was brought to my attention about economic protectionism. And I was wondering if you could answer that specifically because it says with a principal place of business in the state, and something, to do with cross-state business and what's regulated federally versus by the state itself. So is that a problem or a potential lawsuit in this bill?
Is there a subsection of 1207 that you're looking at primarily?
Yes, it's in number 2, eligibility transfer to wholly owned entity. I would tell you which page it's on, except that I think we all are looking at different graphs.
Right.
22.
I
Yeah.
think that Janet has her hand raised as well.
Oh, thank you, Senator Carney. I was looking for the statute. Janet, if you could help out here.
I think Senator Khan is referring to 12072, which does allow the federally recognized Indian tribe to transfer their license to a wholly owned entity for the principal place of business in the state.
Right. Yeah, there was some discussion about constitutional issues and Commerce Clause concerns in various provisions within the bill. And we worked with the Attorney General's office to ensure that those were adequately addressed. And so I'm comfortable that this provision does not present constitutional problems because it was reviewed with that question in mind. If you'd like more information about that, we could probably arrange for Kim Pat-Worden to weigh in, but that was an issue that received some careful attention in the drafting of the bill.
Okay, yes, I think if Kim Pat-Worden had another or any specific thing to add to that for around that question, if she wanted to raise her hand, that would be great. But I will move on for my second question to you, if I could. And it's section J10, which is part 5 of the bill. And in my draft, it's on page 30. It's under subsection 8001, mobile gaming, number 1, which is legislative purpose.
Okay.
And so it says the purpose of this section is to ensure that each federally recognized tribe in this state has the right to conduct all forms of mobile gaming newly authorized in this state on or after the effective date of this section. So this seems like a really broad statement, and I'm not sure that it was meant to be this broad. And also that it's sort of guaranteeing something in future things that we haven't even come up with yet. So if the state was to decide that, right now the state runs a lottery, what if the lottery, they decided to do the lottery online as well? Are we not by this statement then saying, well, the tribes also get the lottery? It just is a very broad statement. And I was wondering if you could help me understand what could possibly come to be there with that.
Sure. And you may want to also ask Attorney Binney for her perspective on that. But as you know, Senator Keim, the legislature can't bind future legislatures. And so I think it's important to bear that principle in mind when reviewing that language. So I would consider this language to be a statement of intent by the current legislature that to the extent other forms of gaming are authorized in Maine in the future, that the federally recognized tribes have an equal opportunity to participate in that newly authorized form of gaming on the same footing, if you will, as other entities. That's the expression of intent that's conveyed here. It does not bind, nor could it bind future legislatures, but that's what this is saying.
And that's correct. And that was at the request of the tribes so that they are not left out again, like they've been left out of gaming so far. And it's right. It's not that the tribes would get any exclusive rights or anything. It's a intent that should the state and the legislature authorize any future types of mobile gaming, that the tribes have an equal access.
So I guess, my follow-up, I guess, would be is that doesn't actually say that it's equal access. It just says if there are any forms, right? All forms, even if it's something that only the state is conducting, that it is, that somehow it's also authorizing the tribe. So, would that then mean that if there was, take for instance, if the state decided to make its lottery system online, what language or what do we do with this language? How does this impact that in the future?
I think sorry, go ahead, Attorney Reed.
Yeah, I'll try my hand at that, and then you should follow up, Allison, if you like. But yeah, I think questions like that would be sorted out by future legislatures. So to the extent that there's legislative activity on gaming in Maine in the future, this language may be pointed out as a reason why the tribes should be able to participate or not, depending on the context. And the legislature would review the merits of that and make a decision that seemed right at the time. So it's not binding in the sense that it would automatically entitle the tribes to participate in the state lottery or become part of the lottery system or something like that, something that would seem to produce an absurd result. The legislature would have control over that in the future to make sure that it's interpreted and applied in a way that makes sense.
That's right. It's the tribes would be part of a dialogue, but yeah, they wouldn't be part of the state lottery because the state lottery law is pretty specific. But it's just to pit it there so that the future state legislatures at least have the dialogue.
Okay, thank you. And it looks like Janet has her hand up as well. And I had one further question, which I can wait on if I need to.
Janet, did you, and I also, Committee Clerk Annette, if you could please move over Kim Pat Wharton, just to address the constitutional question that was raised that had been considered by the Office of the Attorney General. Janet?
So I'm sure you probably already all thought of this, but just to be clear, if this were to be enacted and then there were any other types of gaming developed, this could either be just repealed as part of that legislation, or it could be not withstood. So you could say, notwithstanding that, only the state may engage in this, or only Janet Stokoe may engage in this, and then I would have the exclusive right, and you would just not withstand this law. And that's how you could make me very wealthy. But I'm not interested, so don't pass that legislation.
Thank you, Janet.
Thank you. And has Kim Pat Wharton been moved over? She does not appear to have been. Soupy, are you?
I can try to do that.
Thank you. I don't have that.
Mr. Chair, I have tried twice, and it's possible she is just stepped away from her computer because she can't answer the, when we say moving over, she might not be able to answer.
Understood. I will try to send her an email, or perhaps Soupy, could you send her an email? She's in the global system.
I will.
Thank you. Senator Keim, did you have more questions?
I do have one more question, but Janet is waving her hand at us.
Okay, that's right. I'm losing track of things here. Janet, thank you.
I don't know. I don't think they're interchangeable people, but I imagine Chris Taub would be able to help with that too if he's available.
Thank you. Soupy, if you could please move Chris Taub over as a panelist, assuming he hasn't stepped away with his colleague.
Mr. Chair, I'm not getting any response from him either, so.
Okay, well, when they come back, we will try to have them address that question, but thank you for that recommendation, Janet. And you said you had one more question, Senator Keim?
I do, and I thought they actually might be the people to answer that as well, but I will pose it to Janet and see if she can answer it, and if she can't, maybe she can direct me on the best person to answer. In Florida, there was a tribe that was given the exclusive exclusivity for mobile gaming. And I was told that that was challenged in court and that was successful. So my question was kind of around that and how, if our process here was in any way the same and might go through that same court challenge. Are you familiar with that? And
I am, Senator Kime, though, if you want me to answer it for you.
Sure. And then I might like to hear from the Attorney General as well, because it becomes then a state issue that being challenged in court.
Yeah, in Florida, it's the state legislature passed a law that essentially only allowed one entity to do the mobile, which was the Seminole Tribe of Florida. What was challenged in the lawsuit was the Seminole Tribe of Florida has a gaming compact through the Federal Indian Gaming Regulatory Act. And so they wanted all the mobile wagering that they were doing in the state to fall under their federal compact through the Federal Indian Gaming Regulatory Act. That's what got challenged, is one of the commercial casinos who obviously didn't like that, challenged that. And what the district court said, because it's on appeal, the district court actually sided with the commercial casino, basically saying that when you're doing the mobile sports betting statewide, that can't all fall underneath the Federal Indian Gaming Regulatory Act, because the Federal Indian Gaming Regulatory Act compact is really about governing gaming that's occurring on tribal lands. And so this whole evolution of, taking gaming into the internet is new. And so we'll see where the court cases go on that. The federal government was on the side of the state and the tribe, and they were actually the ones that got sued because they're the ones that approved the gaming compact between the tribe and the state. And so the Department of Justice has appealed that case. So it wasn't about providing the exclusivity to the tribe. It was about whether the whole conduct of the mobile sports betting statewide can basically fall completely under the Federal Indian Gaming Regulatory Act gaming compact.
Right, understood, because that's supposed to be the land mass itself, basically, that controls the land and what happens on the land.
And there's a bunch of other restrictions that are required by the federal law that the tribe preferred rather than dealing with the under state law. So it's essentially the tribe's trying to get it kind of fully governed kind of by the federal scheme. And so that's what's being challenged.
Thank you. And so if I may, Mr. Chair, repeat my question to whichever person from the Attorney General is best to answer.
They have both joined us. Why don't you pose the question and I will let them decide who should.
So I had brought this question up in a different work session, and maybe it got fully answered and I've forgotten, so I'm bringing it up again. But I was wondering if there was a concern under the Commerce Clause around economic protectionism for having, which is in subsection 1207, number 2 of the bill, where it talks about eligibility and transfer to wholly owned entity.
So this is Chris Taub from the AG's office, and I'll try to answer that question, Senator Kime, but Kim may want to follow up if I miss something. Without getting into details, we've thought a lot about Commerce Clause issues, both when we were working on this bill and also with some of the other mobile sports gaming bills that were being considered by the legislature. And we can't say that any bill is without some risk of challenge, that there's not some creative argument that could be made under the Commerce Clause or equal protection or some other doctrine. But we've thought long and hard about this bill. We've done research on it, and we feel very comfortable that if the bill got challenged, we could defend it. Again, that's not to say that we would absolutely win, but this is something that we feel is solidly drafted. We think any litigation risk has been minimized. And so I know this doesn't answer your question definitively, Senator Kime, but it's just not the kind of question that we can say yes or no to. But we have looked at it and we do feel comfortable about it.
Thank you. And would you have anything further to add to my question around what happened in Florida with the challenge there in the court?
So first, I didn't hear your question. I had stepped away, but also I probably know nothing at all about that case. So let me see if Kim is familiar with it.
No, I heard Attorney Binney's summary of the circumstances, and that is accurate.
Yeah,
Thank
and
you
the
so
only
much.
thing I would add, Senator Khan, is the one difference in Florida that we don't have here is all the mobile sports wagering that's being done here in Maine is done under state law. The tribes aren't trying to bring in any federal law aspect to it. It's all state law, and that's what's complicated the situation in Florida. Is the tribes down there are currently under federal law, and they're trying to get the state to pass state law to agree to go under the federal Indian law gaming regime, and we don't have that here in Maine.
Thank you. And I think we've exhausted the knowledge on the case you're referring to in Florida, Senator Kime. Was that your final question?
For now, yes, thank you.
Thank you. Senator Carney, and then I'm going to, we've been at this for over 3 hours now. Everybody's sitting in one place, not getting up and moving. We're going to need to take a break. Everyone who has questions will still have the opportunity to ask them, but I do want to turn to my co-chair. She has her hand up. Senator Carney.
I had a two-part question, and the first part was, could we take a break, which you preempted, and I'll save my second part for when we get back from the break.
Thank you. It is 4:47. I'm making an executive decision to take a break. We will adjourn until, or be in recess until 5 after 5, at which point we will try to decide how we will move forward for the rest of the day's work. So if you could please shut off your cameras and mute your microphones, I will see you. You can leave your electronic hands up. We'll be back at 5 after 5. Committee members, as you return, please activate your video so I know that we are back. We're still waiting for a few members to return. Just waiting to see if Senator Keim and Representative Thorne get back. I will give them 2 minutes. For the members of the public watching and those in the attendee room, I am just giving our colleagues a few more minutes to rejoin us before we begin our work session anew. We're going to give 2 more minutes, but at that point, I will reopen the work session. I will try to reach Senator Keim. I have just sent a text to some of our colleagues.
We were going to reconvene at 5:05. Isn't that right, Tom?
We were, and it's 5:12, but we've been
Yeah.
late before. We have been late before as well.
Yeah.
But at this point, I am going to reopen the work session on LD 585. Welcome back, committee members, persons in the attendee room, and members of the public. And I would recognize Senator Carney.
Thank you very much, Chair Harnett. Committee members, I would like to make a motion. I would like to move ought to pass as amended with reference to the sponsor's revised proposed committee amendment that was circulated this morning. It's dated for work session 3/16/22 at the top, and it's the document that the committee analysts reviewed with us earlier today. And I do that for purposes of framing our discussion as we near the end of the day.
Thank you, Senator Carney. We have a motion ought to pass as amended. Do I have a second? Representative Sheehan? We have a motion and a second. Is there any committee discussion? Representative Babich?
Thank you.
Excuse me, Chair Harnett, I am so sorry to interrupt, but I know that your screen is a little wonky sometimes. I think that Representative Poirier was next in the queue.
Okay.
And my apologies for interrupting.
That's quite all right. Representative Poirier?
That's fine. It doesn't matter if we're out of order. I guess now's the time to talk about how I feel about this motion and the motion that I would support. So first I want to say that I appreciate the collaborative work that was done between the governor's office and the tribes. I do, however, have reservations for the financial implications of the bill. I support the idea of open communication and collaboration between the state and tribal governments. And I understand that the tribe's goal in the tax provisioning would benefit all tribal members, especially through the trying times that we're all experiencing. As far as the gaming, I do believe that our colleagues in VLA carefully vetted a bill that wouldn't monopolize gaming, but it would open up gaming opportunities to everybody, including the tribes. So
I can no longer hear you, Representative Poirier. Representative Poirier, we cannot hear you.
can you hear me any better now?
Yep.
Okay, sorry about that. I don't know where I lost you.
You were talking about VLA and their consideration.
Okay. I do believe that they've actually carefully vetted a bill that doesn't monopolize the gaming and would actually provide gaming opportunities for everybody, including the tribes. And I think that actually is a better route. So I would support a motion that would include the language in that bill for gaming to give everybody that opportunity. And when we get to our votes, I will opt to go that way. Thank you.
Thank you very much, Representative. Representative Babich.
Well, I'm unmuted already. I will lower my hand, Representative Harnett.
Thank you.
Whereas we have everyone in the queue, I wanted to ask Mr. Champion, what would passage of this bill mean for the Gambling Control Unit?
A lot of work, which is absolutely no problem. Yeah, I mean, this would obviously give us another entity to oversee and regulate. You know, I've been talking about the sports wagering now for about 3 years. Obviously, working it more through with VLA. I would only bring up some really key points on sports wagering as a whole. And that is that we found out that back in 2016, 17, or no, actually it was 19, sorry, that, you know, when this thing erupted nationwide, that states tried different ways of doing sports wagering. And strategically, they found out that that having a person walk to a facility or drive to a facility, walk in, register, and be only able to make a wager at a walk-in facility, which is what there's some of the discussions been about today, as far as a sports book or a brick and mortar place to walk in. The revenue was not all that much. In fact, at least one state, Rhode Island, started it where you had to go in and register, or you could only bet from a brick and mortar. And then they had it where you had to go in and register, and then you could use your app when you got home from your phone. But that didn't work either because people didn't want to go to a casino to sign up to be able to. So ultimately, at the end of the day, they ended up going with a mobile application. And since then, states in and out have discovered that, you know, any other entity other than sports wagering, it just doesn't work. All right. So I would say with the current bill right now, or any bill going forward, the mobile aspect is going to be 85% of the wagers. So whatever you're figuring in on, just figuring on whoever's got the mobile app, they're going to get 85% of the wagers. Okay. The other thing is, you know, back a couple of years ago, there is a report out. Oxford University did a real fine report on sports wagering, I believe back in 2017 before this erupted. And they gave some really good information, some good data. And, you know, basically, I think it was testified, there was some testimony I know from me and then from DraftKings as well, that the prediction of the net revenue or revenue income for the state of Maine at a 10% tax rate is going to be about 3.8 to 6.9 million a year. Okay, well, if you put that in retrospect to what the casinos did last year, the state of Maine collected $60 million. So this is not going to be a big one. It's not going to be a big one for us. In fact, when it first started out, a lot of the casinos really described it as no more than an amenity, like putting in a good buffet, you know. So these are the hardcore facts. And I do have all the data, all the information that I've had presented to the VLA committee over the years, and I'd be more than happy to share that information as well, or any other to answer any other questions.
If I may, Mr. Chair, before I let you go, Mr. Champion, what does it mean for you as a regulator, mobile versus brick and mortar? What about the mobile aspect of this? Is that?
Well, it's a little more creative. We actually rely on third-party certified laboratories to make sure the platforms are correct. And then you would do your auditing based on the data submitted. You know, I mean, we have currently right now, we have fantasy sports, right? We do fantasy sports are legal in Maine. Last year, I think our handle was about 15 million. And we collected a revenue of probably $250,000 for last year, and that's only from 10 operators that they don't actually pay any revenue until they have gross revenues over 100,000. So we had 3 operators last year that contributed taxes to the state of Maine, like I said, in the neighborhood of about $250,000.
Thank you for that. Thank you, Mr. Chairman.
Thank you, Representative Babbage. Representative Hagan.
Thank you, Mr. Chair. Just a quick follow-up on the testimony of Attorney Binney earlier, and I would like to hear from Attorney Binney if I could, or Attorney Taub, Padwarden, or Reed on this one. Talking about that Florida thing, it just piqued my interest with the state of Florida having a problem, this and that. The fact that gaming here would be due to state law, but earlier was saying that we would align with the IGRA. So and they're being challenged in Florida. Looking for more clarification on the applicability of IGRA and sports betting, online gambling, and whatnot in Maine. So once this bill passes, what would be the changes to state law versus IGRA, federal.
So there would be no changes to federal law. Oh, sorry.
Allison, the only reference to IGRA that I heard today dealt with the rate that the providers, the technical service providers, could be able to charge the tribes. We are not adopting IGRA. This is a state law. If it passes committee, chambers get signed, this is a state law. It has nothing to do with IGRA. With respect to the case in Florida, we discussed it for about a half an hour. I sort of feel like we've exhausted.
No, I don't want to continue. I just wanted to know how it would go with.
And I would just ask Allison Binney to confirm if what I stated, my recollection is accurate.
Just wanted clarification.
Yes, you're Representative Harnett, Chairman, you're accurate. The only thing we did is we pulled the 30 to 40% cap on management contracts, which is in IGRA. We just included that in state law, that's all. But Senator Keim had asked where that came from. And it was a reference, it came from us looking at how it works in the rest of Indian country for gaming in the rest of Indian country, but that's in state law. We pulled it out of IGRA, but it's in state law. There's no IGRA in Maine. No, we're not applying IGRA or anything. And the court case in Florida is about federal law. It's about IGRA.
Thank you. As we have a motion on the table, I'm asking the committee clerk to please move out of the panelist room. Everybody except committee members and the bill sponsor, Representative Talbot Ross, so we can engage in discussion of the motion that is before the committee. And I'm going to wait till that happens before I begin to recognize people to discuss the motion. First up will be Representative Evangelos, then Senator Sanborn, then Representative Libby. And as Soupy continues to move folks out, given the late hour, I will continue the discussion on the motion ought to pass as amended, beginning with Representative Evangelos.
Thank you, Mr. Chair. I'm going to be voting yes on Senator Carney's motion. Representative Ricketts mentioned that, the reason we were here on this was to benefit the self-determination and economic development of the nations. And so I'm voting yes. However, I do want to say something. I wish this Bangor thing had got worked out. I think we had a chance today where everyone could have walked away happy, and that's not the case. And seems like small potatoes to me. Raceway, casino, we've got one location. I'm not going to get bogged down on it, but it gives me a little pause. But I'm not going to lose sight of what Representative Ricketts mentioned.
Thank you, Representative. Senator Sanborn.
Thank you, Mr. Chair. I am also going to support the motion, and I think this is a step in the right direction. It includes a collaboration structure that I think can be used to continue to build dialogue and trust in the future. It includes the beginnings of some tax reform with regard to how we treat our Indian tribes here in Maine. And then it begins to have some economic development effort for the tribes under state law, although we just heard from the director that it's not a huge amount of money compared to the casinos, which to date our Indian tribes have been closed out of in Maine. So this is This is not the civil rights bill that yesterday's bill was. And for that, I'm disappointed. But I am really pleased that it's a bill that was negotiated over a period of time in good faith between our chief executive and the executive branch and the tribal nations in Maine. And so I will be glad to support it. And I look forward to and hope that it receives bipartisan support as we go forward. Thanks.
Thank you, Senator Sanborn. Representative Libby.
Thank you, Mr. Chair. I do understand the desire for self-determination on the part of the tribes, and I can appreciate that, but I'm also concerned about the economic benefit and development of all Mainers. And we do have an opportunity to get bipartisan agreement via an amendment, but it's not in the current motion. And so I will be voting no, and I will be supporting ought to pass as amended with an amendment that strips out the gaming portion and puts the language from LD 1352 in instead. Thank you.
Thank you very much, Representative Libby. Is there additional discussion by committee members? Senator Carney, then Representative Babbage. Senator Carney.
Thank you. I will briefly, in light of the hour, explain my support for this motion and this legislation. The process that led to the creation of this legislation took many, many months, and there were a lot of hard discussions, hard because the topics that we were discussing were challenging. From a policy perspective, and also really hard from the perspective of just working on the law to get it exactly right. And all of the parties on behalf of the state and the Wabanaki nations invested an incredible amount of heart and thoughtfulness and brain power in this legislation. And with all due respect to the concerns raised by Representative Evangelos, this is a really solid, well-balanced legislation that from a policy perspective achieves what is one of my top priorities, which is supporting the Wabanaki nations in Maine and fostering a significant economic growth and recognition of their importance to our state. And so I'm very pleased to be supporting the pending motion, and I'm so grateful to everybody who worked so hard to bring it to us as such a thoughtful and well-crafted piece of legislation.
Thank you, Senator Carney. Representative Babbage.
Thank you, Mr. Chair. As some of the committee may be aware, I'm very concerned about the expansion of gambling in the state of Maine. You know, my worst case scenario is some family of small means has a spouse that has a small stash that she's been painfully saving for the benefit of her children or whatever, and it's discovered by her husband, who decides to go and I don't know, at the table put it on black, but more so put it in sports wagering. This culture that we're a part of here in America values competition and sports. It's integral. As a teacher who taught AP and was department chair and had 1,000 things on his plate, those years that I coached at the same time, my mind would wander to how I can better compete, help my kids be motivated, strategize to win. And I think that's part of our culture. So I am concerned about consequences, and the consequences of this are real. However, we passed 1352. It's on the AFA table right now. I'm seeing the light at the end of the tunnel. This is easy money. Governments can't refuse it. it's been promoted here in order to benefit the tribes. Very sympathetic to that. And I'm very happy that the tribes and the chief executive have worked together. I feel that this has been vetted to a great degree. It doesn't mean that I'm on board, because unlike, say, a table game at Oxford, which may have as many Massachusetts and New Hampshire folks at the table as Maine folks who are doing online wagering are going to be Maine residents. So any money that leaves the state through a contract with a provider, an operator or whatever, to me, it's important that a good amount of money does stay in state. So, and if we're going to embrace this big step, I do want a bigger portion of I guess we called it adjusted gross revenue, but net income, whatever, go to the general fund. And so that's where I am on this bill. Thank you, Mr. Chair.
Thank you very much, Representative Babbage. Senator Keim.
Thank you. So for my perspective and the reason for my vote, I am in favor of the collaboration. I think that it's important, and you know, I shared and tried to vet concerns that we were being realistic in the timing and the resources that it would take. But I still think it's really it's really important, and so I will be in favor of that. I think putting my own amendment in, but just recognizing that we should have collaboration, and that there should be good dialogue, and that it should happen in ways maybe that are more continually than more continuous than legislation that comes before us. And I'm also very interested in fostering significant economic growth. However, I feel that for all Mainers. And right now, the way we tax and then the benefits that we get from that, we all enjoy because it benefits us all equally. So we're taxed equally and we benefit equally from those. So whether it's fire protection, which is really basic, right? I mean, we would be asking other people to take on the cost of a benefit that we equally share. So other landowners for instance, with that forestry piece would be taking on that cost. But in essence, we would all be taking on, and in any area, the extra cost of through taxation for the upkeep of whatever infrastructure we're touching. And so I think it's important. I would love to see tax reform that would foster economic growth for all Maine people. And the gaming piece, and while I understand that two interested parties spent a very long time working out this bill, that's not at all the same as a full stakeholder engagement process. So for two stakeholder groups to come to an agreement is very different than having overall engagement of all stakeholders. And so I just feel that we have left their voices out of it and sidestepped a process that many of our colleagues were engaged in for years to come up with something that they felt was fair. And so I don't feel right about sidestepping that amount of work and collaboration that already did take place. And that will be how I vote. Thank you.
Thank you very much, Senator Keim. Representative Moriarty.
Thank you, Mr. Chair. I will also be voting yes. I have heard it said that LD 1352 is on the AFA table and on the Senate table. I'm unclear as to which table it's on, but apparently it is on one somewhere. I've lost confidence in the future of 1352 because it's lingered on a table for so long with no apparent signs of immediate attention or resolution. So given the work that has been done in the months since LD 52 passed the House, I think we ought to yield to that work and that product that has been developed by the hard work of a number of different individuals involved. I think that this being a piece of legislation, obviously it can be amended in the future, should it pass and should it be signed. And this by no means remains beyond the reach of the legislature in the future if further tweaking is required. So I'll leave it at that. Thank you.
Thank you very much, Representative Moriarty. Representative Thorne.
Thank you, Mr. Chair. And in light of the conversation that I've heard here today, my basic synopsis, my feel on this is that it's not quite ready for prime time yet. We have discussion about mashing up of 1352 language that is still sitting on a table. I'm for equal rights. I'm not for special rights as far as the gaming is concerned. There are parts about the taxation that have yet to be answered in my mind, mainly how big a commodity the potato and the blueberry and the forest industry figure is, which I didn't hear today. And that, you know, puts that rate at odds with other Mainers that would have to pay taxes for that type of thing that it's not clearly defined. So at this point in my mind, it does not seem like it's a finished product, and I will be voting ought not to pass.
Thank you very much, Representative Thorne. Representative Sheehan.
Thanks, Mr. Chair. I will be supporting the pending motion, and I'm grateful to have had something of a window into the hard work that went into this negotiation. I agree wholeheartedly with Senator Sanborn when she asserts that for the last few weeks we've been contemplating the civil rights issue of our era here in Maine. And I also agree that this is an important first step in what I hope will be a long succession of collaboration, advancing truth, and therefore deepening trust among these parties. So as I support the pending motion, I'm going to do so in the awareness that our children and grandchildren will be looking back on our votes as we look back at the work of our ancestors and decide whether we want to advance or amend what they've done.
Thank you very much, Representative Sheehan. Before having the roll called, I just want to make a few comments, and I know that the hour is late. I will, excuse me, I will be voting yes on the pending motion with strong support. But I want to remind folks, and it's been stated by some, what this bill and what this bill is not. This bill is not about sovereignty. I was proud to vote to move forward LD 1626 yesterday and hope that that continues to move forward, because that is about civil rights. That is about righting the wrongs that we cannot deny in our history. That bill is about sovereignty. But today's bill, LD 585, is about three things that are also very important, although not as significant as sovereignty. And the first being collaboration, which I don't know how anyone could argue with, to better the relationship between Maine's tribes and the state of Maine. As we heard yesterday, that relationship has been unhealthy. And that fact that it's been unhealthy has harmed both the tribes and the communities that surround the tribes and their reservations. Anything we do that encourages people to talk and to resolve differences before they become big problems is a good thing in my mind. With respect to taxation, I think the changes are significant but not overwhelming. It begins again to treat the tribes in Maine and their citizens the same way that tribes are treated all around the country. It's not a giveaway. It's not about different rights for different people. It's about allowing their state government to build their infrastructure with the tax dollars generated by their people on their land. And I have no problem with that. With respect to gaming, the tribes in Maine have been totally shut out of the gaming industry other than receiving a percentage of some of the profits of that. We heard about the Penobscot Indian Nation having to shut down their lawful gaming operation because the people of Maine chose to provide a casino license to a large multinational out-of-state corporation. Real people lost real jobs. Another casino came into Maine, owned by Churchill Downs, another out-of-state multinational company not benefiting the people of Maine. The time for the tribes being shut out of this possibility of economic development is over. We need to do as much as we can to support their economic development, and I firmly believe that when we support the economic development of our First Nations, the communities that surround them, and indeed the entire state of Maine, will benefit. So I want to thank the committee again for all of their time and attention today, and all of the work that has been done by so many people to get us to this point. And I will be voting yes on the pending motion. And with that, I would ask the committee clerk to please call the roll.
Thank you, Mr. Chair. Senator Carney.
Yes. Excuse me, yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
No.
Senator Keim votes no. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
No.
Representative Babbage votes no. Representative Galgay-Reckett. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
No.
Representative Hagan votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Libby.
No.
Representative Libby votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Mr. Chair, I have 8 members voting in the affirmative, 6 members voting in the negative, 0 members are absent. That is the vote of the committee.
Thank you very much, committee clerk. And for those voting no, I would ask what your report is, Representative Poirier.
I would like to propose a motion of ought to pass as amended, striking out sections I and J, adding in the language of LD 1352 as amended in appropriations. And I would also like to incorporate the provisions for advertising restrictions and provisions for management providers. I think Janet has that all set for me.
Thank you very much, Representative. Representative Babbage, your report.
Yes, Mr. Chairman, my report is ought to pass as amended, and it is precisely the bill as written, with the exception that instead of the 6.5% going unallocated to the general fund, Rhode Island has 51%, New Hampshire has 46%, New York 40. I'll go with Pennsylvania. I think $1 out of 4 should go to the benefit of Maine people. 25% to the general fund would be my figure.
Thank you. I think you said a lot there, and Janet has her hand up.
I just want to make sure, is it 25% to the general fund on top of all of the special harness racing funds? Or is it just 25% general fund only?
It's 25% to the general fund, but I know 1% goes to the general fund to go to the gambling control unit. That would be an addition. So instead of the 6.5, there would be 3.5% designated beyond the 25% to the general fund.
Okay. And is that
the bill
for both
the bill is
facility
as
and
written.
mobile?
I'm sorry?
And both facility and mobile, same tax rate?
Yes, yes.
Thank you, Representative Babbage. Do you have what you need, Janet? And Senator Keim, your report?
Thank you. Janet, my report will be part A of the bill, where it is a tribal state collaboration. Thank you.
Thank you, Senator Keim. Representative Libby, your report?
I will try to make this simple for Janet. I will simply hop on Representative Poirier's report, ought to pass as amended.
Thank you, Representative Libby. Representative Hagan, your report?
Thank you, Mr. Chair. I'm intrigued by Senator Keim's report. I'll have to have further conversation, but right now I'm going to be out not to pass.
Thank you, Representative Hagan. And Representative Thorne.
I will go along with Senator Keim on the collaboration aspect.
Thank you, Representative Thorne. And I believe that I got everybody who voted no. If I did not, please raise your electronic hand. Representative Babbage. Okay.
Thank you, Mr. Chair. Residual.
Thank you. It's going to be your middle name, Representative Babbage.
It's a W.
Janet, is there anything else you need from us on this vote?
I don't think so. I will let you know if something comes up during language review, when we go through all the bill with fine tooth comb with legal review, and I'll just let you know.
Thank you. And before I entertain a motion to adjourn, Soupy, do you have anything that you need to discuss with us at this late hour? I mean, at this time?
I apologize. I was on. Mr. Chair, this is a little bit unusual for me to have so many votes, and I'm just wondering if you would like me, for the record, to just repeat what I have and make sure we're all on the same page. Would that
Sure.
be
Sure.
helpful? Okay. If I could, on LD 585, I have 8 members voting in the affirmative, 2 members voting ought to pass as amended. That would be Representative Poirier's motion. 2 members voting ought to pass as amended. That would be Senator Keim's amendment. 1 member voting ought to pass as amended. That would be Representative Babbage's. And 1 member voting ought not to pass. That would be Representative Hagan, for a total of 14 votes.
That's how I remember it. I think you did a great job there. Is anybody?
Whiteout is great.
I didn't know they still made that stuff. I do see some hands up, so I'm going to call on people before I try to bring this to a close. And if I get you out of order, that's the way life is. Representative Reckitt.
Well, my hope is that perhaps Senator Carney is going to answer my question, which is when are we meeting again and for what? Which is because I'm afraid I've missed that in my dashing back and forth to criminal justice. So
we will make sure you have that information before we adjourn.
Thank you.
Senator Carney.
Thank you, Chair Harnett. two items, one a housekeeping item. We should have taken a roll call vote on LD 1728, the sponsor's request to ought not to pass that bill. And so I would like for us to do that again while Soupy is here to take the roll. And then I believe that we are meeting at 10 o'clock tomorrow morning, starting at 10, because everybody preferred to meet on Thursday rather than Friday. And Peggy may have some updates for us on that. But I did want to make sure that we revoted 1728.
Thank you, Senator Carney. Could you call the roll on 1728, Soupy, please?
I would be more than happy to. I just see Representative Record has her hand up, and I don't know if it's on this.
No.
No.
I'm just inspired by Chris.
No, and I actually thought that Peggy called the roll on that. Maybe I was confusing something else. Okay, thank you.
I unfortunately did not enforce the rules on that one.
You're a rule breaker.
I am.
Soupy, if you could please call the roll. Thank you. I'm
I
sorry.
think Senator Kine may have something to say before we do this. Her hand is up.
Okay, Senator Kine.
I just wasn't sure if Dave was there when we had done this, so I wanted to catch him up. I wasn't sure if he was there to hear if Representative Hagan, was present when we voted, and I wanted to make sure he understood what transpired, but now I've lost him. I guess he's not on the screen. Okay, well then I don't need to catch him up.
Thank you, Senator Kine. Representative Thorne, did you have a question before we take the roll?
Yes, Mr. Chair, just for my notes and for procedural, who made the motion on this? What was the motion and who seconded?
The motion was made by Senator Kine, if I recall. I'm not certain who seconded the motion.
Representative Harnett seconded the motion.
I can't believe that he forgot that. Thank you. With that, do you have what you need, Representative Thorne? Okay. Soupy, if you could please call the roll.
Thank you, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Kime.
Yes.
Senator Kime votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll recall the absentees. Representative Hagan. Representative Hagan is absent. Representative Newell. Representative Newell is absent. Mr. Chair, I have 12 members voting in the affirmative, 0 in the negative, and 2 members are absent. That is the vote of the committee.
Thank you very much. And Peggy, did you have anything that you needed to share with us before we call it a day? Night?
I just wanted to double check what our work session is tomorrow. I believe it's LD 598, the discrimination based on hairstyle or texture. LD 1946, the confidential communications with counsel. And I'm not sure if you're planning on taking up the other 2 bills that you heard today that you didn't vote.
I think we will. I think you're absolutely correct on 598 and 1946. And if you could just include that in other work sessions as may be scheduled, because I'm not certain how we're going to proceed on those at this point. Does that give you enough?
That's plenty. And I had sent out the votes on the budget. If your vote wasn't recorded, I listed who was absent. You can let me know. It's due tomorrow. So if you let me know by like 9:30 tomorrow morning, we can make sure it gets incorporated.
Thank you. Representative Evangelos.
Thank you, Mr. Chair. Does that mean we're taking indigent legal up next week?
I'm not exactly sure what we're going to do after the two bills. We'd like to conclude our budget work as quickly as possible. I will confer with the Senate co-chair.
I meant bills regarding indigent legal reforms, not budget.
I'm not exactly sure what you're asking. I'm sorry.
Well, it was on the agenda the other day, and Mr. Andrus was coming in, and we were going to be discussing possible committee bills for reforming the indigent legal system.
I saw Senator Carney had her hand up. I thought we were talking about different funding mechanisms and initiatives. Senator Carney?
Yeah, I was just going to say that I thought, and I don't know if this is what you're referring to, Representative Evangelos, but if we did funding initiatives that would include legislation that would be proposed along with those funding initiatives. I do think we should count on at least having a committee discussion tomorrow. I know Executive Director Andrus is not available, but we are hoping that perhaps the Deputy ED Maciag is available. But regardless, it would be good for us, I think, as a committee to discuss MCILS yesterday, and we'll make as much progress as we can.
So we're addressing the deficiencies that we're experiencing through the reforms through a budget process rather than through legislation.
I mean, we can talk about tomorrow. I would suggest we could talk about that. I'm just not sure. I can't anticipate what you're saying, but I would love for you to describe it to the committee as a whole tomorrow. I just can't make that decision in the abstract.
I'll shut it off now, but I was under the impression this entire session, after all the work we did with the commission and the public hearings we heard and the justices, that we were going to be producing reforms and legislation this session. That is a commitment we've made. And I just want to make sure that we're following through on it and not letting it drop by the wayside because the session got late. This is an important commitment that we've already made to the commission after hearing from the lawyers and the judges. And I want to know if we're going to address it like we promised.
And I think a lot of those issues we discussed the other day with we received a memo from Justin addressing many of those issues, the rate, the reimbursement for CLE, the establishment of a mobile group of attorneys to serve underserved counties. And we still have the geographically limited pilot project. So I think those are all on the table for discussion. Representative Evangelos.
But are those funding initiatives or are those going to be legislative?
I think as Senator Carney explained, they might be funding initiatives that have statutory language attached.
Okay, I'll drop it. We'll take it up whenever. But somebody needs to be notified. There's a lot of parties involved.
It would also, just Representative Evangelos, one final note is that if we have a committee discussion, we have the authority to report out legislation that we could then have a public hearing on. And I know it is getting late in the session, but let's have that discussion tomorrow.
Thank you, Senator Carney. I see a lot of hands up now. Representative Thorne.
Yes, thank you, Mr. Chair. Just long range forecast. What's Friday look like for committee?
Friday, we are trying to keep our commitment not to meet as a committee.
Thank you.
Emphasis on the word trying. Representative Moriarty.
Thank you, Mr. Chair. Are we doing tomorrow the language review that was otherwise on our schedule today? Two bills.
You'll have to refresh my recollection. I'm not.
1310 and 1945.
Those are not ready for language review.
Oh.
And I'm not sure how those got on the schedule.
Okay.
But my apologies. I'm still working out some kinks in 1310 with like SBI and also the agencies that keep track criminal convictions that don't go to SBI, like IF&W, Marine Resources, and just the whole idea of whether it's a separate record sealing process outside of the Criminal History Record Information Act. But we're close.
And I apologize, Representative Moriarty. I did not see those on my schedule. I might be looking at a different schedule. Representative Reckitt.
Now, if I could indulge the group for a moment, what happened with LD 2008? I had to step away.
We had a public hearing.
Yeah, I was here for most of that. Yeah.
And we will need to schedule a work session.
Okay, thank you.
Is there anything else before, I don't even want to ask, is there a motion? Is there a motion to adjourn?
So move.
Representative Thorne, seconded by Senator Sanborn. Thank you all. All those in favor? And those opposed can stay as long as you like. With that,
I just want to say you have, I think, you have voted everything but 4 bills. I think that's my count. You don't have the errors bill yet. And then if you report out anything else, but great work. That's a lot of work. And those bills are hard. So still have some hard work ahead of you. But
you could have
good
stopped.
job.
You could have stopped right with the congratulations.
You're done for the day. How's that?
And none is the errors bill. Yes.
That'll do.
And thank you, everybody, for your hard work every day, it seems. So thank you very much and have a good evening.
All right. Good night, all.
Night.
Night.